an inquiry or dispute arises under the Presidential Records Act, outlined in that works very well. If it's the latter, then privilege tends to fail and the concern by presidential system of executive privilege come into play. And that's really what
paradigm. I apologize, but
that's okay.
Disputing that the documents and as to which President Biden has concluded that executive privilege is not justified. And as to those privileged at the time they were created, there's nothing about this PRA process that creates executive privilege. I thought you were. I might have misheard.
No, I could have been clearer, I'm sure, Your Honor. Hawk rationalization with respect to executive privilege instead of looking at the document as it existed at the time and making claims over these. And just to be very clear about this, former President Trump exerted privilege over or asserted privilege we're talking about here, and the former president
to be that these are not United States to be. And former President Trump has said that's wrong. You should be asserting it. You're going to hurt the executive branch if you don't assert it here. And so what do we do? Is that how you understand it, or is there another aspect?
The process under the PRA, which I think is important to go through in that determination, but executive privilege and an incumbent president, and how do those come about? There's
how do you sort that out?
Yeah, so Mr. Bernal, another way of saying exactly what Judge Millett has identified and what I think is the argument of the other side is that this all boils down to who decides when it's in the best interest of the United States to disclose presidential records. Is it the current occupant of the White House or the documents? And one of the things that I took away from their brief that I hope you respond to is that they said that they cannot think of any other circumstance in which the former president
wants to use it to inform his ability to be effective in his negotiations. And so he says, I'm going to go look at those documents. Is it your position that a former president, in this case, former President Trump, but hypothetically any former president, could also go to court and ask a court to enjoin the archivist from giving those documents to the incumbent president?
That's GSA versus Nixon, Your Honor. That is, and two important.
Okay, so if we're sitting as a court, and your position is if the current president wants to see documents within the executive branch held by the archivist, a former president, and needs them for pressing national security and foreign relations reasons, a former president can put a halt on that and take it into court to prevent the president from having access to information within the executive branch? I just want to be crystal clear, that's your position.
That's the position of GSA versus Nixon. And
there was a different statute. It was a facial challenge simply to the processing. I'm asking you here on about 2205. And this may well be your position. I'm just asking to be absolutely clear. Your position is that under the Presidential Records Act, 2205's provision for an incumbent president to get access to these records is equally subject to litigation, and courts would be called upon to decide that debate about whether an incumbent president really needs this information or should be using other sources to manage foreign affairs and national security.
Well, not to manage foreign affairs and national security.
That was my hypothetical to you, is you need this information
Former president could sue on this. I think it's really noteworthy that has literally never happened before, because this is a first time there's been a dispute with respect to that. And I don't.
I know it hasn't happened. That's why I'm asking. So,
and I would say that one important part of GSA versus Nixon that is facial challenge statute, that's fine. We're talking about confidential information. In that instance, I would presume the incumbent president wouldn't be issuing this for public release or to another branch of government, and that there would be a confidential review of these documents. I can't envision a situation where something that was truly pressing, foreign policy related, that was time sensitive, that wasn't going to be released to the public or wasn't going to be released to another branch outside of the White House and the executive branch, that would arise. Because
you can envision that, and I can envision other hypotheticals as well. But your point is that a court would still have to decide between incumbent president and former president on access to vital national security material, and that a court, sorry, Judge Jackson.
Okay, all right.
And if that, in my hypothetical, the president, there was a very wounded feelings by this foreign country with which relations are extremely sensitive, because that the leader of that foreign country said promises were made to me by the former president, and this is very serious ones, and there's going to be deep and serious consequences for formulations, military operations within our overflight rights in our country, because I think you're breaking that promise. And the incumbent president wanted to go and look and see what promises were made, what communications there were at the time, and discovered that the leader of the foreign country was not reporting truthfully what happened. And in fact, promises explicitly were not made. And so the president said, I need to make public, clear the air. Here's what was promised. There's no violation. I need to do this for the military and national security and foreign interests of the United States government. I need access to the transcript of that phone call, and I need to make it public. Right? You were assuming it would have to be internal and confidential, not necessarily in my hypothetical. I need to make it public to protect our interests. And to be clear, your position is the former president could come in and file a lawsuit. And
well, I would.
To challenge it, now, I'm not saying who would win or not, but I'm just saying your position is the ability to file a lawsuit applies to this provision, and it would be up to the courts then at that point to decide who would prevail on the claim as to what should happen with those executive privilege documents. That's your position.
That is our position, Your Honor. Under 2205, the way it would go is the former president.
Yeah, your position. Sorry, right. I'm going to just jump. Look, it's just I'm just testing what's going on here. GSA versus Nixon says you get to go to court. Statute says you get to go to court. Will you please tell me, under your theory of this statute and scheme, how are courts supposed to resolve the contest between the two? What is the legal test that we should apply? What standard of review, if any, do we apply to the incumbent president's determination? And how do we weigh the competing claims? What rule of law would you like this court to adopt to write into an opinion that says, here's going forward how, yes, you get to come to court, and here is how courts should resolve these very grave disagreements between a former president and existing president over executive privilege?
I have to address that, Your Honor. I would say that the process would start under 2205 in that instance, where the archivist would.
We're past that now. You're in court. Okay, we're in court. We've gone through the process. The incumbent president said, I need it. I need to disclose this. I need to clear the air. Give it to the archivist.
And
You've notified and the former president comes to court and says, no, I get a right to come to court and protect executive privilege. Here I am. And nobody tells us what to do next. Tell me what to do next.
So you'd apply a test, Your Honor. And again, here's the test. You'd first make a determination whether there's a critical need for the documents for the conduct of its business. Okay?
It absolutely is under my hypothetical.
Okay. Number two, is the document available? You determine if the document is available elsewhere, and as Congress sought, failed to get it.
It's not under my hypothetical.
Mm-hmm. All right. Then you look at the privilege, right? Does it meet the privilege standard? Is it a privileged document? If the answer is yes,
mm-hmm.
then you need to say that is the need such that the qualified privilege can be invaded? Okay. Once you're past those first two tests, I would note in that those first two prongs are satisfied in your hypothetical. They're not satisfied here.
I get that it's a hypothetical for a reason. I'm really interested in this test, so I want to make sure I got it. So you say we've gone through it, the prongs are met. It's just we're at loggerheads between the former and the sitting president on this. And you say the test is the need such that the privilege is overcome? Is this like a U.S. versus Nixon test?
That's the final prong of the test, but yes, that would be
that's the ultimate tiebreaker here, right? Because in my situation, in my hypothetical, and I get you have arguments about the elements not being met in C of legitimate need and alternative avenues. You're not taking anything off the table. My hypothetical says those are both satisfied under B. And so now all we have is the two at loggerheads. And can you just tell me again your test? Is the need such that the privilege is
first in that third prong, is the document privileged? Does it meet the privilege standard? Is it a communication?
Of course, yes.
It does, okay. In that instance, you would then need to look at if the need is such that qualified privilege can be invaded. One of the factors in there is confidentiality. And I think that's really important to remember from GSA versus Nixon. And if there's a compelling need, a critical need rather, for it to come out that could overcome that privilege. But I would note in GSA and Nixon, that was those were going to be confidentially reviewed documents. So I just think that's really important to remember. In your hypothetical, obviously that's different.
So what would the answer be in my hypothetical? If you were a judge, what would you do? Would you think that situation of national security, military, foreign relations, angry, sensitive foreign government, does that overcome it?
I don't know, Judge. I would need to know a lot more about it, but
I don't know what more you need to know. I've given you some. I'm not going to name a country. I don't think that would matter so much.
I'm not here to make a determination on that, but what I'm here to do is tell you what I think the analysis.
Well, let me ask the question another way, and I apologize, Judge Jackson. I knew you had a question. I just want to drill this down. Is there any circumstance in which the privilege could be overcome, even though the information is not guaranteed to be kept confidential? Is there any circumstance, or is your rule that there is not?
There is circumstance. I'm sure there is, and there are going to be pressing matters where it could be, but we don't have any case law that confirms that.
I know we don't have any case law, so I'm asking this question.
I don't know. Calling balls and strikes on kind of ethics, non-legal ethics things aren't my bailiwick.
This is not non-legal.
I can't imagine.
Not non-legal ethics. To be crystal clear, I don't understand. This is not non-legal ethics. I'm talking about, can the privilege be overcome under your test? Can it be invaded? This qualified privilege be invaded?
Sure. It was invaded in GSA.
Even without confidentiality.
Even without confidentiality, probably. I would say probably. I just can't think of a hypothetical off the top of my head where it would be.
Did you ever ask the district court for an injunction not against release, but an injunction against the House, requiring the House to keep these documents confidential?
I don't have my docs in front of me.
It's not in your preliminary injunction. So.
We
Judge Jackson saw something I didn't in there.
Yeah.
And I didn't see it in the argument transcript. So you didn't ask for that limitation to the court.
We couldn't really, Your Honor, because of the speech and debate clause in the Constitution. It would, if Congress gets something, there's nothing a court can do to stop a member of Congress.
No. You, of course, you couldn't do that. What you would do is you would say the archivist could, an injunction of the archivist only releases it to Congress under a read-only rule or a confidentiality rule.
We did not ask for that, Your Honor, in large part because it's not, I don't believe it would be effective against Congress. Such an order wouldn't actually keep the documents confidential.
You don't think that you could ask for a protective order, and you don't think that Congress would have to be bound by a protective order?
An individual member of Congress would not have to be bound by a protective order if they were to go to the House floor and read what they had just read in a confidential setting.
So, how is the test to be applied that you suggested any different if the incumbent president also asserts privilege, and there's no disagreement? Both the former president and the incumbent president say executive privilege, and we're here in that posture. Is the test any different, or is the test the same?
Well, I don't think you have a test at that point. I don't think it would get to a court if an incumbent president and the former president agreed that a document was privileged. You wouldn't need to meet any of those factors because it wouldn't come to court. The archivist simply wouldn't release the documents at that point.
Mr. Mr. Clark, that actually strikes at the heart of the question that I had in listening to Judge Millett's hypothetical, which is the assumption, for the purpose of the hypothetical and your discussion, that there really is a cause of action either in GSA versus Nixon or in the statute for a former president to constrict the courts into resolving a dispute between him and the incumbent president over the invocation of executive privilege with respect to these records. And I need to say that I'm not quite sure, maybe not as sure as my colleagues, that that's actually present. As I read GSA versus Nixon, that case was not about the disclosure of records, whether it be to Congress, whether it be to the public. That case, it seems to me, was about whether the former president retained a confidentiality interest in records that the statute now says belongs to the United States. So it was sort of like a property thing. The new statute comes in, they say these records no longer belong to you, President Nixon, they belong to the United States. And he wanted to maintain and exert his interest in confidentiality over those records, notwithstanding the fact that they now belong to the United States. And I read the Supreme Court as merely saying that he has such a confidentiality interest, even though the records are in that state, that there's nothing unconstitutional about the statute that makes the records the property of the United States, that he still gets to raise it, but it's a diminished interest because he's no longer in possession of the records, that he's no longer the president. But it's really not about what happens when the current president says these records need to be released either because I want to use them, they're about a foreign government or whatever, or because Congress is asking for them, and the conflicts between the two of them on the call of what happens to the record. So to the extent that you find in that case the right to come to court to dispute the current president's ability to release the records, I don't see that in that case because that's not the circumstance. I also don't necessarily see it in the statute. So if you look at the E, which is what I thought was sort of where you were getting, this 2204E, it says that the former president can initiate, bring in action asserting that a determination made by the archivist violates the former president's rights and privileges. It doesn't say executive privilege. It doesn't say constitutional privileges. It says rights and privileges. And I think that at least one reasonable way to interpret that is that the statute itself gives the president lots of rights concerning this process. It says you get the right to review these documents. You get the right to prevent their release before you review them in the 30-day period. Personal records have to be segregated out by the archivist. And so that gives you the right to say, hey, wait a minute, this record is a personal record and not a presidential record. Those kinds of things could easily be litigated by the court when the president says, the archivist is about to release a record that violates my rights and privileges. I don't think it is necessarily the case that that language encompasses the right to the current president's invocation of executive privilege in court concerning the records. There's a whole set of other rights that the president could litigate, and I don't necessarily see that in this statute. So maybe you can talk about or explain to me why I am wrong that in a situation in which you have this kind of dispute between the current and the former president, there really is the right of the former president to go to court to do something about the current president's determination.
I appreciate the question, Your Honor, and I understand where you're coming from on this. I think the disagreement that I have with you and my understanding is that if you read 2204 and you identified E, and we're getting down to the determination of what a right or a privilege is, I read GSA versus Nixon as creating a constitutional right of a former president to have certain rights over his or her documents when they were president. 2204E, I believe, codifies that right to be able to make that challenge to it. And 2204,
right, but to be clear, even in Nixon, that right was not sufficient to overcome the public interest as identified by the current president to have, maintain, and preserve those documents. I mean, if you're right, Nixon comes out a different way. Nixon versus GSA, because the former president in that case asserts the right of confidentiality in the documents. The Supreme Court says, yes, we see that you have some right, but the current president has made a determination that you can't just take those documents and destroy them. You can't use them for your own purposes. They're now in the archives. They're the property of the United States. And he's decided that they need to be preserved, that there are important governmental and historical reasons to preserve them. So even in that case, the determination of the current president overcomes whatever confidential rights or whatnot the former president has. So I'm not saying the former president doesn't have any right of confidentiality. What I'm saying is, what do we do And where in the case does it suggest that whatever confidential right the former president has, he overcomes the determination of the current president that it's important that these documents be preserved in Nixon, and in our case, that they be released?
I believe, and our position is that the law creates a situation where the former presidents, all that matters is the disagreement between the former president and the incumbent president. Once that disagreement occurs, an Article III court has to make a determination. That's why the right to sue exists under the statute. That's why Nixon and GSA is there. And the court can give weight to whomever it chooses, but balancing that task that I outlined before and determining whether there's a critical need.
You're rejecting my reading of the statute as giving the former president the right to make sure that the archivist is doing what the statute says concerning the processing of records, giving him the rights and privileges that the statute itself conveys, right, to him concerning this set of documents. That is a reading of the statute, that it doesn't say, I mean, I would expect if you will write a provision in the statute that addresses this very situation, when the incumbent president says executive privilege is waived, I'm allowing these documents to go out, and the former president says, no, I have executive privilege and I'm asserting it, then the former president gets to come to court and the court would decide, and in an ideal world, the court would decide, and here are the standards. This is what Judge Millett was trying to get at. Here are the standards that the court would use. None of that is in the statute. And so as a result, it makes me worry that the circumstance that you are trying to have the statute give you a cause of action to proceed under is really not what's going on here at all. That everybody, you know, we've looked at the legislative history. We see, for example, that executive orders, almost all of them, have determined that when you have this kind of conflict between incumbent and former, incumbent gets to decide, right? So I just don't know that the statute is saying, no, incumbent doesn't get to decide. Instead, take it to the court and let them be the one to decide between current and former. I don't see that in the statute.
Yeah, I think you see the right to sue in the statute, and then I think the regulation at 36 CFR 1270 spot 44, section F3 outlines it a little bit more.
Sorry, can you give me that slide again? Just make sure I'm looking.
Yes, Your Honor. 36 CFR 1270 spot 44, section F, subsection 3. If the incumbent president does not uphold the claim asserted by the former president, fails to decide before the end of the 30-day period of this section, or withdraws a decision upholding the claim, the archivist discloses the presidential record 60 calendar days after the archivist received notification of the claim, unless a court order and an action in any federal court directs the archivist to withhold the record, including an action initiated by the former president under 44 USC 2204E.
And that court action would be the one, I'm assuming that court action would be one referenced in E, which I assume was building on Nixon versus GSA, which rejected the argument that only an incumbent president may assert such claims of privilege, and hold that appellant as a former president may also be heard to assert them.
That's right, Your Honor, and that's the part of the basis of our complaint under 2204, which is why it's referenced there, because this CFR references that, and also references the exceptions to restricted access, which is in 2205. So that's how I think we get there, and that's kind of what fills in some of the blanks that Judge Jackson pointed out with respect to the statute 2204 and E.
Can you also be citing 2208 C2C?
Yes, and I don't have my copy of my statute in front of me, but yes, Your Honor.
Because that's where it says if the incumbent president determines not to uphold the claim of privilege by the former president, then the archivist shall release the records at the end of this 90-day period unless directed otherwise by a court order in an action initiated by the former president. So doesn't that language anticipate that the former president could bring an action like the one you brought here?
Yeah, yes, Your Honor.
And so then in the context of that action, this is Judge Millett's question, what is the court supposed to do? Do we start from scratch to determine which president has the right view of this? Do we look at the records? Is it our determination, or does it matter that we have a current president who's made the decision? That doesn't matter. We treat them equally. There's no deference given to the current president because he's current.
I don't believe so. I think there needs to be an objective test that the court would employ. First, looking at if there's a critical need for the documents.
Sorry, can I just clarify your answer to Judge Jackson? When you said I don't think so, does that mean you don't think there's any deference to the decision of the existing president? Is that what you weren't thinking? So I just want to make sure I understood the transition.
Yeah, I don't believe there is. I believe that the court needs to employ an objective test to determine which party is correct.
The Supreme Court in Nixon versus GSA was, explicit that when it comes to evaluating the interests of the executive branch, that when that call is made by the incumbent president, the counter argument, the interest asserted by the former president is diminished, which sounds to me like counts for something.
I don't disagree with that take on GSA v. Nixon at all. What I'm saying, though, is I think there are a few steps prior to that presidential determination in terms of privilege that a court would need to weigh, and that's with respect to Congress's business under 2205. So analyzing
Why is that?
Well, the statute, Congress limited its own ability to obtain documents under 2205, right? And it limited it to records that contain information that's needed for the conduct of its business and is not otherwise available. So I think a court needs to make a determination that there's a legitimate legislative purpose and that the requests are tied to that legislative purpose in a meaningful way.
And no deference is given to the incumbent who presumably has made that determination, because the archivist has to decide in the first instance whether this is an appropriate request, right? So the incumbent president, presumably, per the statute, has decided those 2 points. And so when it comes to the court now, you say that there is the opportunity for the court to make this determination. And I guess what I'm asking is, do we defer in any way to the incumbent's determination that those criteria are satisfied?
I actually don't think so. I mean, I don't think that runs in the face of GSA versus Nixon, because this is under a congressional request under the statute. So I think the demonstration of a critical need and looking at the connection between the legislative purpose and the actual request, whether they need those specific requests to answer their legislative need, is a job for an Article III court. When there's
the court says statutory criteria are satisfied. The court agrees, but deference aside for now, the court says, defer or not, we would agree that they are met here. In a hypothetical case, I'm not going to ask you direct questions on this case, of course. So hypothetical, in some other case, the court agrees, the president decides, incumbent president decides, the court agrees, the statutory criteria are met. And so once again, here we are, a court left with the incumbent president and the former president really at loggerheads only about one thing, and that is the interests of the executive branch, right? That's what President Trump, he's here in his official capacity. He's not asserting any personal confidentiality interests, anything like that. He's here asserting, this is all your arguments have talked about, the interests of the executive branch in confidentiality. And so President Biden makes one call, the incumbent president makes one call, former president makes another on the same question, the interests of the executive branch, whether they will be able to weather the storm of this waiver of executive privilege. And GSA says,
well, I think you missed one part of the test. I think you missed one part of the test, which is that is the document available elsewhere.
I've told you the statutory criteria, not plural, are met. Okay, I'm now at those. We're past that. We're past statutory criteria.
GSA would say to give weight to the incumbent president and their determination.
And the former president's interest is right. And the former president's interest, ability to evaluate the interests of the executive branch, is diminished. Right. We have one president at a time under our Constitution. That's what GSA is saying, and that the incumbent president has said, has made the judgment and is best positioned, and the Supreme Court has told us to make that call as the interest of the executive branch. So just as between those two arguments, former president's view of the interests of the executive branch and confidentiality of these documents, incumbent president, the president, has made the decision about the interests of the executive branch and confidentiality, given all the statutory criteria are met. What then?
We are in Nixon versus GSA, where
right, and Nixon versus GSA says the incumbents carries more weight. So what happens then? You lose. The former president, not you. Sorry, let me rephrase. The former president loses.
If there is a question, if it only comes down to a question of the interests of the executive branch, if it only comes down to that, the court has to weigh it. And under GSA versus Nixon, the court gave more weight to a former president than or incumbent president than the former president.
So if in some hypothetical case, the court finds itself at that stage, gone through the statutory criteria, and I am not dismissing here for a second. You have your arguments about those statutory criteria. I hear those loud and clear. But if the court moves past those, and here's the former president's arguments about the needs for confidentiality of the executive branch, and here's the incumbent president's determination, the incumbent president wins.
Well, the incumbent president's determination gets more weight. I don't think they win. I wouldn't say that.
Well, I thought that's what you just said. So then what happens? Okay, it's got more weight, so then what?
Well, then the court has to weigh everything. The court's got to weigh, does it meet a privilege standard? What are the contents of the documents, and what are we talking about here? Is it something
we're talking about presidential communications privileges?
I mean, does it get into territory that Congress was concerned about, where they passed a law where the archivist could be susceptible to possible pressure from the incumbent president to release embarrassing and inappropriate material concerning a predecessor or a rival, and from the predecessor?
All right, I'm sorry. Where are you reading from in the statute?
I'm just reading from the Presidential Records Act debate on the floor, which we had in the legislative history. I mean, there are other possibilities that the court could weigh, not just the incumbent president's determination.
What else should be weighed in this case? If we assume we're there again, and this is just assuming we get past your arguments about. I'm not saying that we do. I understand we have to go through, in your theory, we have to go through those statutory criteria. And if we say they're met, and this is all executive privilege material, you've asserted it, they aren't disputing that it calls for that, and so, and you've got arguments about executive privilege. The incumbent president has made a judgment about needs of the executive branch. Some president gets more points on the scoreboard on that question. What else in this case are we supposed to weigh at this point? In this case now, not hypothetical.
Well, we're not there yet on this case, because you would actually have to look at the individual documents in question.
Why? Under what authority do you say we have to look at the individual documents?
Well, I believe a court in making a determination on this, once we got to this final part of the test, we need to look at the documents to determine whether or not they should be released and whether or not the interests of Congress. How is
the court? So you have made no particularized arguments at all. Like normally in a FOIA case, right, there's arguments focused on the particular document and the interest in it. And there's declarations from the government, at least, about their need for privilege. The person asserting privilege has provided a declaration that's particularized to the documents at issue. We have no declaration. We have no particularization. Your thought is that without any guidance from the former president, without any insights, any declaration, any argument even from the former president, the court itself is supposed to go through and make arguments that the former president hasn't as to individual documents. That's your position in this case.
I'm not sure I follow you, Your Honor, and I only say that.
What arguments has your client made, or have you made in this case, that says it's an individual document? This one really can't be disclosed because it's about X, and this one really put aside general interest in executive branch confidentiality. This one really is so sensitive, it outweighs the extra points on the scoreboard for the incumbent president. Where is that in this record?
Well, Your Honor, it's not there yet, and we're at the preliminary injunction.
Not there yet. No, I know, but you have the burden of establishing your right to preliminary injunction, and you want the court preliminary injunction stage, is that right, to go through these documents?
I think the preliminary injunction is meant to withhold the documents until the court has the opportunity to go through and make a determination.
But you're only entitled to that based on an assessment of whether you have a likelihood of success on the merits, which means that you have to point to evidence that would support your contention that these documents are subject to being withheld, notwithstanding the determination of the incumbent that they should be released under these circumstances.
Right.
So Judge Millett is saying you have not gone through and looked at the particular documents with an eye toward giving the court the argument and the evidence as to why these particular documents, when we get to the final stage of this analysis, should be withheld, notwithstanding the incumbent's determination about what is in the best interest of the United States. And let me just add that what is in the best interest of the United States, I think, determination includes not just a look at how confidential these documents are and what is in the best interest of the executive with respect to confidentiality, but also accommodations, which is the way this is normally worked. So what I mean by that is that the incumbent president, I would think, is making a decision about whether or not to cooperate with the legislature. And that encompasses not just how confidential these are and all of the concerns related to confidentiality, but also the process of negotiation, back and forth, how we're going to behave with respect to these documents or other documents in light of legislative requests. It's the co-equal branches of government in operation. And so that's a pretty weighty concern, I would say, when the executive is making a decision that it should give or shouldn't give the records. And it's a concern that is not on the table necessarily with respect to the former president. So if the former president wants to come back and say, notwithstanding a determination that the executive incumbent has made about the release of these particular documents in light of all of the things that are going on, we still say that the document should be withheld. Judge Millett is pointing out that you really have to make a showing about these records and why that's so important under these circumstances. And so where in the record have you done that?
Well, we made our claims in the complaint and in our briefing that these documents fall under traditional categories of executive privilege. And we're talking about the privilege and what's in the individual documents, what those specifically are. I mean, there will be a line where you can't go over, and then the documents are just kind of out in public in terms of what they are. But we've made, and your comment about political accommodation is really important. In this instance, the former president has made really, I think, very consistent and honest attempts to make calls with respect to executive privilege.
But that's not what your brief says, by the way. I'm surprised to hear that, because your briefs suggest, without evidence as far as I can discern, that the current president has not done.
No, I'm
You're saying the former president has done. Okay, so but what is your view on whether the incumbent president has exercised his duty carefully and thoughtfully? That's not what your briefs said.
No, that's right. I stand by our brief in that one, because the incumbent president has simply said that they are releasing all of the documents without a determination, or they disagree with the incumbent or the former president's determination on privilege and are releasing all the documents.
So I have a couple of questions here. The first one is, suppose in a hypothetical situation, Congress issues a subpoena to the archivist, and there's 10 categories, 10 document requests for the former president's records. And the incumbent president goes to Congress and says, I'll waive privilege as to 2 of the 10 as an accommodation, but I'm not as to the rest. And I'll waive privilege as to 2 of the 10 if you agree that you will accept that and just withdraw the other 8 requests so that we don't have any court battles. And Congress says, okay, fine, we'll take that deal. But the former president says, no, shouldn't make that deal. I'm objecting, and I want to claim privilege to even those 2 categories. Your view would be that if the incumbent president has reached an accommodation that wouldn't require court involvement, the former president could bring an action and require the court to get involved anyway, right?
Yes, Your Honor.
Okay. And to, I guess, get back to the prior questioning about your argument for document by document review, it seems to me that your argument is inconsistent with our precedent, i.e. Senate Select Committee v. Nixon and Nixon v. Sirica. Because Senate Select Committee basically approved and kind of reaffirmed the prior en banc decision from Nixon v. Sirica, which said that you can make the privilege determination kind of writ large against the whole class of documents and say that the need overrides the privilege and therefore the privilege has to yield and the documents have to be produced. But there's a second step, which is that kind of akin to a Vaughan Index and a FOIA case, and they cited EPA v. Mink, a Supreme Court case. They said that, like, if as to a particular document, the president were to say, well, that one isn't really responsive to the request, or it's really sensitive because it's got personal information, or kind of there's some other kind of extraordinary circumstance where that document should be redacted, or maybe a substitute should be produced, then you can like make those individual requests, but you essentially have to prepare something like a privilege log or a Vaughan Index where you say, as to these documents, they shouldn't be produced because they're not really responsive, or there's personal information, or some other, kind of compelling reason why, even though that privilege has been overcome, we want you, court, to look at those in camera, and here's our argument for why those shouldn't be produced. That's what Nixon v. Sirica says. That's our precedent. And you haven't done that. You're just saying the court just has to go through every document by document and determine individually whether the privilege should obtain. But that's not the way we say we do this, at least the way I read those cases. Tell me why that's wrong.
I don't necessarily disagree with your reading of those cases, but what I would say is that this is the first time under this statutory scheme that we've dealt with this situation. And the only process I see in terms of being able to do this in an appropriate way is for a court ultimately to look at these documents. And here's why, Judge. I think under the process of the PRA, the way it works is first the former president receives the documents to do a review and assert their privilege. I believe they're on NAR's website. I could be mistaken, but the letters are out there. The former president then sends a letter to the archivist outlining essentially what you disclosed. There are situations where something was withheld because it wasn't a presidential record. There were certain documents that a decision with respect to those were deferred, and those are outlined in that letter from the former president. The documents then, well, it's not one after the other, but at some point after the former president receives them, the incumbent president receives those documents and does their own review and issues a letter after the former president does in response to that. And that's what we have here. The process then really turns to the former president going to court at that point. And so that's where we are in the process right now. And I don't necessarily disagree with you that a priv log or something like that would come up, but we're under a statutory scheme and kind of what we have.
I don't see anything, I'm sorry, counsel, but there's nothing in the statute that says that the privilege determination has to be made on a document by document basis. What we have in our precedent and, the court didn't listen to the tapes before they determined that privilege had been waived in Nixon. They didn't have to listen to the tapes to determine whether there was a privilege or the privilege was overcome. They knew basically what was the subject matter discussed in the tapes, and they knew what the legislative or the purpose was for the grand jury to have the tapes, and they made the call. And they made the call kind of on a categorical basis, but they said, but look, to the extent that there's like a particular aspect of the tape or a particular aspect of a document, then you can raise whether that's really responsive to the request or whether you need the whole document or the whole tape or you redact it because of some sort of sensitive nature. But that's a second step. That's after the determination that of whether or not the privilege has been overcome. Because if the privilege hasn't been overcome, like it wasn't in Senate Select Committee, you don't get to that second step. You just say, there's no, the privilege obtains and it hasn't been overcome, so Congress doesn't get the tapes in that case. So you seem to be blurring the kind of two steps, and that's what my concern is. Can you respond to that, please?
Yes, Your Honor, and I understand your concern on that. I just, when you get down to, there needs to be some review, whether it's a general view of the contents or something, of these documents by an Article III court to see whether it fits within a privilege category once you get to that third step of the analysis. I don't know how to
clarify something. I don't mean to interrupt your response, but when you say whether it falls within a privilege category, so are you asking the courts to look at them to see whether, to verify whether former President Trump was accurate in asserting executive privilege? That's all?
I think you have to in that third step.
Okay, but assuming, let's say the court instead says, I'm going to give you, these are all executive privilege documents. But you said this comes after the incumbent president has waived executive privilege. And that doesn't make sense to me. And you agree that under Nixon versus GSA, in that, whether it's in the interests of the executive branch, the long-term interest, and the interest of the United States, not to assert executive privilege here, Nixon versus GSA is quite explicit, more points on the scoreboard for the incumbent president in the weighing analysis. And so it doesn't matter at that point if we stipulate that these are executive privilege. I don't see where that gets you if the court looks and goes, yeah, they're executive privilege. We could look at them all. We could look at them all and say, yep, they're all fall within executive privilege. We'll credit former President Trump's assertion of that, but that doesn't change the balance that Nixon versus GSA already struck on that very issue.
But you have two steps prior to that a court needs to review before you get to that analysis. One is the critical need analysis in terms of...
Please stop, because here's where we've been, I thought, through this argument. All right, we are assuming the statutory criteria have been met. We're assuming that they've been met. We're stipulating that those have been met. All right, and we're now in court. I'm back where I was. The former president are at loggerheads as to the interests of the executive branch of the United States, and the incumbent president wins that debate under Nixon versus GSA, right? He gets to make that call under Nixon versus GSA. The former president just isn't in a position to do that. And then you say, well, now let's look at the document to see if they really are executive privilege. It doesn't matter, because the incumbent president has said, I agree these are executive privilege, or even if I agree or I agree, I am not choosing to exercise that privilege. So it changes the analysis not a whit for a court to spend time going, yeah, executive privilege, not executive privilege. It's been waived. Is that what you want? You want the document review just to determine whether these are executive privilege documents or not?
No, to make a determination as to whether the qualified privilege of executive privilege should be invaded.
Okay, but so that's again where it seems like it's the burden is on the former president to come forward with some reason as to why, notwithstanding the extra points on the scoreboard for the incumbent president on making a judgment about waiving executive privilege, then the former president's going to have to come back with some interest, something that's missed in that calculation, some supervening interest. And it won't be enough to go, see, I told you it was executive privilege. See, I told you it was an executive privilege document. You're going to have to come up with something more powerful that's going to outweigh the incumbent president's decision to waive, right? You're going to have to change the score on that scoreboard.
So, for example, Mr. Clark, you could say, with respect to these particular documents, there's going to be some concrete harm to the executive that I'm identifying, presenting to the court, explaining, but it's sort of in the same vein as Judge Wilkins and Judge Millett have been talking about, because you come back and you say, here it is. This is why, even though the incumbent president wants to waive the privilege, it needs to stay in place, and I need to be able to prevent these documents from being released. Here's the concrete harm that this particular document will cause if it goes out to Congress.
The harm here is a constitutional harm to the executive branch, which I know we've discussed. And I don't believe that I've raised this except at the beginning of my argument, that the former president's determination with respect to privilege in some instances is going to be a better determination with respect to privilege because of the context of conversations, of documents, of records, whatever. And the court needs to weigh those. I mean, again, in 2204, a former president can't waive, sorry, I keep mixing those terms up. An incumbent president can't waive a former president's determination of privilege assertions to the public for a 12-year period of time. The archivist shall not disclose records. In that instance, we've said, yeah, former president not only has rights, but knows better.
Sure, but 2205, where Congress or an incumbent president asks for them, says notwithstanding.
Understood.
2204. Okay.
But all I'm saying with this, Your Honor, is that it's evidence that there are going to be instances where a former president is going to know context and issues better than an incumbent president with respect to certain documents. And right. I think that needs to be
and Judge Wilkins points out, and as I tried to point out before, that the incumbent president will know better the needs of the executive branch with respect to accommodation of the legislature, right? The briefs from the appellees talk about the fact that the incumbent president has the current present relationship with Congress and is taking into account not only the confidentiality interests as put forward or expressed by the former president, but also other things. Judge Wilkins' hypothetical was exactly that. We're making a deal, says the current president, about the release of these records. So why then would it be that the court should preference the former president's concerns about confidentiality, even though he may have the superior knowledge of what the documents were about or whatnot? We're in a different world today because we have a different president who's taking into account not only confidentiality, but other things?
There are considerations such as, you know, if we look at a document and it's going to be an embarrassment to a former president, if it's meant to cause political turmoil, it's what Congress itself was concerned about in its passage of the PRA when it passed it. There are factors, and there are going to be factors that a court needs to weigh in determining whether a document or a series of documents need to be disclosed. And that's really what we're saying here in terms of the reviewing documents. We're not talking about
but you've made no showing on this record in support of your preliminary injunction motion that the documents at issue in these first three tranches involve that. Any of those concerns?
We phrased it specifically as to category.
Yeah, I mean, we've raised it with respect to the categories of documents that are there.
But you have no evidence. You have no evidence.
I'm sorry. Just you've raised what? That it'll be in the what?
We've raised concern about categories of documents that
You have concerns, but you all have looked. You or someone on your side of the table has actually looked at these documents, and I've seen nothing in your briefs or arguments. There's certainly no declaration, but even in your briefs or arguments that says, look, as to 5 of these documents, they will do nothing but finish the sentence.
That's fair, Your Honor. That is not specifically in the record with specificity on each document.
But you just say you have concerns, and your concerns have come up with, I think, generally in your concern about the global reach of this congressional request.
Well, yes, because there are concerns with the breadth of the request, which I'm sure you'll get into with opposing counsel. But the concern here is we are on a timeline in terms of a 30-day timeline, and getting a preliminary injunction so we can hash out these issues is really important on our end, and that's where I think we are.
Mr. Clark, we've kept you up a very long time. I'm sure you'd like a drink of water or something more, but I have to say, I'm sorry, Judge Wilkins, I think I jumped in on the answer to your question, so I didn't know if you needed to follow up. I apologize. I was just trying to understand what he was saying.
No, that's fine. I guess what I'm trying to get at, counsel, is we're kind of switching gears for a second. Any privilege can be waived. The attorney-client privilege can be waived. So why is the executive privilege different in that you agree that the executive privilege can be waived as a general matter, right?
Yes.
So your argument is that the incumbent doesn't have the absolute right to waive the privilege. The former president can object and say, no, I don't want to waive the privilege. And then the court has to decide whether the incumbent's desire to waive the privilege should be given effect. Is that the way we should look at this case?
Yes, Your Honor.
So in determining whether to give effect to the incumbent president's desire to waive privilege, you say that we should use a test that is essentially the same as a test that we would use if the incumbent president said, I'm not waiving privilege, and this were just a fight between Congress and the incumbent and former presidents over whether the executive privilege has been overcome. You're basically saying we should use the exact same test, aren't you?
I think it's similar for sure. I don't think it's the exact same, Your Honor, because you've got a statutory scheme in this instance that you follow. But boy, they're very similar to the Supreme Court's precedent, Mays, ours, and others, with respect to a fight between the executive branch and Congress over the
Why should it be the same test? As if like the incumbent president's determination to waive privilege like didn't happen at all, is irrelevant, doesn't matter. Why should we use the same kind of balancing test in this context?
I think in many ways you are, but I don't think it's the exact same only because you've got statutory language here, Judge. That's the really big distinction here with respect to any test and release of documents.
Right, and I'm just following up on an earlier exchange you had with Judge Jackson. I do think it is to the credit of former President Trump that he has been discerning in going through these documents and hasn't sort of done a global assertion of privilege. That means that these documents have all been carefully looked at and thought about on your side, and that's good for the process after all. My colleagues don't have any more questions at this stage, and I think we've held you a little bit over your time, but we will still give you, I promise we will still give you some rebuttal time.
I appreciate that, Your Honor. Thank you, Your Honor.
We'll hear from Mr. Letter. Hang on, you're not muted yet, Mr. Clark, before you start whispering.
May it please the court. I'm Douglas Letter, the General Counsel of the U.S. House of Representatives. With me today, I was going to say in the courtroom, but in the room here are Eric Columbus and Stacy Fossil from the House General Counsel's office, and Mary McCord, Annie Owens, and Joseph Mead from the Georgetown Law Center Institute for Constitutional Advocacy and Protection. What I wanted to do is just make a short point up front, and then I was planning to go through and respond to various questions that the court has posed, but obviously we'll interrupt that at any point with other questions that you have. I think it is very important, given the argument that has been made today, to remember what Chief Justice Marshall said in the United States versus Burr. Said the president, quote, is elected from the mass of the people, and on the expiration of the time for which he is elected, returns to the mass of the people again, end quote. And Judge Chutkan's decision certainly picked up on that. And we really do have, as one of your honors observed a little while ago, we have one president at a time. And the argument being made here by Mr. Trump just doesn't give that sufficient weight.
Well, I mean, to be fair, right, we do have one president at a time, but the Supreme Court has told us that at least as to this question of executive privilege and confidentiality within the executive branch, that claim can be asserted by a former president, even when not asserted by the incumbent president.
That's absolutely right, Your Honor.
So don't get us to that point. So,
yeah. However, as we know, as I said, that's absolutely right, Your Honor. I was interrupting you to say, but as we know, as the Supreme Court set out in Nixon versus GSA, it is the views of the current president that are so obviously paramount, in part because of the very hypothetical that you raised, Your Honor. You can easily envision circumstances when the current president is making determinations about national security, foreign affairs, etc. And it has to be in that circumstance that we have.
I get that, but here's what I find so difficult here, because Nixon versus GSA said the former president can shoot. The statute says even when the incumbent president is not asserting the privilege, the former president could go to court, right? There could be a court order that would interrupt disclosure. And what I'm grappling with is assuming, and that's something to be talked about, I'm sure, but assuming statutory criteria are satisfied. In your view, what type of showing would a former president need to make to be able to prevail over the views of an incumbent president? Because it seems to me quite silly. I don't think the Supreme Court was being silly in Nixon versus GSA, and I assume Congress wasn't being silly in recognizing that the incumbent president could persuade a court to stop a disclosure. So it can't be that you all go to court and we go, incumbent president wins. Thank you for playing. There'd be no point to the lawsuit. So what is envisioned? What type of showing is it that a former president can make that will overcome the decision or even the indecision, staying silent of a former president of an incumbent president, excuse me, on the privilege? What can overcome? And how do courts review those competing claims?
Right. There are a couple of responses. One, an indecision case might raise totally different factors. It's not clear to me that maybe we can come up with a hypothetical where the current president is just extremely busy overseas, whatever, and so some raises a situation very different from this one, where the current president has looked at the very documents that are at issue and made a specific determination about them. In those circumstances, Your Honor, we have thrown around various hypotheticals that we find it very difficult to come up with anything that's realistic when the views of the current president, the determinations by the current president would not govern. I'm guessing that again, that we can come up with some extremely strange hypotheticals that don't have much to do with reality.
You're representing, at least the House of Representatives, which is half of the entity that enacted the statute, and it specifically envisions a former president being able to obtain a court order over the contrary views of the incumbent president. And I assume it wasn't because they were envisioning the sort of inconceivable hypotheticals that you're talking about.
Your Honor,
something realistic in the statute.
A couple of things, Your Honor. One is the former president could sue to challenge determinations made by the archivist about what is within the restrictions or not within the restrictions. So that's one thing that the former president could do without challenging some determination by the current president about executive privilege. Two, as I said, maybe there are some circumstances when the current president just has not weighed in at all. That could pose.
That's not the statute. The statute is if the incumbent president determines not to oppose. So it's not my. Right. I was giving you both options in case you had something to offer me. We're talking. The statute itself is really talking about the two being at loggerheads.
Yes, and Your Honor, again, if, for example, I think we've mentioned if there's some situation when the current president is acting in a way that is so far outside the realm of how a president is supposed to act. And for whatever reason, as he's not being impeached, maybe the Congress is of the same party or one of the houses or something, but is acting so far outside the realm of what is reasonable.
So what about if it's January 21st, a new president has come in, and new president says, I won. And Congress is in control of the same party as the White House. They're on the same party. And every committee of the House, the Senate, and every subcommittee starts lobbing in document requests to the archivist for everything, covering all 4 years of the prior presidency or 8 years, whichever it was. And the current president and the new president says, I disagreed with everything that former president did, everything they stood for. I thought it was a travesty for the American people. And I think it's in the interest of the United States that every single executive privileged document be released to these committees and to the public. Go do it. And just because I disagree with everything that person did and stood for and said. And so it's in the interest of the United States, in the new president's judgment, to release everything. Needless to say, the former president comes to court. Hang on. What happens? What are we
I think the current president would prevail in those circumstances, Judge Millett, because the current president would have made what could be totally reasonable and rational judgments that what the former president did is so outrageous, maybe fomented an insurrection against the Congress of the United States.
No, we're not going to make it that easy. All right, so we're going to talk instead of, it says it's in the interest, I won by a landslide. American people really are unhappy with what happened. And so I am going to avenge the people of the United States on this president. I'm going to avenge them.
Yes,
Your
Your Honor.
desire is to see all these documents. They're all coming out.
Excuse me, Judge Millett, are you talking about in this hypothetical release to the public or release to
both? Every committee passed, I'm going to give it to all the committees, and I'm going to give it to the public. Both.
Yeah, Your Honor, the hypothetical, the way you've now framed the hypothetical, it seemed to me that the former president would have a strong argument that could be made, and that is.
What would that argument be? Because the current president will have said it's in the interest of the United States and people of the United States to see all this. I'm going to avenge their interests by this person that they resoundingly voted out of office. It was a complete electoral landslide in my hypothetical. All right. And I've made that judgment. And so what's the court supposed to do? That's not look at motives. Are we supposed to say, well, you got the interests of the American people, the interests of the public wrong? You weren't careful enough? What is the court supposed to say?
Right. And that's why your hypothetical is frankly a very difficult one. Let me go through it. Remember that the Supreme Court recognized this in part by saying we assume that a current president will be aware of the institutional interests of the presidency, given that the current president realizes that at some point he or she is going to be a former president, and therefore that will act as some sort of brake on that. Two, however, if in your hypothetical, it's the current president saying, I want to punish that guy I beat. I just want to punish him. And so I'm going to make sure that everything is known.
Well, I think it's in the
that-
interest of the United States
Yeah.
to have this response to
Right. And that's when
that.
your
Punish makes it too easy, right?
that's but I was I was trying to say why Congress might have come up with this as
Mr. Letter, I thought your answer was going to implicate the one situation that Mr. Clark pointed to, that is the difference between 2204 and 2205, which is in a situation like the one Judge Millett hypothesizes. Mr. Clark suggested that 2205 would give the former president the right to say these documents cannot be released to the public for a certain period of time. And that what we're dealing with here is the exception and the extent to which Congress gets the records, notwithstanding that, and different president determinations about whether to give them to Congress. And so am I wrong about, like, could we accept Mr. Clark's reading of 2204 to be that in a situation in which there's a dispute between the former and current president over release to the public, Congress has made the determination that the former president would get to decide which records get released over time in the way that the statute says. Maybe the former president wins that battle, but that's really not what's happening in a government request kind of situation.
I think you're right, Judge Jackson, that those are two different situations, and it might therefore be that in a situation involving simply a release to the public, there might be circumstances when the former president could sue and could prevail. Hypothetically, again, it would be something so far outside our experience as a nation. But I think that you, as your hypothetical is coming up with, if instead this is a request from Congress, we believe that the 2204E provides that the former president can raise a claim about privilege. They can raise a claim, but overwhelmingly, the current president is going to prevail in that kind of circumstance. And as I say, again,
my hypothetical was the answer with respect to the statutory claim as to public release. What's the answer to the hypothetical as to release to the committees of Congress? For my hypothetical about it's in the interest of the people of the United States to avenge ourselves on what happened for the last 4 years.
and I'm sorry, Judge Millett, I wasn't sure I heard. This is when it's
as to what happens when it comes to court with respect to count one, don't release them to the committees. I've asked for everything under the sun. Every committee has done something in, and they got all 4 years pretty well covered here. What's the response?
So if it's a request by Congress, it seems to me that overwhelmingly the current president would prevail. But I'm willing to say, I don't want to say never. I don't want to get.
If you can't conceive of an ever, and you're not willing to say that my hypothetical would be an exception.
Your Honor, I can conceive. I don't think I can conceive of a realistic one.
But counsel, whether or not the incumbent president would prevail doesn't really tell us how a court should determine whether the incumbent president would prevail. I mean, do we, we don't just flip a coin or draw straws or something. What tests are we supposed to use?
Yeah, and Your Honor, putting aside the highly unrealistic hypothetical, I think the test is rather clear. It is the current president is in the best position, best by far, to determine what is in the interests of the executive branch at that time. The current president has weighed, as the Supreme Court indicated, we assume the current that there are benefits provided by executive privilege, and so how those should be carried out. And then the current president makes a determination, as this president did, bringing it back to this case. This president, as we know, said we have an extremely strong interest here in the select committee being able to carry out this investigation as part of its legislative duties, responsibilities, and therefore, in that situation, what the court should do is say the current president has spoken, and that's it. We're done.
Mr. Leonard, can I test something, because I'm still interested in the language of the statute and the provisions that my colleagues have pointed out with respect to the former president's ability to bring a claim. What I'm noticing is that the statute, and I'm looking right now at 2208 C2C, which I think Judge Wilkins previously raised. It says, if the incumbent president determines not to uphold the claim of privilege asserted by the former president, or fails to make a determination, the archivist shall release the presidential record subject to the claim at the end of the 90-day period, unless otherwise directed by a court order. And then this is the part that is I'm sort of homing in on. In an action initiated by the former president under section 2204E of this title, or by a court order in another action in any federal court. So to the extent that the former president is relying on the first part of that, a court order in an action initiated by the former president, I am wondering whether it is possible to interpret a court action initiated by the former president under that statute not to actually be putting the two presidents at loggerheads on the broad question of executive privilege, but to be a claim about whether the archivist has followed the rules with respect to what the statute gives the former president in terms of the amount of time or whatever else. It seems like it's very qualified language. The Congress is saying an action initiated by the former president under that section. And that section doesn't talk about constitutional rights or the extent to which the president can make a different call on executive privilege than the former. So in my hypothetical analysis of this, it would seem that the president can raise a constitutional claim, the former president, the incumbent president takes a look, says, you know what, for whatever reason, accommodations or anything else, I'm not going to invoke it, I'm going to waive it. And then to the extent that the former president still wants to say that those records should not be released, he can make a claim under 2204E about the practices of the archivist or whatever else, and the that because then we'd have standards, right? The statute actually says what is supposed to be done in a circumstance procedurally related to the records. So if the president has claims about those sorts of things, notwithstanding the incumbent's view of executive privilege, then he can raise it. Now, I don't know what to do about the second part of this by court order under in another action, and maybe that's where we get to, the former president raising the executive privilege claim in federal court. But I think I can still read 2204E as allowing the former president to make a kind of claim about the rights and privileges that the statute itself provides in an effort to prevent the release of documents that he believes are privileged or whatever else. Do you understand what I'm saying? That was a long-winded question, but what do you think about that? Am I misreading 2204? Do you concede that E allows for the executive privilege claim brought by the former president in contrast to what the incumbent president has said?
As you recognize, it's a long question. I can't give yes, no, but exactly. Yes, a lot of what you say is correct. But remember, 2208 is specifically the provision that talks about disclosure to the public. So 2208 does not apply to this case. But you've said if there were instead a claim under 2208, yes, that
even helps. That helps my scenario even more. So we don't even have the language of or another court order. We have only E. And if I'm reading E to mean, Mr. Former President, you can claim that the archivist didn't give you enough time, that as the statute requires, or that this is a personal record, not a presidential record, and you can come to court. If I'm reading it that way, then we don't really have a world in which the court is resolving a direct confrontation between the two presidents on the question of executive privilege, right?
I believe so, Your Honor. But again, I want to emphasize, yes, that we're under 2208, but so yes, there are hypothetical situations in which a court could rule on certain things, depending on what the current and former president have done, said, or nothing.
I mean, that would mean that we don't have a situation that my colleagues are worried about. Presumably, hypothetically, that the court is being called upon to decide who has the better of the executive privilege issue. The incumbent will win because he's made the determination, and the only thing the former president can complain about in court is whether and to what extent the rights and privileges that are listed in the statute have been followed.
Yeah, and again, Your Honor, I want to be very clear on this because this is very important. Yes, there may be claims that a former president can make in court under 2208 involving requests from the public for access. What we have, so yes. What we have, though, here is a request by Congress. So this is covered by 2204E and which must be read in conjunction with 2204C2, which, as you know, says nothing shall be construed to confirm, limit, etc., expand the constitutionally based privileges available to a former president. So that is executive privilege. So it's an executive privilege claim that would be brought under 2204E. And remember that the statute, a different statute, but in many ways related, GSA contains similar language, where the Supreme Court thought that privilege meant executive privilege. So if I may, just to summarize again, if we have a case like this one, where it's a disclosure to Congress that's governed by 2204 E, 2204 C2, etc., and that means that the former president can raise privilege claims. As we've said, the current president should overwhelmingly win any of those if they are indeed at loggerheads, as they are here.
There's no question of the cause of action. And in fact, one of the statutory terms is the presidential communications privilege. So both as a statutory claim and a constitutional claim, they're both here under 2204 E2. And as you said, all read in light of 2204 C, we're not withdrawing anything under the statute that is constitutionally based, which Nixon versus GSA tells us includes the former incumbent has as one of right or privilege, whichever way you look at it, to address and raise claims of executive privilege. So we do, in fact, the statute does create the very loggerheads, assuming we get past the statutory criteria that are argued about by your friends on the other side.
But it doesn't tell us what to do. But it doesn't tell us what to do, right? And so what do we do?
It doesn't, but that's where, I'm sorry, Judge Wilkins, did I interrupt? Sorry. I thought I heard a voice. I may have been wrong.
No, go ahead.
Okay. I'm hearing voices. That's all. Right. The statute doesn't tell you what to do. That's where I believe the Constitution tells you what to do, because the Constitution, for instance, as we cite in our brief, silo law says what many Supreme Court decisions have said. We have one president who runs the executive branch. Nixon versus GSA, I'm sure we've all read it backwards and forwards for this case by now at least 6 times, says yes, the former president can raise that claim, but I want to come back to that in just a moment, can raise that claim, but the current president holds sway there, certainly. Now,
wait, hang on, you say hold sway. I wish they had, but what they said is that the former president's claim is
give greater weight.
Yes, give greater weight.
Greater weight.
They make the diminished or something like that.
And
I suggest that there's still balancing to be done. And so, what?
And there may very well be, Your Honor, in various cases, because remember, Nixon versus GSA also was quite different from this case because it was a broad challenge to a brand new statute. In this situation, we have the current president. In those cases, in that earlier case, it was 2 former presidents who
right.
said
We
the
don't
statute was
today. So back to my original hypothetical about the avenging one. So, former president comes into court and says, wait, you're releasing information. I have in these executive privilege documents the identities of foreign agents of foreign governments who are adversarial foreign governments who are cooperating with us and helping us. And it's going to get out. And they're going to die, and we're going to lose all that information that we need. And so, yes, incumbent president, you have made this judgment about the executive branch's interests and the interests of the people of the United States. And so I'm lower on the scoreboard or lower on the scales, but I'm coming to tell you there's 8 specific things that are so vital and are not reflected in this generalized assertion of the interests of the people of the United States that have yet to be taken into account that need to be weighed by a court, including people will die. Could the former president win then? At least for those documents?
I think, yes, Your Honor, that may be a circumstance when the 25th Amendment would suddenly become relevant. I'm not sure, but remember.
I'm not talking about the 25th Amendment. I'm talking about the balancing that the court's doing.
No, I understand, but as we know, presidents have to make determinations regularly when people will die. The president is the commander in chief, and the president could, a former president decides to send troops to a particular area. And then the new president, let's say that new president won on the basis, the key issue in that campaign was, I'm bringing the boys home. Boys and
troops
girls.
home.
I'm bringing the troops. Thank you. I'm sorry, Your Honor. That was insensitive of me. I'm bringing the troops home. And that may mean that people will die. Nobody would possibly say that the current president is not the one who makes that determination. As we know,
no, I'm only talking about the executive privilege as to documents, right?
Right.
No.
Well, it documents, records, materials. Obviously, it can be tapes, etc.
Yes, of course.
But again, that's the decision by the current president, except in some weird hypotheticals that maybe we can come up with, which, as I say, might very well raise questions about the president's sanity or something. But certainly that's nowhere close to anything we've ever faced as a nation.
So if the former president, the former president comes in and says, I beg to differ on your judgment about the interests of the American people and the long-term, immediate, short-term, medium, and long-term impact on the executive branch of this sweeping waiver of executive privilege that you're doing. I think you're very wrong to do it. You're misguided. You're doing it for all the wrong political reasons. You really are going to end up hurting the executive branch, but nothing more particular than that. That tie under Nixon versus GSA goes to the incumbent president.
Always, Your Honor. And the one other point I wanted to make about Nixon versus GSA is remember too that what that case was about. That was a situation where up until then, presidential records with the personal property of the president. Sadly, many presidents destroyed their records. And the Supreme Court notes this in the GSA opinion. Congress then makes a major change and says, we need these records preserved because President Nixon otherwise is going to destroy these records. And so we are changing things. And so President Nixon was suing really in his personal capacity, saying, no, these are my records. 180 or 70 degrees years of history show that. And this is a major change. Now, so his claim was really quite different from now.
Counsel, I think, though, that there was a threshold issue that was raised that the Supreme Court decided that impacts how we should interpret what we're doing here today. There was a threshold argument made that there was no separation of powers concern in Nixon v. GSA because you had bicameralism and presentment. The Congress had passed this bill. President Ford had signed it. The incumbent president, agreed with Congress on the action that should be taken with respect to these tapes. And so this didn't really present a separation of powers issue. And the Supreme Court flatly rejected that.
Yes.
And said, it doesn't matter that the incumbent president agreed with this action. The former president still has this right to raise executive privilege. And yes, we say that it gets less weight than the incumbent president's view on executive privilege. But to resolve the separation of powers concern there, they did a balancing test. They said only where the potential for disruption to the executive is present must we then determine whether that impact is justified by an overriding need to promote objectives within the constitutional authority of Congress. It's essentially the same sort of balancing test that was done in U.S. v. Nixon, that we did in Select Committee versus Nixon, that kind of is the overall kind of like balancing that is done, that was done by the Supreme Court in Mazars. You know, compelling need, or the need of Congress, is it sufficient to override the privacy interests, the interests of the executive?
Right.
You're saying that we don't do a balancing. We just say, you know, we weigh the incumbent more. So what if, like, there's 4 former presidents that say these documents should remain privileged? It would be terrible. It would destroy the office of the executive to waive privilege, but the incumbent says no. I think that privilege should be waived. The 4 former presidents, does that equal one incumbent president? We don't do a weighing. I mean, why don't we do a weighing of the interests? If Nixon v. GSA did a weighing of the interests, why don't we do one here?
Yeah, because, Your Honor, there's a very key difference. First of all, the quick answer to I think it was a rhetorical question, but 4 former presidents versus 1 incumbent. No, that's easy. The incumbent obviously wins. But the difference is, there's a very central difference between the Nixon case and this case. There, the president, the former president, was suing and making an executive, making a, as you point out, a separation of powers claim and separately an executive privilege claim. And the Supreme Court said he loses on the separation of powers claim. This case, remember, is not about the president making a claim in his personal capacity saying, I own those records. We know he does not own those records. And by the way, remember, not only was Nixon making that argument, Nixon turned out to be right, because he later obtained compensation from the United States government because he did own those records until Congress changed the law. Here, Mr. Trump has said absolutely clearly in his brief, he is suing in his official capacity.
But I don't understand what difference that makes. My point is that the Supreme Court said that this statute raises a separation of powers concern.
Right, and this does not.
Even though President Nixon isn't in office anymore.
This case does not raise a separation of powers issue because the President Biden, the only head of the executive branch, and the legislative branch are in complete agreement here. So there is no clash. There is no separation.
That same argument was made in Nixon v. GSA. They said there's no clash because this statute, which is being challenged as facially unconstitutional, was signed by the incumbent president and passed by Congress. So where's the clash? The court said there is still a clash.
But again, remember the clash there was because former President Nixon was saying those papers are mine. President Trump is not saying that. He can't say that.
But the personal, his argument that the papers are mine didn't present a clash between Congress and the office of the presidency. It presented a clash between his personal property rights and the law.
Right. And let me, though, if I can, just jump to, I've made the point, we think they are different, but in any event.
Okay, hang on that thing, well, before you in any event us, as part of the separation of powers analysis, it's a separation of powers analysis, notwithstanding the views of both President Ford and the Carter administration that defended the law. Well, it seemed important to them that this law does not make the presidential materials available to the Congress. That was cited as part of their balancing of separation of powers there. And this statute quite expressly does.
That's right.
Does that not change? So for some reason, they thought we're still going to balance separation of powers even when the incumbent political branches are in agreement. We're still going to balance here. And this time, the balance, there's different weight on the balancing because this does make documents available to Congress.
Right. Then the fact that this does make them available to Congress, you're right, is a difference between the two. The fact remains that the only claim under the statute that the president can raise is his privileges. And so he can make an executive privilege claim, and the current president, so there is no clash here between the branches. Mr. Trump says, I'm suing in my official capacity. And what we're saying is, you really have basically no official capacity here, except under the statute, you are allowed to make an executive privilege claim, which again was allowed in Nixon versus GSA.
Mr. Letter, in Nixon versus GSA, I guess I'm confused by your concession that this wasn't about Congress's needs or interests or whether or not Congress could have access to the documents, because I'd understood the Supreme Court, at least in part, stating that adequate justifications were shown for the limited intrusion into executive confidentiality, and that among those interests was Congress's interest in preserving the materials, to restore public confidence, Congress's need to understand how political processes had in fact operated, and that's why the Supreme Court suggested, at least in this part of the opinion, that the intrusion on confidentiality of the executive was justified because Congress had made the determination that these records needed to be preserved and treated as public records, not private records, because it may need them to facilitate a full airing of the events leading to his resignation, that there were important governmental and historical reasons for the preservation of the records. So it seemed to me that the Supreme Court was contemplating that Congress could access these records, the public may access these records, and that's why it was constitutional in the separation of powers balancing to have a statute that says these records are public records, they belong to the United States and not to the president. Am I wrong about that? I mean, there was a congressional interest in this.
Your Honor, you are exactly right. And Frank, I was about to make that point. Yes, you're exactly right. And in fact, let's look at the other highly relevant case here, U.S. versus Nixon. You know, Mr. Trump here makes the same claim. Well, U.S. versus Nixon was about simply an in-camera inspection by a judge pursuant to a criminal trial subpoena. But remember, the whole point of the criminal trial subpoena was the court would then do an in-camera inspection, which could then lead to that it would be publicly disclosed as part of a criminal trial. So in both U.S. versus v. Nixon and in Nixon versus GSA, both of those cases had as part of the background that can't be forgotten that it wasn't just about disclosure within the executive branch or disclosure simply to a judge to make a determination about based on an in-camera inspection. It was about something much larger than that, as you have correctly pointed out. All I was going to do, Judge Millett is saying, make these points, but in any event, we and President Biden here win anyway. If you're going to do any kind of balancing, the balance is the interest of the executive branch versus the interest of the legislative branch, and that's where I come back to, and I will not be shaken from. There is no clash here between the branches. The president has made a decision that he explained about the important interest of the American people in having the select committee get to the truth here. And so the president is completely in agreement with Congress in this situation. So there simply is no separation of powers claim that a former president can make that could.
Part of evaluating the executive privilege, whether it is overridden, you typically do a balancing, just as was done in Nixon v. GSA. That's what we did in Senate Select Committee. And when you do a balancing, you weigh considerations such as the scope of the requests, the necessity of the information, and indeed, because of a ruling by our court that there wasn't a necessity for the records, the court upheld the executive privilege claim in Senate Select Committee, right?
Your Honor,
if we start doing the balancing test, don't we have to consider things like that, scope of the request, the necessity, burden, etc.?
Your Honor, remember in Senate Select Committee it was completely different. It was a sitting president. There was a clash between the branches. There was a separation of powers issue. There is none here. And so, no. I
don't understand your argument, counsel. You're saying that if a former president raises executive privilege, you don't do a balancing test, but if an incumbent president raises executive privilege, you do a balancing test.
That's exactly right, Your Honor. So, and here's why that makes perfect sense under Supreme Court doctrine, because we have one president. That one president is in charge of the executive branch. That president has done the balancing. It's up to that president to make the balance. That president has made the balance, and he said, part of what he said is the need here is extremely pressing. It's so great that this executive privilege is not appropriate here. As far as separation of powers, I'm going to say it one more time. Senate Select Committee is a completely different case, just as Mazars is a completely different case. There is no separation.
Different case because that involved a former president.
I'm sorry, which did?
Nixon v. GSA involved a former president, and they said there is a separation of powers concern here.
But again, they recognized they dealt with President Nixon's argument, and what I'm suggesting is it was in a different context, especially because remember, here we have the incumbent president has actually looked at the documents and done the balancing. This isn't a claim, a constitutional claim facially against a brand new statute. This is about specific documents in a specific context.
So, Mr. Letter, at a minimum, even if you're right, or Judge Wilkins is right, that nevertheless there's some balancing for the court to do in a situation like this. You say the incumbent president himself, in a situation that we are in, has done the balancing of the various factors that we would ordinarily do if it was actually a dispute between the legislature and the executive. So he's done it in this situation, and he agrees with the legislature. So you say that should be enough. If Judge Wilkins is right that there's still something left for the court to do, at a minimum, would you say that we should give some deference to the incumbent's determination of this, even if he doesn't get to win it, right? Are we talking about, either we have to give it all to the incumbent and we don't do any balancing, or I suppose there's a world in which we could say, okay, the court still has a role to play here in this current circumstance, but they have to give some deference, if not great deference, to the incumbent's determination of the balance.
Yes, Your Honor, and indeed, I'm trying to think of what the court order would be like in this case. The court would say, no, we know better than the current president does, that Congress is not entitled to this material. I don't know what the why would be. I think all you could do is say, because the president's, there's a strong interest in the presidency in confidentiality and having presidential advisors being able to give clear advice. When the current president has said that's outweighed here, and remember, that really is about the only argument they're making. And remember, a very key point, Nixon versus GSA, U.S. versus Nixon, and the practice of almost every modern president is they have disclosed to Congress and the public the advice they have gotten from high-level officials in the White House.
They haven't, I'm sorry, go ahead, Judge.
Counsel, you would concede that in any kind of clash between Congress and the president, where the president has invoked privilege and Congress was saying we should get these documents notwithstanding the executive privilege because our need outweighs the interests of the executive, and you came to court, you would want us to overrule the incumbent executive's determination about the interests of the executive there so that you could get the documents, right?
Exactly as U.S. versus Nixon. You would do exactly what...
So you're saying that the court can overrule the incumbent president to give Congress documents but the court can't overrule the incumbent president to say that Congress can't get documents. You want a one-way ratchet.
Yes, Your Honor, because again, remember, this is so essential. I cannot emphasize this enough. Remember that we're dealing with a question of are the branches in conflict with each other? In this case, the branches are not in conflict with each other. When the branches are not in conflict with each other, there is nothing really for this court to do as far as separation of powers. If the president
Except to the extent that the former president representing at least, having some standing to speak up for the executive branch does say that there's a conflict.
And no, he can't say there's a conflict. He can say President Biden is wrong. President Biden doesn't know what he's doing. And so I want a court to tell President Biden, you are so far wrong that this requires the Article 3 branch to step in and override both the Article 1 branch and the Article 2 branch. I find it very difficult to come up with, as we talked before, of a hypothetical that is anywhere close to realistic when this court or any court would feel that it was appropriate to do that. When
even if you had 4 former presidents, you would still say the court could never find that they might have a better understanding or their views should merit more weight than the one incumbent president.
Oh, obviously, Your Honor, because only the current president knows the situation. Only the current president knows what is in the national security interests of the United States. Former presidents have no special knowledge. As I started out with, Chief Justice Marshall said, they go back to the private sector.
Well, I don't know why Nixon v. GSA was written the way that it was, why Public Citizen v. Burke was written the way that it was, why Nixon v. Freeman from our circuit was written the way that it was, because it might as well just say, whatever the incumbent president says goes. And the former president's views have no weight.
I don't, as we've been discussing, we probably can come up with some hypotheticals where the former president's views would have weight. We probably can. I'm not aware of any that are realistic. And it seems to me that therefore, and I'm fairly sure that you're going to hear the exact same thing from Mr. Boynton. Therefore, there is no clash between the branches. When there is no clash between the branches and no private interest, remember, Nixon versus GSA, there was a private interest. In this case, Mr. Trump has said, I'm suing merely in an official capacity. So this isn't a question where the president and the Congress are getting together and ganging up on some private rights. So under those circumstances, this is not, it would be astonishing for this court to override the current president and Congress. And I don't think that the Freeman case or the Burke case are in any way inconsistent with this. Those were cases where involving what was to be done, how the former president's records were to be dealt with, what standards were to be applied within the executive branch, and private parties then were suing about that and arguing what should happen. And if I recall correctly, Nixon versus Freeman was about the very thing I was talking about before. President Nixon actually did have a private interest, and he got many millions of dollars from the United States government. But that has nothing to do with what we are talking about in this case. And obviously, in order to affirm the judgment below, this court does not have to say there are no circumstances we can conceive of when the former president might prevail. You don't have to do that. The key is here, did Judge Chutkan reach the correct result? And under the facts of this case, it seems to me that is indisputable. I had some notes here about some of the other questions that that were asked. If you give me a second, I just want to skim them to say, I'm sorry, Judge Wilkins, you had asked my friend about would there be a situation when the court could issue a protective order that would bind Congress as far as what it could do with the documents. This, as we cited in our brief, this circuit's precedent, Hearst versus Black, says that you cannot. Under separation of powers, there is no Article 3 power for you to issue an injunction like that to Congress. So that's the law of the circuit.
No, but if there's an injunction, if the injunction is to the archivist to provide it to a committee on these terms, right?
That injunction wouldn't bind Congress then.
That's not my question.
I'm sorry.
The question is, yes,
Sorry.
the injunction would bind the person named at the archivist. What is, are there rules within the House or for the committee that would, maybe they can't be enforced in litigation because of speech and debate clause, but are there internal rules that could be internally enforced that would give weight to that confidentiality agreement?
Different committees have different rules, Your Honor, about confidentiality.
What does the select committee have?
My understanding is the select committee has no rules about this on its own. The select committee is governed by the rules of the House. Mm-hmm. The rules of the House provide that records of a committee belong to the committee and they belong to the House. So the House could decide voluntarily to, if the archivist sent the records to Congress and said, I really, really hope you don't publicly disclose these, Congress, the House could make a determination of whether to abide by that or not, but that would be a decision by the House. I'm not aware that there's any rule that would govern what the select committee would do.
Let's not have the archivist just say pretty please. Let's say the incumbent president's decision says I'm making this decision.
Right.
Based on accommodation between the branches, we've worked through this, we've had an agreement, and it is being provided subject to promises of confidentiality by the committee. And it's by the committee as an entity and each of its members.
And Your Honor, it would, I think it is extremely likely that when accommodations like that are reached, Congress will abide by them. But the president, neither the president nor the courts have any authority under the separation of powers to issue any kind of binding decision rule.
Well, I'm just asking what would happen in practice. In practice, would there be consequences if a member then breached that agreement? Would there be consequences for that member?
There could be consequences, yes. Remember that the speech or debate clause does not apply to Congress itself. So Congress could discipline a member who violates House rules about confidentiality.
Remove them from the committee? I'm sorry, Judge.
That's essentially what I was getting at. Yeah, you can't issue a protective order that binds Congress, but you could issue a protective order that says that the archivist can't disclose this to Congress unless and until there's an agreement about confidentiality that says X. And then maybe it can't be enforced in court, but just like any member of Congress can't take like some classified document that they got in the Intelligence Committee and decide to go out on the House floor and disclose that document because they think that the American people need to know it, and do that kind of without any consequence. You could construct a scenario here that would protect these documents in a similar fashion, couldn't you?
Your Honor, I have to answer yes or no and say, yeah, you could construct something like that, and you presume, right, under law, you presume that Congress acts in good faith, and therefore it is, I would think, extremely likely that that agreement will be followed. If an individual member of Congress chooses to act in a renegade manner, as you know, there's nothing that the courts or the president can do about that. That's the framers made that decision. That's binding. Congress could discipline such a member, and so that is a way that Congress has of enforcing something like that. But I don't want to miss.
Understood. But my point is that it's not inconceivable that the court could order terms of the disclosure by the archivist that would have some practical effect, even if they couldn't be enforced by contempt against Congress. But assuming that everybody is acting in good faith and abides by their agreements and isn't going to, flout the law or the spirit of the agreement, that the court could place some limitations on the disclosure by the archivist that would, likely or more than likely ensure some restrictions in confidentiality, right?
Exactly, Your Honor. The way you framed it just then is key. And so, yes, I can agree with you on that. But remember, we're talking about a practical world here. The select committee, when it gets the material, it has to do something. It has to use these materials. That's the whole point of why these are being asked for. So the select committee would be looking at the materials. Their staff would be looking at the materials. Remember that the select committee then is making all sorts of recommendations to Congress as a whole, et cetera. But again,
understood, and I think our point with the friend on the other side, just to kind of bring this to a close in the interest of time, was that they never made any such request anyway, right? That issue isn't before us because they didn't ask for that limitation and say they would be fine with disclosure with that limitation or any other limitation. They just raised a broader objection to disclosure to Congress, right?
That's exactly correct, Judge Wilkins. You're 100% right on that.
Mr. Letter, in the interest of time, I actually have two just sort of quick other points, if my colleagues will indulge them, which is I'm trying to understand whether all of the PI factors at issue here actually turn on the likelihood of success on the merits. So that if we disagree with the former president's claim that he would win on the merits, does he necessarily lose the irreparable harm point because he's saying that he'll be harmed by the confidential nature, by the release of confidential documents, but the merits is the determination about whether or not he has the right to withhold them? And then what about the public interest and, the balancing of the equities here? If he can't succeed, does he necessarily lose on that as well?
That's exactly, Your Honor. I think your observations here are very perceptive. Yes, in determining the merits there, I believe you would automatically then have ruled on those other two factors. As you know, the Supreme Court and this court have said the public interest prong, it applies in a special way when you're dealing with the government, which we are dealing with here, the two branches. And yes, in order to have ruled that there was no likelihood or little likelihood of success, you would have held that there isn't an injury here to Mr. Trump, because that's not what executive privilege is. Not for Mr. Trump, it's for the presidency.
All right, and then my only other question is about remedy. So if we were to affirm the district court's denial, I would think that the reasons for our administrative injunction preserving our jurisdiction would be resolved, and there wouldn't be present need from our perspective, jurisdictional perspective, to maintain that temporary hold. So would we dissolve that injunction at that point? Would the records be released immediately? Should there be some consideration given to the right of the former president under that hypothetical situation for further review, or how should we think about that?
Your Honor, yes, you would dissolve the injunction. On this, I think this question has to be asked to Mr. Boynton, because, as you know, the records are in the possession of the executive branch. We think that the stay or injunction pending appeal should be dissolved, and that the records can and should be turned over immediately. But as I say, we don't have the records. And I'm going to definitely be quiet in a second. I just want to point out one other thing, unless the court has other questions. There was talk about accommodations. Remember that in the Lassiter declaration, joint appendix, page 128, paragraph 25, he points out that there have been accommodations that are already being made between the executive branch and the legislative branch. And so that is something that the requirement.
There was a deferral of a request. What does the deferral of a request mean?
It meant that as you know, there are many records involved here. The archivist has agreed to examine them and turn over records on a rolling basis. So what the archivist suggested was that on certain records, we could defer them so that wouldn't get in the way of the archivist and the White House performing its function.
I'm going back to where I started. What does defer mean? I think that means the committee hasn't chosen not to pursue that claim, or is it withdrawing as to those documents?
No, there is no withdrawal.
Tabled for now.
What you just said. Right. Yes, we're not withdrawing. We're saying yes. Those are put aside. So by agreement of the two branches, those are put aside, and it may very well
for the time being.
Yeah, exactly. Yes, Your Honor. And it may be that is permanent then, when after this litigation is over, after the archivist has
or the President Biden may not, push come to shove, may decide to assert privileges to those.
That can happen at any moment. Yeah, exactly, Your Honor. That can happen at any moment.
Deferral reserves the ability to, I guess I should ask Mr. Boynton, or he can tell me if I'm wrong, but deferral at this point certainly reserves the ability of the President Biden to assert privileges to those.
Absolutely.
And so should we be concerned as a practical matter about the court sort of interfering with this process of release and accommodation that is ongoing? I mean, is there some aspect of this that is kind of akin to, you know, do we have a final order? Are we in a place where the court can review privilege in a meaningful way without interfering with the processes that are ongoing in the negotiations between the legislative and the executive?
Absolutely, Your Honor. And as you, I believe Your Honor is very familiar with the Supreme Court decision in Eastland, where the Supreme Court made clear that the courts are to be extremely wary of issuing injunctions that interfere with an ongoing congressional investigation for legislative purposes. So yes, that's why you know, we hope that this court will rule very expeditiously and will affirm Judge Chutkan and vacate the existing injunction, because this is interfering with something that is going on right now with immense speed. And these are key documents, as President Biden recognized, these are key documents that the Congress should have, and they should have them right now.
The committee have a sort of, it may not have a formal timetable, but a sense of when it needs to at least issue maybe a first report on this to allow legislation before the next election. I'm just trying to get a sense of the compressed time frame here.
Your Honor, I
being urgently, and we are too. But
I have not heard Chairman Thompson or Vice Chair Cheney give any kind of dates. So I'm not aware of anything that I would feel comfortable saying to the court as far as timing. It's just they're moving at breakneck speed. Thanksgiving has not slowed us down at all, sadly. So the select committee is moving very, very rapidly. So no, to my knowledge, I'm not aware of any time guidelines, et cetera, that the chairman has announced.
my colleagues have further questions? All right, thank you, Mr. Letter. We're just under an hour on you, so thank you for your time. Mr. Boynton, I hope you didn't make lunch plans.
Thank you, Your Honor. I did not make any lunch plans.
I apologize for the delay.
No problem. I'm happy to launch right into things here. Or if the court wants to take a quick break, that's okay too, however you prefer.
I'm ready to proceed. Or are my colleagues ready to proceed?
Yeah.
That's fine.
Excellent. May it please the court, Brian Boynton from the Department of Justice. In light of the extraordinary events on January 6th and those surrounding it, President Biden made an affirmative determination that it would not be in the best interests of the United States to assert privilege with respect to the documents that are at issue here. That decision—
Just to be clear, the documents at issue here are the first 3 tranches?
That's correct, Your Honor. That's all that's at issue in this PI. And that's what we're here talking about. There will be more tranches to come, and those will be reviewed by the administration carefully, and determinations will be made then about whether or not to assert privilege. The accommodations process will occur. It has already been occurring, and it will continue. And there's every reason to think that some of the requests will be narrowed, and that there may well be some assertions of privilege down the road. But at this point—
And you retain the ability to assert privilege. I just want to confirm that I'm correct in understanding that as to the documents that there's already been a deferral on, that preserves President Biden's ability to assert executive privilege at a later point.
That's correct. That deferral was part of the accommodation process. It means the documents have been tabled. At some point, the committee could decide to withdraw the request. The administration could decide to assert privilege. No decision has been made yet. But with respect to the documents that are at issue here, where President Biden has made an affirmative determination that it would be in the best interests of the United States not to assert privilege, this really should be a straightforward case. There are lots of difficult issues that we've discussed and we'll discuss further, I'm sure. But in the circumstances of this case, given the greater weight that is owed to the incumbent president's determination, President Biden's decision not to assert privilege was eminently reasonable and ought to be controlling. The court has asked some questions about
that decision. I don't mean to probe in a way that's inappropriate, but the former president raises concerns about the breadth of this request, and that, you know, it's the first three tranches seem pretty closely tied to January 6th and events between the election and January 6th itself. But that's certainly not the reach of this congressional request. It is much, much broader and going all the way back to April 2020. In making decisions on executive privilege, does the president include in that a judgment about the sort of statutory factors that are referenced in 2205, the congressional need and the availability of alternative documents, or is that something that the president, I guess, just leaves to the archivist?
Your Honor, those same criteria in the statute, track the kinds of things you would look at generally in assessing whether Congress has authority to make a request to the executive branch, and the kinds of things that the executive branch would normally consider as part of the accommodations process. And so, yes, those are factors that will be considered in the ongoing discussions. But is there a need for these documents?
Are they considered in the decisions already made as to the first three tranches? Not to, if you can say, were they considered in determining not to invoke executive privileges to the first three tranches?
What I can tell you is that the documents, were carefully reviewed, by the White House, as reflected in the White House counsel's letter. A determination was made that Congress had a compelling need for these particular documents that are at issue. And so, yes, there has been a determination about the needs for these particular documents.
But what about the second prong? I'm sorry, go ahead.
But does that, I thought that your brief was saying that kind of like a broader determination had been made by President Biden, which was that executive privilege was not going to be asserted for anything that fell within the scope of these requests, not just the first three tranches. Did I misread that?
Your Honor, so far the determinations that have been made to date relate to the particular tranches of documents at issue. There's not been a determination that every document that falls within the breadth of the request would be disclosed, or that would be in the interest of the United States not to assert privilege with respect to that broader set of documents. Those are determinations that will be made down the road.
What about the second statutory factor on alternative sources?
Your Honor, that is something that generally is considered as part of the accommodations process. There have not been any arguments that I'm aware of that the particular documents at issue in these first three tranches are from some other source. The former president in his brief makes arguments generally about the availability of documents from other sources, but does not make any particularized arguments about the documents at issue in these first three tranches. down the road in future tranches, if there are arguments about the availability of documents from other places, yes, those are things that would be considered. I'm happy to continue along these lines. I'm also happy to discuss the jurisdictional and cause of action questions, and then return to the executive privilege questions, however the court would like to proceed.
I'm going to ask you the same question I've asked everyone else, and that is, what is the position of the executive branch on the United States government on what courts are supposed to do if, assuming the statutory criteria are found to have been satisfied, at least as to these tranches, and we are left with the decision of the incumbent president that executive privilege is not warranted in this case, which Nixon versus GSA says at a minimum gets more points on the scoreboard. On the other hand, we have, Nixon versus GSA talks about executive privilege. It diminishes over time, but this one is pretty quickly on the heels of former President Trump leaving office. So I think on his side of the scale, although they have not argued at this point, on his side of the scale, the recency of it has to count for something on the nature of his interest. And so, one, what is the legal test we should apply? Is it just the same balancing test we would do for Congress versus an incumbent president? And two, what, in whatever that test is, can you include what weight, deference, treatment, extra points is accorded to the incumbent president's decision?
Yes, Your Honor. So let me start first by saying we don't think it's the same test that applies when an incumbent is asserting executive privilege. This is a unique situation. We're not aware of any case that has dealt with a situation where a former president has asserted privilege and the incumbent president has made an affirmative determination not to assert privilege. This is different from Nixon versus GSA for the reasons that have been discussed. In that case, President Carter was defending the constitutionality of the statute and the general scheme, but there was no individualized evaluation with respect to particular documents. So therefore, there's no test existent in the case law for how to deal with this situation. Nixon versus GSA lays out a whole bunch of reasons why the incumbent's views ought to be given greater weight. The DC Circuit said the same thing in the Dellums case. One, this is a privilege that is held by the Republic, not by an individual. Two, the incumbent is in the best position to evaluate the costs and benefits of asserting privilege. Three, if there's a decision made not to assert privilege, the burdens of that fall on the incumbent. Four, the incumbent is the only politically accountable actor. And then fifth, it's the incumbent that is exercising the duties of the presidency. And in no other respect, this was discussed earlier, in no other respect that we're aware of does a former president have the ability to block something the current president wants to do. The current president could decide to declassify information his predecessor had classified, withdraw a state secrets privilege, withdraw from an executive agreement. It would be extraordinary in any of those circumstances to think that a former president could say, no, you cannot do that. So we think that whatever the—
Mr. Boynton, does that mean, with all of those considerations taken into account, those aren't really particular to this set of records or this circumstance? They seem to suggest that in every situation, the incumbent would win. And is that your view? So we come to court, assuming the former president has the right to bring in action saying my view is different than the incumbent president's with respect to the exercise of executive privilege. Are you saying there really is no test to be applied in that circumstance. The court, based on the factors that you just articulated, says incumbent view wins.
It may well be the case that the incumbent is going to win most of the time, perhaps all of the time. We don't think this court should make that determination. We don't think you need to or should issue a ruling that says the incumbent always wins, because this is an unsettled area of the law, and there's no need to reach that conclusion here. We think instead.
What test do we apply? I'm back to where I started. So what
Yes.
test do you recommend we apply?
I recommend that the court review deferentially the incumbent's decision that it is in the interest of the United States not to assert privilege. I think that would be an appropriate test if the court were to determine that some test had to apply here. And that would mean
Reviewing the decision like an APA type review, the difference, we're going to look and we're going to say, does this make sense to us? Or do we take that as a given and that judgment as a given, and then we just balance to see what's on the other side of the scales? Those are
Right.
two different ways of analyzing this.
I agree, Your Honor, and I don't think this would be like the APA. This is a very different context here. I think if there is any kind of review a court would engage in, it would have to be a highly deferential review that asks whether the decision could be objectively rational. It wouldn't be any inquiry into particular motivations. I don't think a court is in a position to do that. And it can't simply be some kind of de novo assessment of whether the court believes it's in the interest of the United States to disclose these documents. The president is uniquely, the incumbent president is uniquely well situated to make the determination about what's in the best interest of the United States. And so any kind of test here would have to be one that was extremely deferential and would only block an incumbent president in the most extreme cases. And I don't think the court should definitively hold that there are any cases in which the former's views should displace the incumbents, but I think the court could proceed under the assumption that there could be extreme circumstances in which the former would win, but then conclude that in the circumstances of this case, the incumbent's claim is rational on its face and is not one that the court is in a position to second guess. I think that's largely what the district court did here, and it seems like the right approach.
Rational on its face. So here we have a written explanation of the White House counsel. But what if the president gave no explanation, just said, I have determined in the exercise of my Article 2 responsibilities under the Constitution, this is not to be exercised in this case. Nothing else said.
Yes, so I don't think this is like APA review. There's no requirement for a written record. There's no requirement that.
How do we decide under your test that that decision is, I think what you said, objectively rational?
It could be similar to the way courts review legislation under a rational basis test, asking whether there's any conceivable basis on which the president could have decided that this was in the interest of the United States. I don't think it would be a test that looks at particular motivations. That would be impractical and intrude too greatly into the presidency.
You mentioned Dellums v. Powell. In Dellums v. Powell, we said, and this involved records of a former president, we said the various decisions concerning the privilege reflect a balancing approach, weighing the detrimental effects of disclosure against the necessity for production shown. And then after surveying the law and the record, we affirmed the district court, and we said we were affirming a ruling of the district court that the plaintiffs established a specific need for the requested information sufficient to overcome the rebuttable presumption of privilege of a former president, assuming such a privilege exists. So the district court did a balancing test. We affirmed their balancing test, and we said, generally speaking, in determining privilege questions, executive privilege questions, we do a balancing test of kind of need versus and determine whether that overcomes the kind of intrusion on the office. So I don't understand why you say there's no balancing test that we do here.
Understood, Your Honor. I agree that if you were to determine that the former president has validly made an assertion of executive privilege, notwithstanding the fact that the incumbent has determined not to assert privilege, such that there was some executive privilege that had been validly asserted, then I think you would move to a balancing, like in Dellums or Nixon versus GSA, and you would look, it would be a different kind of balance than would occur if you have an incumbent who's asserting privilege, because the former's assertion would be due less weight, but there would be some kind of balance. What we're saying, though, is that in the circumstances of this case, you don't even need to reach the balancing. Dellums was a case like Nixon versus GSA, where the executive branch had not reviewed particular documents and made an affirmative determination not to assert privilege, that it's in the interest of the United States for the documents to be disclosed. In that case, the executive branch had resisted the subpoena, but had not asserted privilege, had just raised relevance grounds. You didn't have the same kind of affirmative determination by the president that it's in the interest of the United States to disclose the documents. So that's what we think makes this a different case, where you don't even need to get to balancing of confidentiality versus need. We think that in this case, the incumbent's view with respect to the assertion of the privilege ought to prevail. But this court can and perhaps should reach both conclusions and conclude that if there is an interest here on the part of the former president, that the need that Congress has asserted outweighs that interest. And I think, Judge Wilkins, you were correct earlier in your assessment of the DC Circuit precedent that kind of balancing would happen on a global scale, not on a document by document scale. And that in the circumstances of this case, the congressional need would overcome whatever residual confidentiality interests there were on the part of the former president.
Mr. Boynton, can I just maybe say what I think I hear you saying in perhaps a different way, and you can help me to determine whether this is what you mean? That in a situation in which we have a determination by the incumbent president that the privilege is going to be waived, that these documents should be released, there is perhaps a separate separation of powers concern about the court coming in and making this decision to award it or to say the incumbent president has gotten it wrong and the former president's view should prevail, consistent with some balancing test that we invoke. That even if we would ordinarily just balance everything out in a world in which we were called upon by the separation of powers as between the two branches, right? If there was a conflict between the executive and the legislature, and we were somehow called upon to resolve whether the document should be released, we, under our precedent, might do the balancing test or whatever is required to determine that outcome. But that in this situation, where there's not only the lack of a dispute between legislative and executive, we have the incoming executive having actually made a determination about whether the documents would be released. And so in this world, the court swooping in to do some sort of balancing test as we would in the other world actually raises its own separation of powers concerns in terms of the power of the court to resolve or to second guess what this executive is saying. Is that your position?
Yes, Your Honor, we agree that having a court try and referee this dispute between the incumbent and the former does raise those kinds of separation of powers concerns. And we made that argument in our brief. It's one of the factors we think should lead the court to determining that if there is any review here, it would need to be highly deferential and give significantly greater weight to the incumbent than to the former. And it's a reason, I think, that the court ought to decide that the incumbent's view, at least in the circumstances of this case, is controlling, and therefore that there's not a need for balancing. If you then go on to decide the balancing issue too, that may well be something you decide to do, and we would have no objection to that, but we don't think you need to reach the balancing issue.
There's your view or your response to my questions earlier about how to properly read Nixon v. GSA, because there again the claim was made that there was really no separation of powers issue raised because the then incumbent president agreed with Congress on the statute, and so to the extent that there's a question as to whether the statute raised any separation of powers concerns, that's resolved. And the court said, no, not so fast, we disagree.
Yes, Your Honor. I think there are two different things going on in Nixon versus GSA. There is a separation of powers challenge, and there's also an executive privilege assertion. It is completely ordinary for a court to still consider a separation of powers challenge to a statute, even if the executive branch is defending the constitutionality of the statute. The executive branch doesn't get to simply acquiesce in something that otherwise would violate the separation of powers. The executive couldn't, for example, acquiesce to a line item veto power for Congress. The court still has to evaluate that challenge. Executive privilege, though, we think is different. Executive privilege is something that is vested in the executive branch for the benefit of the executive branch, and that where the incumbent president has made a determination that it is in the public interest not to assert the privilege, we think that ought to be controlling at a minimum in the vast majority of cases, and potentially in all cases. But again, that's an issue we don't think you need to reach. And so I agree that the court in Nixon versus GSA did do that balancing, and it did it in the context of the separation of powers challenge. It also did it with respect to executive privilege. But with respect to executive privilege, our view is that the reason the court had to do that is because it wasn't a case like this where the executive, where you were dealing with particular documents and the incumbent president had made a determination that they should be disclosed. There was a separate argument that was raised by the former president in his reply brief that we haven't touched on today, but I would like to just mention it briefly because we haven't had a chance to address it. The reply argues that the PRA itself limits the ability of the incumbent to second guess a privilege assertion by the former. The former president points to the language that's existing in 2208 C2C, and is also in the regs at 1270-44 F3 that talks about whether the incumbent president is going to not uphold a privilege assertion by the former. And they argue that not uphold has a specific meaning, and they say that that means the incumbent president can only assess whether the requirements for the invocation of privilege are met and doesn't allow an incumbent president to make a determination, as occurred here, that it's not in the interest of the United States to assert privilege. We think that argument is waived because it was raised for the first time in the reply brief. We also think it's demonstrably wrong. It's inconsistent with the PRA, which makes clear that the statute is not limiting either president's constitutional authority. That's in 2204 C2, I believe. And there's also nothing in the text of the language not uphold that says that what the incumbent is allowed to do is only determine the legal validity of whether a document potentially could be subject to a claim of privilege. There are no cases supporting this not uphold argument as well. And it's also contrary to the legislative history of 2208. There's a House report and a Senate report, neither of which give any indication that 2208 was designed to limit the authority of the incumbent president. In fact, it's to the contrary. They talk about how the process there mirrors the process in the Reagan and Obama executive orders, which gave more authority to the incumbent president by making disclosure the default in a circumstance where the incumbent president has decided not to invoke the privilege. So that was just a new argument in the reply brief that I wanted to touch on. It relates. Sorry.
Did you want to finish up that point? Go ahead.
No, I was done with that. I was going to transition to some of the other statutory issues, so I'm happy to pause for questions.
Yes, back to discussing sort of the court's role in this, can you help me understand from the executive branch's view what the nature of a former president's continuing executive privilege interest is? It's not any personal interest in confidentiality. You know, I promised someone I wouldn't say that. It's nothing personal like that. This is, they've made it quite clear this is an official capacity privilege. And GSA says, and it's not to try to second guess or override the assessment of the interests of the United States or the executive branch, because we nod to the incumbent on that. So what exactly is the interest?
That's a good question, and I think you're exactly right that it is not a personal interest. Nixon versus GSA makes it very clear that it's an interest of the executive branch. There might be circumstances where the importance and confidentiality of particular documents is not apparent on their face. You could have documents that in fact are highly sensitive and should not be disclosed, and perhaps the incumbent wouldn't be in a position to recognize that from the face of the documents, and the former might say, oh no, you should be aware these are highly sensitive documents that you ought to consider very closely. So I think that's one reason to give a former president a role. It might be the most important reason, their familiarity with these particular documents. It gives them a way to make sure that the confidentiality interests are at least flagged and taken into account by the incumbent.
That already happens in the, I don't know whether to call it the administrative process here, but the, where the archivist alerts the former president and the incumbent president, and looks like at least gives the former president a little lead time. And so anything like that would have already been communicated between, under the statutory scheme here, and under the regulations would have already been communicated to the incumbent, and I guess when, of course, assume that that was factored in when the incumbent president makes a decision. So when the former president shows up in court, what interest do they, if there is a balancing, what interests are they supposed to put on the table?
So, I think there's a question about the circumstances in which a former president can, in fact, come to court to assert privilege. But let's assume, for current purposes, that 2204E does permit a former president to bring an action in court to challenge, to bring an executive privilege challenge.
And you haven't challenged that thus far in this litigation. So
Correct.
You guys
Correct.
At this stage are accepting the cause of action.
Correct. That is correct with respect to an assertion of executive privilege. We have argued that there is no cause of action for the former president to bring a challenge either to the statutory requirements in 2205-2C or to the to the authority of the committee under the Constitution to bring the valid legislative purpose type arguments. But we do think that there is a cause of action recognized in 2204E to assert executive privilege. And in that, in those sorts of cases, the former president could make these kinds of arguments I alluded to a minute ago, that there are particular confidentiality interests inherent in particular documents. That has not occurred here. Right, there's been no particularized arguments with respect to specific documents. In theory, that could happen. I'm not saying that
the former president is part, whatever this residuum of executive privilege is, also assert that the appropriate thing for courts to do is a balancing test, like Judge Wilkins has raised questions about, and that requires, as part of that analysis, an inquiry into the nature of the legislative interest that may well parallel the 2205 factors.
I agree that if a court concludes that there has been a valid assertion of executive privilege, even by the former, and that balancing is appropriate, that balancing of the qualified privilege would look at some of those same issues with respect to the congressional need. In a situation,
but please finish.
I was going to return, this is a related point, but you had asked some questions earlier about how could it possibly be that the incumbent always wins when we have a statutory scheme that seems to envision that the former president can go to court to bring an executive privilege assertion. There are a couple of arguments there that I think are important to consider. One is that the only statutory provision that expressly seems to contemplate a challenge by the former president in a circumstance where the incumbent has either decided not to invoke privilege or stayed silent is 2208 C2C. But the way that statutory provision works is it actually allows it requires the archivist to disclose if either two things happen. Either the incumbent decides not to assert privilege or the incumbent does nothing. And it says if either of those two things happen, then the former can go to court to assert executive privilege. So it may well be that Congress was contemplating the former would go to court when the incumbent is silent. It doesn't necessarily have to be the case that Congress believed that a former could displace an affirmative determination by the incumbent.
Except
it might all.
There are two different provisions. There are two different clauses in that statute, right? So
Yes.
you're saying both of them mean the incumbent says nothing. But how can that be? Doesn't that render one of them superfluous?
Yes, so there are, right, earlier, Judge Jackson, you had pointed to the second clause, which is, or by a court order in another action in any federal court.
Well, I'm sorry, before you get to that, I'm talking about, it says, if incumbent president determines not to uphold the claim of privilege asserted by the former president, or fails to make the determination under this paragraph.
I see. Yes.
I just understood you to say that both of those somehow encompass only the scenario in which the incumbent president doesn't speak. But isn't the first one the incumbent president saying, I am not going to uphold this claim of privilege, I'm going to waive it? And then the second one is he's silent.
Yes.
If I'm right about that, what did we do with the first one, and how is that consistent with what you just said?
Yes. So the way it's drafted, it may just be that the Congress meant that the former president could go to court in these general circumstances when one of these two things has happened. It may be that Congress envisioned that the former president could go to court even when we're in that first clause, the incumbent has made a decision not to assert privilege. And that determination, I think, would be consistent with the general approach of the PRA, which was to leave executive privilege law where Congress found it. It was neither expanding nor contracting either president's rights to assert executive privilege. And so Congress was recognizing that a former president could go to court and make whatever arguments are available to the former president. It may well be that when you have a situation that the incumbent has made an affirmative decision not to assert, that the former's right to assert executive privilege is either non-existent or quite minimal. But that's something that Congress left to the courts to sort out.
So you're saying that we should not be reading this statutory circumstance as necessarily Congress saying that when both presidents are in court, because the incumbent has said, I'm not going to assert, I'm going to waive, and the former says, I really think we need to insert it here, and so I'm going to court. So both of them are there. You're saying this doesn't speak to or suggest that they have equal, their position should be given equal weight by the court, and that we should just do the same balancing test we would do in another circumstance as though the incumbent never said anything. Is that what you're saying? I say the same thing in different ways, and I'm wasting everybody's time, but is that what you're saying?
No, that is correct, Your Honor. I am saying that when they're both in court, it certainly is not equipoise where you look at both claims of privilege equally. Our view is that the incumbent's position is entitled to significantly greater weight. I was also making a point even a step further to say that the fact that the former can go to court doesn't even necessarily mean that the former can ever win in these circumstances where an incumbent has made an affirmative decision not to assert privilege. It may be that Congress left that as an open question. And as I said before, I think that's something this court believes as an open question as well.
Rather extraordinary. It seems rather extraordinary to go to the trouble twice of talking about these actions that a former president can bring, and for the Supreme Court to have expressly said in terms that the former president has an interest under executive privilege that can be enforced in court. It's said in terms in that case, when it's going to be an entirely empty exercise at the end of the day. But just to make things more interesting, let's bring Article 3 into the picture. That seems to me the exact opposite of how we should assume. We don't assume Congress is creating constitutional problems with the statutes that it writes, and I'm certainly not going to assume the Supreme Court thought it was creating, more opportunities for the judiciary to step into fights between, or to actually do unsettle agreements between the executive branch and Congress. And it seems to me that part of, I'm assuming what was going on, and this is just assumption, is, and I assume you would agree on behalf of your current clients that the executive privilege is really important. It's part of the lifeblood of the executive branch, and the ability to exercise Article 2 powers depends, or to do exercise them wisely, depends on having confidentiality. And if we have a constitutional scheme in which that privilege turns off at 12:01 p.m. January 20th, it won't be a real privilege at all for the preceding 4 years. It won't, because everyone will know the clock is ticking. And, God bless the president who tries to get confidential advice on something imperative on January 19th, because everyone's going to know, well, tomorrow it's coming out. And so my sense is that the Supreme Court was not playing games, and was recognizing that there has to be, the only way we can think to ensure that this executive privilege remains real and doesn't expire, it doesn't have a clock ticking on it the entire time, is to allow for some way of vindicating executive privilege that goes beyond the minute a president becomes a former president. And that's why they talk about it dissipating over time. And if that's what the Supreme Court was conceptualizing there, maybe I'm all wrong, you can tell me that, but if that's sort of what they were concerned about there, I still haven't heard you or anyone address on Mr. Trump's side of the scale here that these requests are coming in pretty quickly on the heels of him having assumed the title of former president. And how does that factor in either into your defer to the executive analysis or the incumbent analysis, or a balancing test?
This administration and the executive branch takes very seriously executive privilege and understands the value of it. And there is no indication that this administration or prior administrations has willy-nilly disclosed privileged information where there's not a basis to do so. Many prior administrations have made determinations in specific circumstances like Watergate or the Iran-Contra affair or 9/11 that the administration is not going to assert what would otherwise be a valid executive privilege because of the circumstances of the case. And that's what's happened here with respect to the January 6th investigation. There are other requests that Congress is making for information from the executive branch right now where privilege is being asserted and the accommodations process is occurring, and this administration is not just handing over information to a supposedly friendly Congress, but the circumstances in this case are extraordinary and involving an attack on the Capitol and the events surrounding it.
Right. That sounds like a much more nuanced analysis than deferring because the decision is not irrational.
Your Honor, I agree that this is a relatively straightforward case. We think the court ought to avoid deciding the really difficult cases where a decision not to assert might be more questionable than the decision here. It's very difficult to figure out in advance what that test would look like, and it's difficult to say with certainty that a former president, in fact, can displace the judgment of an incumbent. And so our view is that that's an issue that ought to be left open for the hard case that follows and doesn't need to be resolved in this, comparatively more straightforward case.
So suppose you have a congressional request for a former president's documents, and the former president says, "I'm not asserting privilege. Congress, you can have all of them." And the incumbent president says, "No, I think that that's not in the best interest of the executive. I assert privilege as to all of the documents," and Congress sues. We apply the same test in that case that you say we should apply in this case?
No, for a couple of reasons. One, the incumbents' views, I think, are entitled to greater weight than the former's. Second, I don't think there's any indication in the PRA or in the executive orders that an incumbent's decision to assert executive privilege ought to be displaced by a former's decision not to assert executive privilege. The way they work is that if the incumbent asserts executive privilege, the document doesn't go out, and Congress could try to make arguments that it has a need for the documents, in which case, if Congress has an ability to bring that action in court, which is an open question in which we contest, but if they are allowed to bring that in court, they would have to satisfy the traditional balancing standard under the Senate Select Committee case.
I was confused by, so in Judge Wilkins' hypothetical, I think Congress gets the documents, right? Or maybe they don't. The incumbent president is saying, I don't think we have an executive privilege issue. I'm going to waive. And the former president says we shouldn't do that. Under the way the statutes and the law works now, absent a court order, those records would go out, right? So there would be no basis for the Congress to be suing.
No, my hypothetical was that Congress wants documents. The former president says you can have them. The incumbent president says, no, I'm invoking privilege.
I see.
And Congress sues, and we have to decide whether Congress gets the documents.
I see.
And so your answer to my question is that ultimately we would do the balancing like Senate Select Committee. We wouldn't just defer to the executive because we'd have to make the call as to whether or not Congress's need for the documents overrides the privilege, right?
That's correct, Your Honor. It's a qualified privilege and can be overcome. And so the court would go through that exercise, assuming there was a basis for the House to go to court.
And we would have a dispute between the branches in that situation.
Correct.
And so it's your position that there is no dispute between the branches here, and that's why we use a different test?
That's correct, Your Honor. With respect to at least these first three tranches of documents, there is no dispute between the branches. There is a dispute between the presidents, the former and the incumbent, but in our view, the incumbent's position is given significantly greater weight than the former's, and therefore the traditional Senate Select Committee test is not appropriate in our view.
My colleagues have any more questions?
No.
No.
Thank you very much. Mr. Clark, am I right in understanding that you're the one that's providing rebuttal?
Yes, Your Honor.
Okay, and we will.
And I'll be very brief because I really only have one point I want to bring up that wasn't raised in our briefs. So
Well, I have to give you some time first. So just for the record, if I can say, I will give you 4 minutes.
all right, I appreciate that, Your Honor. I want to address Judge Jackson's hypothetical regarding the current administrative stay that's in place. And considering the weight of the issue, the former president would need and request some period of time, not a long period of time, to consider and request another administrative stay or injunction pending appeal. Again, we're not talking about a huge period of time, but some period of time if the court were to rule as in the hypothetical that Judge Jackson indicated.
Period of time for what?
Time to file an administrative stay pending appeal from this court in the event of the government winning this appeal, and the administrative stay dissolving. There was a discussion about immediate release. I'm just saying we would request some period of time within which for us to file a motion for a stay, some other motion, and to be able.
If you're requesting time, we don't need to give you time to file a motion for time. Normally, what happens is someone requests time to a window to file a petition for certiorari. In a case like this, where everything is very, very urgent on a very tight timeline, and everyone needs to proceed as fast as possible. I know that's what happened in the Mazars case. They asked for a very concrete period of time to file a certiorari petition or something like that. Is that what you're alluding to?
That's what I'm alluding to. I just want to alert the court that we would.
What kind of time?
I mean, it would probably be
14 days, I think, in that case.
Yeah, that's exactly what we were just nodding at each other about. 14 days seems right to be able to get a cert petition.
We're not there yet. We're not there yet.
It was brought up.
Your first argument is we should win.
That's right. I'd be remiss to not bring it up because it was discussed. That's absolutely. All. But other than that, we're willing to rest on our briefs on this argument.
Do my colleagues have any more questions?
No.
I have one short one. The statute and regulations allow asserting a claim, but not as to segregable portions of the record. So if you've got something that a portion is executive privilege, but there's another portion that could be released, you have to do that. As to the 3 tranches that have been reviewed, and then as within those documents, the documents as to which former President Trump has asserted executive privilege in his official capacity. As to those documents, are you representing to this court that they've been carefully examined to determine not only that they qualify in former President Trump's judgment for executive privilege status, but there is nothing segregable?
Within the document.
Each document, yes.
Yes, that's right, Your Honor. That's my understanding, and I believe that's correct. So.
Okay. If there are no further questions, then the case is submitted. Our thanks to all counsel for your time and careful and thoughtful presentations, very helpful to the court.
Thank you, Your Honor.
This honorable court is now adjourned until Wednesday, December 1st at 9:30 a.m. The law clerks are coming in. Judge, may I open court?
Can you just tell me how to make the people who are not visible
Sure.
Not on my screen.
Sure. If you put your cursor on the box next to mine, it should say Cliff Cislak on it.
Yeah.
When you do that, you should see
Yep.
a
Got
square.
it. Excellent.
Okay,
Perfect. Thank you.
You're welcome, Judge. May I open court?
Please.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5280, National Association of Postal Supervisors, Appellants versus United States Postal Service and United Postmasters and Managers of America. Ms. Graber for the appellant, Mr. Jenda for the appellees.
Good morning. When you're ready, Ms. Graber, you may proceed.
Thank you, Your Honor, and may it please the court. The Postal Service now concedes on page 17 of its brief, quote, NAPS may seek non-statutory review. That issue is no longer in dispute. The Postal Service then asserts that the statutory provisions at issue here are not limits on the Postal Service's authority. I'd like to spend my time today explaining why the statutory standards regarding supervisory differentials, compensation comparability with the private sector, and the rights of the postal supervisory and managerial personnel to be represented by NAPS are clear and mandatory, and how the Postal Service has violated those mandates. And our dispute with the Postal Service has two parts. The first concerns the 2016 to 2019 field pay package, which violates statutory mandates that the Postal Service pay a supervisory differential and that it establish compensation that is comparable with the private sector. Second, I will turn to why the statute permits NAPS to represent all supervisory and managerial employees, including postmasters, and why the Postal Reorganization Act does not distinguish between any category of supervisory and managerial personnel based on their reporting structure or any other category. Regarding the substance of the 2016 to 2019 pay plan, in the 1979 NAPS decision, this court held that the very same provisions at issue here regarding the supervisory differential and pay comparability establish standards that are clear and mandatory and reviewable under non-statutory review. This court held that the Postal Service was required to implement some supervisory differential and consider and fulfill in good faith pay comparability. The complaint here plausibly alleges that the Postal Service has failed to meet these requirements. As we point out on page 13 of our reply brief, this court already interpreted the Postal Reorganization Act to require that, quote, all, end quote, supervisory and other managerial personnel must receive some differential in compensation compared to the clerks and the carriers that they actually supervise.
But isn't there a differential? The problem is just simply that the employees, the clerk or other employees who are the supervisees can earn overtime that supervisors can't?
No, Your Honor. As we explain at paragraphs 38 and 39 of our complaint, for thousands of supervisors, there is actually no differential at all, even before you take overtime into account. With regards to base pay, these supervisors earn less than the employees in the clerk or carrier grade that they supervise. And the reason is that the Postal Service has benchmarked a very low supervisory differential against a lower paid grade for the clerk employees, and thousands of supervisors represent higher paid carriers. So for these employees, even before you get into overtime, there is simply no supervisory differential. And this court was clear in the 1979 opinion that all supervisors must earn some differential compared to the employees that they actually supervise, not again just compared to one of the lower paid clerks or carrier grades in the system.
Do you think that our opinion held that every single supervisor has to have a differential or else there's a violation of the statute?
That is the import of the court's remand to the Postal Service when it determined that it could not know from the affidavit that the Postal Service had filed whether, quote, whether all supervisory and other managerial personnel actually receive some kind of differential. It's also clear from the statute, which does not say some supervisory and managerial personnel must earn the differential. So yes, I do think that all supervisory and managerial personnel must earn some differential.
But I guess the question is it when there's a comparison under the statute between supervisor and other managerial personnel and those they supervise, can that comparison be made in gross, or does it have to be made for every single office or every single supervisor? And I take it that the Postal Service is saying, well, it can be made in gross.
Again, I think turning to the court's 1979 opinion, what it said is that it couldn't tell, and it had to remand to the Postal Service. It could not tell whether all supervisory and other managerial personnel actually received some kind of differential. And it made clear that that differential should be pegged to the employees and the clerk and the carrier grades that the supervisors actually supervised. So it seems clear from that opinion and from the language of the statute that yes, it does have to be all supervisory and managerial personnel, not just in gross. And I think it's an issue that can also be, considered on the district court on remand as to which supervisory personnel, as to how the supervisory differential has actually played out.
I had a question, Ms. Graber, about one of the other issues about whether the association was unlawfully denied participation in setting the pay for the postmasters. And I guess in part, this is a question that I think part of which also applies to the headquarters and area employees. If the Postal Service has not presented a pay plan that covers the postmasters, does NAPS have any dog in that fight? I mean, they just haven't presented a plan, have they?
Your Honor, whether or not the Postal Service has presented a plan is not a fact pled in the complaint, but the consultation rights apply more broadly than just to individual pay plans. I can represent that the Postal Service did present a plan for the postmasters, and we would be able to add that to our complaint if necessary on remand. But if you look at the statute, section 1004C requires monthly consultations to implement the provisions of the statute. And furthermore, consultation is required to implement for the implementation of any given pay plan, not just for the negotiation of the pay plan.
So I had a question about this statutory provision, the section 1004B, which the Postal Service argues, I gather, Mr. Janda can correct me if I'm wrong, but I gather that they're saying at least it's susceptible of being read to set up three mutually exclusive categories. Your argument is no. I take it that you view them as nested categories. There's a supervisory organization that represents a majority of supervisors, or an organization other than an organization representing supervisors that represents 20%, at least 20% of postmasters, or a managerial organization other than a supervisor or postmaster organization representing a substantial percentage of managerial employees. When I read that, I actually don't see it as setting up three mutually exclusive categories. I see it as setting up nested categories. But my question is, why? It's really hard to imagine what this is about in the real world and why it would be written this way. That I take it to be saying postmasters can be part of a supervisory organization, managerial employees can be part of a supervisory organization. If it's a standalone postmasters organization, the representation only triggers if it's at least 20%. Why would they have these different participation thresholds, and why would they contemplate organizations that have amalgams of different types of employees to some extent, but then not in other ways? I'm having a hard time understanding
I do want to answer your question. I'm also mindful of my time, and I want
We'll
to
give you more time as needed. As long as the panel has questions, we'll give you additional time.
Okay, thank you, Your Honor. So some of the reason I think for the strangeness of the structure of the statute, as you've identified, is that the way the postmasters organizations were sort of shoehorned into the statute in 2003 was somewhat peculiar. But we agree with Your Honor that the nested structure is the reading of the statute that conforms to the statutory text. And what it does is that it gives all supervisory and managerial employees the rights to join together in one umbrella organization if they choose. And if they don't, then they can form more group-specific organizations, as you've identified. The fact of the matter is that there has never been a managerial organization. Employees have been satisfied with the representation that they've chosen through the National Association for Postal Supervisors and through the Postmasters organization. And that is permitted through the statutory structure that you've identified. What is very clear from that statutory structure is that there is no distinction made between employees who are headquarters and area employees and employees who operate in field positions. That's a distinction that the Postal Service has just read into the statute. And the Postal Service's position here is a fairly extreme one. What it's asking the court to do is give it the unreviewable total discretion to decide which employees can choose to be represented by NAPS and which cannot. And in doing so, it would give itself the power to not only deny NAPS arbitrarily, deny employees arbitrarily the right to be represented by the organization of their choice, but also really to destroy the supervisor's organization. And I want to emphasize that this is not a hypothetical. After a briefing here was completed, the Postal Service announced a reorganization in which it realigned thousands of supervisory and managerial personnel who were in field positions into headquarters positions, and then initially took the position that NAPS could no longer represent those employees. What it is really saying here is that it has the power to totally destroy the supervisor's organization, and in doing so, it could totally eviscerate the entire statutory scheme, and that cannot be the law. I see that I am over time. Oh.
I have a series of questions, I guess, about related to this point. The statute doesn't define managerial employees, right?
Correct, Your Honor.
So how do we know what the difference is between a supervisor and a managerial employee?
As Judge Pillard identified, for the purposes of the question before the court, it doesn't actually matter because NAPS does have the power to represent all supervisory and managerial employees as the umbrella organization. So the distinction for our purposes today is one without a difference.
Well, I guess what I'm trying to get at is the statute speaks in terms of, in its definitions, under 1004I 2, it says members of the supervisor's organization means employees of the Postal Service who are recognized under an agreement between the Postal Service and the supervisor's organization as represented by such organization. I never saw in your complaint an allegation of who the Postal Service has agreed can be that your organization, your client can represent. I saw an allegation that the Postal Service said that they believed that you could not represent postmasters, but there's no allegation as to exactly who the Postal Service has agreed you can represent. Did I miss that?
No, Your Honor. There has not been a present agreement between the Postal Service and NAPS since 1981, when the previous agreement expired. But what is true is that under 39 U.S.C. 1205, the Postal Service has been deducting the dues of the supervisory and managerial personnel who have chosen to join NAPS from their paychecks. But there is not a present agreement between NAPS and the Postal Service. But if you allow the Postal Service to take the provision that you identified in 104I2, to give it the power to agree to anybody or nobody to be represented by NAPS, it's taking this narrow definitional provision and allowing it to totally override the entire statute. And that simply can't be right. This court has already found that whether or not the Postal Service has engaged in appropriate consultation is reviewable. And to allow the Postal Service a backdoor out of that consultation process and out of reviewability for avoiding the consultation process is entirely inconsistent with the statutory scheme and with this court's precedent.
What do you think I'm sorry, go ahead, Rob.
Go ahead.
No, I just want to make sure I understand. What do you think the issue is? I'm trying to make sure I understand your position. You're lumping managers and supervisors in one category, and what are you saying about postmasters? Are you saying they are managers and supervisors or not?
Postmasters are a subset of supervisory and managerial personnel under the statute, and therefore can choose to be represented by the supervisory organization as for that.
Just to be nitpicky about that, as I understand it, they are a subset of managerial and that some of them are a subset of supervisory. If you're a postmaster that doesn't have employees that you supervise, I had the impression that that was the case in some places.
That's correct, Your Honor.
Okay. So
and then your claim is there's a separate issue with respect to the headquarters and area employees is a different issue. You're saying that the Postal Service simply excludes persons who are working in those areas, right?
Mostly. It doesn't take a fully consistent position. It actually does recognize.
Right, so you're saying to the extent that they claim that those persons cannot be covered by the benefits of the statute, they're wrong, wherever it's happened.
Yes, Your Honor.
That's not the managerial supervisor postmaster issue. They're different issues.
The issue of the postmasters versus the headquarters and managerial employees are distinct. I do want to clarify, headquarters and area employees. I do want to clarify that headquarters and area employees are supervisory and managerial employees under the statute, as are postmasters.
Well, that the employees about which you're concerned are the supervisory or managerial employees at headquarters or in the areas, because there are employees at headquarters, presumably, who aren't managers or supervisors.
Presumably, there are employees at headquarters who are members of the senior executive service, correct? But
or who are under collective bargaining agreements.
That might be true, Your Honor. I'm not 100% positive about that. But yes, we are concerned about the...
That's a different issue, is all I'm trying to make sure I understand. You're saying they are claiming they can exclude anyone who's in a place called headquarters or area because that's where they are, no matter what their job is, right?
Correct, Your Honor.
All right.
So just as far as trying to figure out how this statute works, 1004H talks specifically about postmasters and postmasters organizations. And then when I look at 1004B and setting up the kind of three different ways that an organization can be recognized, I see that Congress use, when they talk about a managerial organization, they call it other than an organization representing supervisors or postmasters. Congress used an or, not an and. So I guess, unlike Judge Pillard, my inclination is to see these as three mutually distinct categories and not overlapping ones. Given that postmasters organizations seem to have kind of their own set of rules, and I don't really understand how those clauses in the parentheticals are doing any work unless you view these as three mutually exclusive groups. Tell me what's wrong with the way I'm seeing this.
So under the nested interpretation that we think is the more persuasive or the really only textual interpretation of the statute, those parenthetical clauses are still doing work because they say that the postmaster's organization or the managerial organization can form groups that do exclude, for the postmasters, that exclude supervisors, and for the managerial organization that exclude supervisors and postmasters. So then that does continue to give those clauses effect while still allowing employees to band together in the largest group available to them, the umbrella organization, which is the supervisory organization.
Well, suppose I believe that, well, maybe you do have an argument that that is a plausible reading of the statute, but I believe that the statute is ambiguous. If the statute's ambiguous, then how do we exercise non-statutory review when we only do so when the Postal Service is acting ultra vires? And we said in the earlier 1979 case that where something was ambiguous, it falls outside of ultra vires review.
So this court in aid association so first of all, I have a couple of points I want to make about that. First of all, this court in aid association for Lutherans made clear that the scope of review contemplated by the 1979 decision is in all respects consistent with Chevron. So even if you did find ambiguity in the statute, the Postal Service's interpretation of the statute must still be within the reasonable range of interpretations that Chevron allows. And the Postal Service's decision, particularly to exclude headquarters and area employees from being allowed to be represented by NAPS, is not within the reasonable range of interpretations because it reads something into the statute that simply isn't there. Furthermore, if you were to find the statute ambiguous in this way and allow the Postal Service to create these three very distinct organizations, then the postal managers would have no representation because there is no managerial organization and there never has been one as far as I'm aware.
But that's not a problem with the statute. That's just a problem with those employees needing to form an organization, and they can go out and do so.
But I do think that it sort of casts some skepticism on the Postal Service's position that Congress would have wanted there to be three separate organizations because it perceived there to be some inherent conflict between these groups. That's not how the statute or the Postal Service has been put into operation for the last 50 years. And
is there a conflict between the groups? I mean, what about the potential for conflict between managerial employees and their supervisors, for example?
That's not an issue that has any factual support behind it that the Postal Service has been able to identify. It's something that perhaps could be explored on remand if necessary. But the Postal Service can't simply assert it and declare that it must be true, particularly when the managers have been a part of NAPS for such a long time.
All right. Do my colleagues have any further questions?
I guess my final question is, I'm trying to get an understanding. Is there anything in your complaint or in the record that we can recognize that indicates that the Postal Service has acknowledged that NAPS can represent managerial employees?
So there was a concession by the Postal Service that NAPS can represent some of the headquarters and area employees. Whether or not the Postal Service considers those employees to be managerial employees, I think the complaint is not clear. So I think that's the best answer I can give to your question, given the posture of the case.
All right. Thank you, Ms. Graber. We'll give you a limited time for rebuttal. And in the meantime, we'll hear from Mr. Janda for the Postal Service.
Thank you, Your Honor, and may it please the court. Good morning. Sean Janda for the United States Postal Service. I'd like to start, if I can, by just taking a step back for a moment. And I think it's important to understand the context here, which is that when Congress created the Postal Service as an independent agency in 1970, it decided that the provisions of the APA generally should not apply to the Postal Service's decision-making. And that was a decision that is consistent with Congress's broader determinations that the Postal Service has to have the freedom to control its costs and to manage itself efficiently, and that the Postal Service, and not the courts, and certainly not the plaintiffs here, are in the best position to weigh the many competing factors that are required for the Postal Service to try to achieve its many conflicting statutory goals of providing high quality and effective service, of controlling costs, of doing all of that while charging reasonable and just rates, and managing. Sorry, go ahead, Your Honor.
I'm sorry, I didn't mean to interrupt you. Go ahead and finish your sentence.
And just that that's sort of a multidimensional balancing act that the Postal Service, Congress has recognized, is in the best position to achieve.
So we have recognized some non-statutory review of the Postal Service and under this provision. And the district court suggested that it wasn't available here because the association had an option to request a second non-binding fact-finding panel. But you're not pressing that point on appeal.
We are not, Governor. So with respect to the pay package claims, which I think is what that mostly goes to, our claim is twofold. Our argument is twofold. One is that these provisions that NAPS relies on simply aren't limitations on the Postal Service's statutory authority. And so any claim under those provisions would not be cognizable in non-statutory review. And then second is that at the absolute most, and maybe this is what the 1979 NAPS decision recognizes, those provisions may require the Postal Service to consider those goals in good faith. And here the complaint makes clear that the Postal Service considered the goals in good faith. There's an explicit supervisory differential adjustment in the challenged pay package of 5%. And the comparability requirement, I think the complaint recognizes, not only does the Postal Service evaluate that internally, but in this case, the Postal Service hired an outside expert to conduct a survey to look at the comparability provision. And that's sort of above and beyond, I think, what this court and the Supreme Court has said that agencies have to do even when faced with the prospect of APA review. And it certainly suffices for the sort of low bar, good faith consideration of the requirement that is all that NAPS can get review of in this case.
You assert in your brief that the association didn't allege that the Postal Service failed to fulfill any of its obligations with respect to consultation and fact-finding, but as I read their complaint, they are alleging that, and that at a minimum, there, as you say, there's this sort of procedural requirement that the Postal Service at least consider in good faith the views of NAPS. And they do allege, and as I see in paragraphs 53 and 54 at page 17 of the appendix, that there was a failure in that regard. And what's your response to that?
So although NAPS does make those allegations in the complaint, there's not plausible facts in the complaint that could support those allegations. And so with respect to the comparability requirement, the survey itself is more than enough to satisfy the requirement to consider comparability in good faith. And even beyond that, the Postal Service has an in-house compensation and benefits department that tracks and evaluates the comparability requirement in those trends. And I don't think there's any sort of plausible facts to suggest that the Postal Service didn't consider that either when issuing the pay package or when going through the consultation and administrative mediation process. And to the extent that NAPS's argument is that a bare allegation of failure to consider is enough to survive a motion to dismiss in this context and to get into sort of evaluating the administrative record and doing whatever the next steps that they think would be appropriate in this litigation are, that just underscores how much NAPS's view of how this non-statutory review process ought to go would undermine Congress's determination that judicial review generally isn't appropriate.
But let me just ask, I mean, I don't think this is a separate count, but the association alleges that the Postal Service has broadly failed to engage with NAPS and failed to provide information required by the statute. They haven't furnished details of their decision to implement their pay programs. They haven't provided information on which they're based, but perhaps more sort of significantly from their perspective that when the Postal Service has rejected their recommendations, the Postal Service has an obligation to provide reasons to NAPS. And my understanding is that you don't dispute that that hasn't taken place, to provide an explanation to the association if it rejects any recommendations. Am I wrong? Or do you think the recommendations are illegitimate because they purport to represent members they can't represent? Or what's your view of why those explanation obligations have been met?
So I think initially that's not an issue presented in this appeal. NAPS hasn't briefed that issue, hasn't pressed any argument in this appeal on that issue. That being said, to the extent that the Postal Service is required to provide reasons, I can tell you it's not alleged in the complaint, but the Postal Service, when it issued the final pay package, provided, I think, an 8-page letter that goes through the fact-finding panel's recommendations, explains which ones is accepting, which ones is rejecting, and provides written reasons for each of those. And so, again, it's not alleged in the complaint, but the Postal Service did provide that written sort of decision explaining what it was and wasn't accepting from the fact-finding panel. And so, to the extent that is a statutory requirement, the Postal Service certainly fulfilled it in this case.
Is that letter before us? Can we consider it? Was it incorporated into the complaint?
So, Your Honor, our argument might well be that had NAPS pressed that claim or pressed that argument, that the letter is appropriately incorporated into the complaint and could be considered on a motion to dismiss. We haven't put it in the record. It wasn't in the record of the district court. It's not in the record before this court because NAPS hasn't pressed that as an independent claim.
I intended to ask appellant's counsel that, and I forgot, but I don't see a separate count in the complaint saying that the Postal Service violated the statute by giving an inadequate explanation. And I also didn't see any requested relief in the complaint of requesting a remand or anything relating to requiring the Postal Service to provide more robust explanation or rejecting the recommendations. So that's why you're saying that the issue isn't before us.
That's correct, Your Honor. I think neither in the complaint nor certainly pressed in NAPS's brief in this appeal. And so, even if there are portions of the complaint that gesture in that direction, it certainly hasn't coalesced into an argument for relief in this appeal.
Counsel, my understanding is fairly straightforward that the obligation with respect to pay differential is as to supervisors and the employees they supervise, and you haven't satisfied that. You haven't shown that you satisfied that requirement. Maybe in some cases you have, in other cases you clearly have not. And so there's certainly remand there. Am I wrong?
Yes, sir.
If that is my interpretation of the statute, then it has to go back on that, right?
So I cannot tell you that every supervisor earns more in base pay than every employee they supervise. And if that's your interpretation of the statute, then this ought to go back. But that's just not.
It really is not as onerous as you're suggesting, unless the Postal Service is more screwy than I would have imagined, because most employers put supervisors in categories as to their employees. So you're not talking about Joe Blow and the two people he supervises. That's not what the inquiry would be. It would be whether certain groups of supervisors are making more than the groups of employees that they're supervising. It's not an onerous requirement. You either did it or you didn't. My understanding of the record, just so you can know what my concerns are, is that you certainly have not shown that. It may be the case in some instances, but you have not satisfied that requirement, if I am right that that is the requirement. So that's one thing, right?
So I think that depends on exactly how your Honor understands the requirement. So what the Postal Service did in this case, and what it's done, my understanding is for a long time, is it chunked up supervisors into different groups. And for each group, picked a benchmark supervisee employee, generally the sort of most populous supervisee employee, and then added the supervisor differential to that employee's base salary to create the minimum salary for the supervisor. And there may be some supervisees in particular circumstances who earn more in base pay for whatever reason than their supervisor. But I think the NAPS's argument is that that's not okay, that every supervisee must make less than his supervisor. And that's,
it does seem like if the statute says that employees and the employee, there should be a differential between supervisory employees and the employees they supervise, that the methodology that you describe is fine up until the choice of some median or, you know, plurality of the supervisees. Why wouldn't the necessary benchmark be the highest paid of the supervisees, since the point is there has to be a pay differential between the supervisory employees and the employees they supervise?
So I think 1004A is the relevant statutory provision, Your Honor. And all that says is that, I mean, number one, it's a policy goal, which
right.
But beyond that, all it says is that it shall be the policy of the Postal Service to provide adequate and reasonable differentials in rates of pay between employees in the clerk and carrier grades and supervisory and other managerial personnel. And so the statute speaks in gross terms between the two categories. The Postal Service, in this case, it broke it down even further by looking at, I think, 4 different groups. That's my understanding. I don't want to say that is definitely correct, but a number of different groups of supervisors and sort of their supervisees. And that, I think, is more than enough to satisfy the statutory requirement.
But that policy argument, you're not really pushing that, are you? There's another part of the statute that makes it clear. It says shall.
Actually, I don't think.
Go ahead.
I'm sorry. I don't think that's correct, Your Honor. So I'm not sure if you're looking at. Also, I'm not sure which part of the statute you're looking at. 39 USC 1001C says the Postal Service shall achieve and maintain compensation that's comparable to compensation. That again, it is a policy goal. The title,
with or without, it doesn't have a policy.
So the
mandatory language.
So the title of Section 101 is Postal Policy, and I think it's obvious from the context.
Then it says what postal policy will be. The Postal Service shall achieve and maintain comparable compensation, et cetera. Doesn't say the Postal Service will strive to reach a policy of. It says they shall.
I think in the context of Section 101, what if you look at it, it's I believe 7 different sort of broad policy goals that the service should be operated as a basic and fundamental service, that the Postal Service shall provide a maximum degree of effective and regular postal service to rural areas. And I think in that context, it is clear that these are broad goals that the Postal Service is required.
Is that the way we initially construed the statute, to say, you know, do your best? I didn't think that was our initial interpretation of the statute many years ago.
So I think this court's interpretation of the statute is that the Postal Service has to give sort of good faith consideration to these goals, and has to arrive at a result that it thinks in good faith appropriately balances the goals. And again, here, I don't think there's any question that the Postal Service did that. There's an explicit supervisory differential adjustment in the package. And on the comparability piece, the Postal Service went so far as to hire an outside expert to look at comparability of pay between the Postal Service and the private sector.
Yeah, but it could, I mean, I think their allegation on comparability is and I thought our court had spoken to that as well. There is an obligation to attend to this. And I thought their claim is, which is not frivolous, that it was bogus. There wasn't any serious effort to look at the private sector and reach comparability determinations. We've certainly said there is such an obligation under the statute. You're right, where you end up, if you've done it in good faith, you certainly have a whole lot of room to run, but you certainly don't have a whole lot of room to just do it willy-nilly and be subject to a claim that you didn't do this seriously. You haven't seriously looked at the private sector to make the determination the statute requires.
So I have 2 responses to that, Your Honor. The first is that I think there's just no question in this case that the Postal Service looked at these obligations in good faith. I mean, they hired an outside expert on comparability to evaluate, to do an independent study to evaluate the comparability of the 8, my understanding is, most populous NAPS represented positions. And that goes well above and beyond what this court or the Supreme Court has held is required, even under APA review. And so that, I think, absolutely satisfies whatever good faith requirement there is. And to the extent that even in light of that study or in light of the explicit supervisory differential adjustment, NAPS's conclusory allegations that the Postal Service didn't do it in good faith could be enough to get them over a motion to dismiss. That just undermines Congress's judgment, which I think this court sort of articulated very, very clearly in the 1979 NAPS case, that this isn't something that is generally subject to judicial review.
So I appreciate that there was some effort made, and the allegations before us are that the assessment was very, very partial because they looked at 8 of approximately 1,000 positions. And I take it your pushback on that as well. There were 8 significant positions for purposes of NAPS. But the other thing they claim is that the Postal Service substantively just does not meet this requirement because they're not giving annual raises. So they're just in a really structural and persistent way tying into a approach to pay that just is not comparable. And that the statute requires that the Postal Service shall achieve and maintain compensation that's comparable to the rates and types of compensation paid in the private sector. So how is it comparable, and how can it be maintained as comparable if there's not even increases, periodic increases that are standard in the private sector?
So I think, again, sort of quibbling around the edges of the specific portions of how pay is calculated, and whether that's bonuses, whether it's annual raises, whether it's locality pay, none of that is in the statute. The statute doesn't require any specific parity between the Postal Service and the private sector, and it doesn't require any sort of particular features of the pay package to achieve that goal. And so to the extent that the Postal Service sort of evaluated comparability and made a good faith determination, which is clear from the record they did in this case, that the package that they were issuing sort of was a good faith effort to satisfy the comparability requirement.
I mean, you refer to good faith, and I don't have any reason to question, and as a subjective matter, any good faith on the part of the Postal Service, but they didn't need to say you need cost of living increases, you need regional adjustments for where it's really expensive to live, or because they use a shorthand comparable to the private sector. So why doesn't, if there's no explanation of, oh, we do that in this different way in our pay structure, then how can the association employees, members, be confident that it actually was even sought to be comparable?
So I think there is, of course, a extensive consultation and administrative mediation process that the parties engaged in this case. And that's the process where the Postal Service can provide reasons to NAPS. It did provide reasons to NAPS in this case.
But even the fact finders there thought that the Postal Service had not fulfilled its obligations. I'm not sure that supports you.
So that was the finding of the mediation panel, but the Postal Service, even after that finding, provided a letter to NAPS explaining how it had considered the requirement and why it believed it met the requirement. Mm-hmm. And I think, again, this all goes back to the fact that Congress has determined that the Postal Service is in the best position to weigh these competing factors.
Right, if it's weighing them at all and giving an explanation. I know we've kept you up here a long time. I had really wanted to hear your view, though, on the categories that the association claims were just completely categorically overlooked. What is the position of the Postal Service on the headquarters and area employees being excluded from the pay package, and what is the position on the statute that allows postmasters to be represented by a supervisory organization?
Yes, Your Honor. So starting with the headquarters and area employees, the Postal Service's view is that most headquarters and area employees are not eligible for representation by NAPS as they're non-supervisors. That being said, even the complaint recognizes that the Postal Service has recognized that some area and headquarters employees are supervisors, are eligible for representation, and has excluded those employees from the 2016-19 area and headquarters pay package. And my understanding is included those employees in the recently issued pay package that was developed after consultation with NAPS. And so the Postal Service isn't drawing any absolute distinction between area and headquarters employees and field employees in terms of eligibility for representation. And again, I think it's under sort of non-statutory review. It's NAPS's burden to show that the Postal Service has plainly violated the statute. And there's just nothing in the complaint that explains sort of which employees NAPS thinks have been improperly excluded from representation.
I thought it was pretty clear. I thought it was pretty clear. They represent supervisory, postmaster, managerial employees. And as you just said, the Postal Service excluded them from the past pay package to the extent that they were area or headquarters employees, even if they were, or maybe because they were represented by NAPS. So there's like a carve out there saying we are generally looking at area and headquarters employees, but if you happen to be NAPS representative, we're not going to include you. Is that right? And I'm trying to make sense of that.
So my understanding, Your Honor, is that there are sort of two separate pay packages. So one is for area and headquarters employees that carves out those employees who are represented by NAPS, and the other is for field employees and those area and headquarters employees who the Postal Service recognizes as represented by NAPS. So those are the two pay packages, and NAPS is consulted on the pay package for field employees and for area and headquarters employees who are represented by NAPS. And so the distinction that the Postal Service is drawing is between NAPS represented employees and non-NAPS represented employees, or employees who the Postal Service doesn't think are validly represented by NAPS. And I think you can look through the complaint. There's just nothing in the complaint that says,
so
here
run
are
that by me. I'm sorry, run that by me again. So there are two pay packages. One is area and headquarters employees, and the other is field employees.
Correct.
And those pay packages generally include supervisory and non-supervisory employees, generally, but they exclude supervisory managerial employees represented by NAPS?
No, Your Honor. I'm sorry if that is what I said. So my understanding is there are two pay packages. One is area and headquarters executive and administrative service employees, but not those that the Postal Service recognizes as represented by NAPS, just the other ones.
And when you say EAS, that means typically supervisory managerial.
I think not necessarily, Your Honor. There are,
but a bunch of them are.
Some of them are, yes.
Okay.
My understanding is many fewer in headquarters. There are many more, whether it's sort of SES or whether it's professional or administrative employees rather than supervisors and managers. And then the other pay package, and this is the one that was issued, sort of the challenged one, and then also the one was recently issued that we filed a letter about. That pay package covers all field EAS employees and the headquarters and area EAS employees who the Postal Service believes are validly represented by NAPS. And NAPS has been consulted on that package. I don't think there's any question about that. And so the
second package, just so I have it right, is the field employees and the area and headquarters employees that NAPS represents?
That is correct, Your Honor. That is my understanding. And I think at the end of the day, the sort of fundamental point is that just looking at the face of the complaint, NAPS concedes that the Postal Service has excluded from the unconsulted package those employees who the Postal Service believes are represented by NAPS. And there's just no factual allegations in the complaint that could support the notion that the Postal Service has plainly sort of violated the statute in drawing the distinction that it drew.
So it bunches all the NAPS employees, whether they're area and headquarters or field, all the NAPS represented employees into the field package, just as a way of saying everyone we're dealing with the NAPS is going to be in the field package, even if they're not field employees.
That is my understanding, Your Honor.
All right.
And the problem is we don't know who I'm listening to you carefully. We don't know, you say who the Postal Service determines the union represents. But in that answer, I think what you're saying is you're making some determinations with regard to certain supervisors and managerial employees that you will not recognize, or you say the union cannot represent. It's totally unclear. Are you conceding now? Let me see if I can clear it up this way. Are you conceding that the union can represent supervisory and managerial employees in these offices, in headquarters and area offices? There's no doubt in your mind they can. They represent them. You have to consult with them. You agree?
So, Your Honor, my understanding is
take my question. I want you to answer my question. Are you conceding to the court that yes, the union can represent managerial and supervisory employees in any area and headquarter situation? We are not objecting to that, and we have an obligation to consult with them if they do represent those employees. We cannot exclude from representation employees who are supervisors or managers merely because they are in area and headquarter positions, right? Yes or no? Are you conceding that or not?
So I think there were two different questions there.
No, there's not. There really is not. Are you I'm going to try and make it one question because I really am curious what your answer is. Are you conceding that the union may represent supervisors and managers in area and headquarters positions, and that the Postal Service has an obligation to consult with the union with respect to those employees?
Our understanding of the statute is that employees may not be excluded from valid representation merely because they are headquarters or area employees.
Do you concede that supervisors and managers in headquarters and areas positions can be represented by the union, and you have an obligation to consult with the union with respect to those employees? You concede that or not?
I don't think I can broadly concede that, Your Honor. I can concede that because I think supervisory and managerial employees is a very broad category. I think it's not necessarily clear from the statute that NAPS is even entitled to represent managerial employees as distinct from supervisory employees. And my understanding is that the Postal Service has sort of recognized a list of positions at headquarters and area employees who NAPS validly represents. It has excluded those.
Yeah, well, that's self-serving. Who validly represents. That's the whole point. You either everywhere else, if there's supervisors and managers, they're not in headquarters, they're not in area. You're conceding, you're not doubting that the union may represent those employees and that you must consult with respect to them, right? Everywhere else, if you're a supervisor or a manager, the union can represent those employees and you must consult, right?
I do not know that is correct, Your Honor. My understanding.
So just to focus it, I think on you were resisting managerial, and I think that gets back to the three different categories.
Correct.
And whether they're mutually exclusive or nested. So let's just keep it simple and say supervisory employees that are headquarters and area employees. Those are people that NAPS is entitled to represent, and with respect to which the Postal Service therefore has an obligation to inform, discuss, consult.
So
you agree with that?
We have not made any argument that supervisory employees at area and headquarters are not validly represented by NAPS.
No, could you just, no.
But you also,
would be easier for, no, Judge Phillip, answer Judge Phillip's question. Do you agree with what she just said? Yes or no? Because then that takes a big issue off the table for me, because if whoever is writing this, that's pretty easy. That ends the big question. We agree or not?
I don't know that I can broadly agree to that statement. What I can say is that there is not a single thing in the complaint that makes out an allegation that there is some group of supervisory employees that are at area or headquarters that are not being consulted or who are not being covered by the consulted pay package.
I think there is an allegation.
Certainly is an allegation.
To that regard, they say that the pay package, the 2016-29 pay package, concerned only association members designated as field employees, excluding 7,500 of its members that the Postal Service treats as headquarters or area employees. And so they're saying we have a big chunk of membership that, you know, I recognize there's a separate legal position that the Postal Service is taking with respect to managers, but that includes managers and supervisors that we represent that are headquarters and area employees and everything else the Postal Service says. And you're not including them and you're not recognizing us.
And I thought the fight was over. I thought your position somewhere along the line was that you were trying to distinguish between supervisors and managers on the one hand and professional and technical on the other. I thought that was the fight, but maybe I've just completely missed this case. That's why I'm trying to get you to either concede or not that the fact that you're a supervisor and manager and you're in an area or headquarters position, you still can be represented by the union, and the Postal Service must consult.
So I don't think I have the ability to broadly concede that. But
I mean, broadly, I don't want you to do it broadly or narrowly. I just want you to concede that sentence. That's all.
I do not believe I can concede that.
And why is that wrong?
So I think there's two things. One is that this court doesn't need to get into
No,
that
counsel, please, indulge me. Okay, indulge me. Forget whether I have the authority to decide something. I'm trying to understand the case. So I don't want you to tell me what I can and cannot decide. Just tell me whether you agree that the union can represent area supervisory and managerial employees, and the Postal Service is obliged to consult with respect to those employees if the union does represent them.
So I agree that as the mere fact of being an area or headquarters employee does not exclude someone from valid representation. I think the fight in this case is over the exact scope of that valid representation with respect to area and headquarters employees. My understanding is that the Postal Service has recognized a set of area and headquarters supervisors as validly represented by NAPS and has consulted with NAPS with respect to those employees. And there's
in what context, with respect to what pay package? With respect to the field pay package?
So my understanding, Your Honor, is that those employees were carved out of the 2016-19 area headquarters package and were included in the recently issued 2021 sort of, I don't know that it's called the field pay package, but it's the pay package that includes all employees that the Postal Service recognizes as represented by NAPS.
Okay.
And so,
okay. But before your 28J letter, we had nothing showing that they were included in anything.
Correct, Your Honor. But I think the complaint admits they were excluded from.
Right. And so your view is if they're excluded, then there's no, we'll just put these people by the side of the road, and then we won't violate our consultation obligations because we're just not giving them a package.
So I don't think that's what NAPS's claim is getting at. I think NAPS's claim is focused on the issuance of the 2016-19 area and headquarters pay package. And my understanding, I mean, if I could just back up for a second.
And your view is, so your threshold view is they don't have a dog in that fight because that doesn't even cover any of their people?
It
doesn't actually affect the terms and conditions of their employment, because even though they may work in headquarters or work in what for other administrative purposes USPS denominates area, they actually are treated for purposes of a pay package as not there. And therefore they don't even have standing to kind of address the headquarters and area package. Is that right?
So I don't think it's an issue of standing, Your Honor.
Or, I mean that loosely. I mean that they don't have, they're not included, and so they're not harmed in your view?
Yes, sort of. So if I could just back up for a second. This is my understanding of NAPS's claim. NAPS says you issued this 2016-19 area and headquarters pay package for area and headquarters employees. You excluded from that pay package certain employees that you recognize are validly represented by NAPS. And that is true. But I think what NAPS's claim is that they believe they represent additional area and headquarters employees who were not excluded from the pay package, and that they ought to have been consulted with respect to those employees. And that is how I understand NAPS's claim.
And when you say that, the additional employees, you're talking about managerial employees, and this is because of the tripartite reading under 1004 I2 or something?
So I don't have the information on sort of the exact employees who were excluded and who were included and who NAPS believes they represent. And I think fundamentally that is a problem with the complaint. The complaint doesn't include, it could include a paragraph that says, here are the 5 job titles of employees at area and headquarters that we think we represent. Here are their job duties. Here's why we validly represent them, and we should have been consulted with respect to them. The complaint doesn't do any of that. All it says is that we disagree with who you excluded, but that's not enough to plausibly allege a plain violation of the statute because there's just no supporting facts.
All right. I really also want to hear your view on the provision that requires the Postal Service to recognize associations of its employees. Because as I mentioned, this is 1004B, upon presentation of evidence, the supervisory organization represents a majority of supervisors, that an organization represents at least 20% of postmasters, or that a managerial organization represents a substantial percentage of managerial employees, such organization shall be entitled to participate directly. And then there are these parentheticals that I left out on that reading. Supervisory organization represents a majority of supervisors, that an organization other than an organization representing supervisors represents at least 20% of postmasters. Implication, to me, clear, unmistakable implication of the parenthetical is that an organization that represents supervisors could include postmasters, because they're basically saying if you're postmasters and you want legitimate representation, if you're on your own, you have to have 20% of postmasters. If you're folded in with an organization representing supervisors, that limitation, that threshold does not apply. You can just be part of a supervisory organization representing a majority of supervisors and whatever portion of postmasters or managers want to be part of it. And so too, on the third clause, a managerial organization other than an organization representing supervisors or postmasters, which have their own membership thresholds that we've just told you about, managers can be part of an organization, and the Postal Service will have to consult with an organization that represents a substantial percentage of managerial employees. Why is that not the clear and, in fact, only way to read the statute? Because if what they wanted to say was these 3 groups can have mutually exclusive organizations and they have to be specific to these job categories, and we'll talk to them, that would be like way easier to say in a different way. The only reason it would be done in this way is if they're nested in the way I mentioned.
So the statute is certainly not a model of clarity, Your Honor, and we recognize that. That being said, we think a couple features of the statute point in the opposite direction, and it's certainly not the case that the only reasonable reading of the statute is as nested. So there's a couple things. So one, as Judge Wilkins sort of pointed to earlier, is that I think that second parenthetical that says other than an organization representing supervisors or postmasters, which seems to suggest a distinction between an organization representing supervisors and an organization representing postmasters. And then second, and more broadly, is that this provision, I think the only reason to enact it the way that Congress enacted it is as recognizing that there are sort of supervisory, postmasters, and managerial organizations, and that the interests of those employees may conflict, and the purposes of effective consultation may not be served by allowing the same organization to represent both.
So it's your position also that the intervener who intervened in your favor, which purports to represent managers, is illegitimate as a representative of those managers as well.
So, Your Honor, the statute sort of carves out managerial organizations as a separate organization.
Yeah.
My understanding,
under your reading.
Right, correct. My understanding is that, as Ms. Graber said, there has not ever been a managerial organization. There is not a managerial organization, and in recognition of that reality, my understanding is that the Postal Service has been willing to consult with sort of non-managerial organizations with respect to their managerial members.
Well, there's also never been a separate postmasters organization. There's a postmasters and managers organization, right? There's a postmasters and managers organization, and there's the National Association of Postal Supervisors, which purports to represent all 3 tiers to the extent they want to be represented by it. So your view is that the postmasters and managers, that the Postal Service actually cannot negotiate with them about the managers because of the way you read 1004 be?
So there's a difference, Your Honor, in our view between who the Postal Service may consult with an organization about and who an organization is entitled to be consulted about. And I think as a practical accommodation, the Postal Service has traditionally been willing to consult with NAPS or with the UPMA to the extent that those organizations represent managers or claim managers as members. The Postal Service has been willing
there, it really doesn't matter that there's a conflict of interest between the postmasters and the managerial employees under their purview who help them run the post offices, whereas there is a conflict that would prevent reading of the statute as establishing these organizations as nested.
I don't think that's necessarily the case, Your Honor. I think the Postal Service's view is that, and I don't know what would happen or what the Postal Service's view would be if there were a managerial organization, but rather than cutting off their managerial employees from any consultation whatsoever, the Postal Service has been willing to make an accommodation, even if that accommodation is not one to which NAPS or PMA are entitled by the statute.
We've really, I'm sure, kept you longer than you anticipated. I want to make sure that
I'd like to ask one question. How does the Postal Service think that a managerial employee is defined and can be distinguished between a supervisor?
So the statute, my understanding is, does not define managerial as distinct from supervisors. And I think because there is no sort of separate managerial organization, I don't know if the Postal Service has ever had to articulate a clean dividing line beyond sort of the plain text difference between supervisor and manager. And so that's just not an issue that I know if the Postal Service has sort of articulated an understanding or what that understanding is.
All right, thank you.
Thank you.
Thank you, Ms. Kraber. I don't believe you have any rebuttal time because we kept you up for more than your allotted time, but we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. And I'll do my very best to stay within those 2 minutes. There are 3 main points I want to make sure I hit. The first is that the 1979 NAPS decision was very clear that it is not just that the Postal Service must consider the statutory factors, but that it must fulfill them. So it is not enough for the Postal Service to allege, by the way, drawing inferences in its favor from the complaint, that it has given good faith consideration. The second point I want to hit is regarding pay comparability. What NAPS has alleged is that the Postal Service engaged in a post hoc survey after it had already implemented the 2016 to 2019 or established the 2016 to 2019 pay package. It did a post hoc survey of only 8 of 1,000 positions. And even for those 8 positions, that survey could not allow it to fulfill the statutory mandate because 101C and 1003A refer to rates and types of compensation and benefits, telling the Postal Service to look at total compensation. And the Postal Service never studied total compensation for any position. And the court cannot simply allow the Postal Service to draw inferences in its favor that it must have because it has unpled internal expertise. Third, regarding this issue of the headquarters and area employees, we do not share the Postal Service's understanding that any 2016 to 2019 pay package covered the headquarters and area employees represented by NAPS. And under 1004E, the Postal Service was required to issue a pay package and consult with NAPS during a certain period of time after it issued the pay package for the collective bargaining groups. I do want to make sure I point the court to paragraph 57 of our complaint, where we allege that the employees represented by NAPS that the Postal Service has refused to recognize include employees who perform both supervisory and managerial responsibilities. The Postal, and so just to wrap up here, the Postal Reorganization Act anticipates and desires all supervisory and managerial employees to have representation, and thousands of postmasters and headquarters and area and other supervisory and managerial employees have chosen NAPS as their representative, and we ask this court to allow them to do so. Thank you.
Thank you. We'll take the case under advisement. Thank you both for your energetic responsiveness to our questions.
Case number 20-1319 et al. Wendt Corporation petitioner versus National Labor Relations Board. Ms. Schroeder for the petitioner, Ms. Rajapaksa for the respondent.
Good morning, Council. Ms. Schroeder, you may proceed when you are ready.
Good morning, judges. May it please the court. As noted, my name is Ginger Schroeder of Schroeder, Joseph and Associates, and I represent the petitioner, Wendt Corporation. Almost 20 years ago to the day, Judge Edwards heard oral argument in a case where he noted that the NLRB in a substantive area of law had, quote, come full circle. And when he wrote the decision in that case, he penned an observation that has often been cited in cases by the DC Circuit and other courts, that it is a fact of life in NLRB law that certain substantive provisions of the NLRA invariably fluctuate with the changing composition of the board. And I would submit that nowhere is that inconvenient fact of life more apparent than in the development of the controlling case law on the issue of past practice, and particularly with respect to the factual issues governing my client's obligations under the temporary layoff that occurred in 2018. I think over time, particularly the past decade, employers have been wondering, what set of facts are actually going to privilege them to claim a past practice such that they can act consistent with that and have the privilege of, unilateral action or unilateral imposition. And I think that looking at the last 10 years of case law, discerning a past practice is a bit like, it's a bit like changing a tire on a car rolling downhill. So we have the backdrop of Katz, and if you look at the decision in Raytheon, you'll see that the myriad of cases that have dealt with this. It says, in sum, and for the reasons stated above, we overruled DuPont as well as Beverly 1 and Registered Guard, and we reinstate Shell Oil, Westinghouse, Winn-Dixie Stores, Beverly 2, Capital Ford, and the Courier Journal cases. Finally, when you look at the transition of those cases over time, just 7 weeks before my client had the temporary layoff, we have the decision in Raytheon. And that, I think, privileged my client to deal with the layoffs in the manner that it did. In Raytheon, the court declared the DuPont standard very unworkable. And in the numerous decisions where boards and courts have interpreted Katz, which is the Supreme Court precedent in this area, they really all support the view that when determining whether an employee action constitutes a real change and thus triggers the obligation to provide the union notice and an opportunity to bargain, really the only relevant question that we should be asking is that action similar in kind and degree to what the employer did in the past, such that employees would understand, what was going to be the circumstance and what was going to be the response. In Raytheon, the circumstances in that case.
I don't see any change or whipsawing back and forth in how the board has treated the focus of the inquiry. So here the claim is that the employer unilaterally transferred work out of the unit. Wendt's response is, we have a longstanding practice of allowing some workers outside the unit to do some of the work that the unit employees do. And when we promote these 3 shop employees, they're consistent with the past practice of allowing non-unit employees to do some work. Board says, no, you've transferred work out of the unit by creating new positions and promoting people into it. Past practice supporting that, I did not see Wendt as providing evidence of any comparable prior removal from the work unit. So I know that's the second reliance that you have on past practices, but there isn't any past practice referred to, is there, in the record of Wendt doing that kind of thing, removing work from the unit?
So with respect to I believe Your Honor is referring to the supervisors, the creation of the supervisory positions and the failure to backfill the positions of the lead men.
Or failure to negotiate over that change, yeah.
Correct. That the board would have to show that there was a material loss of work. And if you look at Appendix 72 and Appendix 792 through 795, that demonstrates that the unit work that was performed by those employees combined to only 1/2 of a full-time position.
Right.
So that's not a material change.
So
Sufficient
that's
to
really,
trigger.
with respect to that, that's the position that you're relying on, is just that it's de minimis, not that there was in fact a past practice that was acceptable on this point.
Well, we certainly did provide some evidence in the record relating to other supervisors who performed work. For instance, in the
Right, but not that,
shipping-
that work was taken out of the unit by a change in the way the workforce was organized. On your principal argument about relying on past practice, it's about the layoff practices.
Correct.
And again, you know, when reading all of the board's precedent as, you know, not a zigzag, but just a body of precedent, it does not appear that 2 temporary layoffs over 17 years is a kind of established past practice. At least none of the cases that I read, you know, Raytheon or Katz or Mike Sells or the cases that they themselves cite seems to recognize that kind of intermittent and far in the past practice as the kind of what do they call it? Dynamic status quo.
Dynamic status quo, Your Honor. Yes.
That the past practice doctrine is meant to embrace.
So I'd like to address that because you really, Your Honor, get right to the crux of the problem. The administrative law judge in this case did not actually analyze at all the issue of the past practice of layoffs, and in fact gave very short shrift to it. That caused the board to almost do really a de novo review. They said themselves that they were going to do a careful review of the record. Well, their careful review of the record had factual inaccuracies that were not supported by the record. So if we look at Appendix 612 through 613 and 824 through 843, we will have layoffs that occurred in 2001, 2002, 2003, 2005, 2009, and 2015, all predating the 2018 layoff. Very conveniently, when the board did look at the layoffs that it actually found in the record, it dismisses in like or substance the 2015 layoff by saying, well, that was permanent in nature, so therefore it doesn't count. I'm suggesting to this court that when we're looking at the issue of past practice, we have to look at the circumstance and we have to look at the employer response. The circumstance that Wendt is faced with being in a very cyclical recycling industry is downturn in work beyond its control. The recycling industry goes up, it goes down. How does Wendt respond to that? By laying off employees when it hits the valleys, and by taking them back when it hits peaks, or even hiring temporaries when it hits peaks. The board did not deal with those layoffs at all. So if we look at 2001, you know, we had 5 people laid off. 2002, we had 2. 2003, 1. 2005, 2. 2009, 6. And 2009, the board would like you to ignore the 2009 layoff as well by saying, well, there they laid off both unit workers and supervisory workers. So it's different in nature and kind than the other layoffs. And what I'm suggesting—
It's interesting you're referring to, I mean, not even in your brief to us do you refer to all of those. You reference, I think, 5 layoffs. The board says 2002 and 2003 layoffs. There were no sizable group of people. You know, I didn't see your brief making any serious effort to combat the distinction the board relies on there. And we review the board, especially on this kind of fact-bound, record-bound issue, just for substantial evidence and with a lot of deference. So when you bring up, you know, straight from the record and not even in your brief, some larger body of putative practice in this area, I don't really see precedent that allows us to reach through what the record, the argument you made in your brief to us, and just sort of consider that de novo.
With all due respect, Judge Pillard, what I just read was from my reply brief, down at the bottom of page 3, going to the top of page 4, and I specifically cite those pages in the appendix that have those exact documents that were respondents' exhibits in the underlying trial. I actually was somewhat surprised that the board would have taken the position that our layoffs were not the same or similar in kind and substance to what had occurred in the past. Layoffs are not something that like in Raytheon, where they're every year facing a healthcare implementation and they're making changes to that healthcare plan every year. Layoffs are very circumstantial. And that's why I think we need to look at circumstance, decline in work, and what whence action was. And even the testimony of our witnesses in the underlying trial specifically noted, and the board, and certainly the general counsel, never put in a single bit of evidence as to anything different that Wendt did when faced with a downturn in work. There's a dearth of evidence on that.
Do my colleagues have further questions for Ms. Schroeder?
I do not.
All right. Thank you, Ms. Schroeder. We'll give you a brief amount of time for rebuttal.
Thank you, Your Honor.
Ms. Rajapaksa.
Thank you, Your Honor.
Sorry, I just butchered your name. And I'm guessing
okay.
I'm not the first person who ever did that.
No, you're not. And you actually did quite well. May it please the court. My name is Meelakshmi Rajapaksa. I'm counsel for the National Labor Relations Board. This case involves the board's findings that Wendt committed numerous unfair labor practices in the first year after its employees designated a labor union as their collective bargaining representative. Most of the unfair labor practices at this point are uncontested, and the board, of course, seeks summary enforcement of its order as it corresponds to the uncontested unfair labor practices. With regard to the contested findings, I do want to focus on the unilateral changes that were the subject of Ms. Schroeder's discussion with the court today. In terms of the past practice defense, Judge Pillard, I do think that you correctly identified the problem that Wendt faces, which is that in Raytheon and Mike Sells, the board didn't fundamentally change the quantum of evidence, so to speak, that the employer has to put on in order to establish a past practice in the first place. So the company at minimum has to show that the overall frequency and number of past events amount to a past practice. And if you look at the unilateral removal of work, the company certainly did not clear that bar.
When you read the earlier decisions, they seem to talk about, this dynamic status quo, the idea that there are going to be things that are going to have an impact on terms and conditions of work, like changes in the amount of premiums and the benefits that one gets under the same status quo health plan. That makes sense to me. This notion that we're going to unplug from that and just say overall frequency and number of events could be a past practice. Is there any way you can help us understand that this isn't just some random number cutoff or frequency eyeballing by the board?
Well, the board is bringing its.
I'm a little surprised that something like a layoff, which, as Ms. Schroeder explains, can be very important prerogative for a business, but also is not something that is sort of a dynamic status quo. It's very circumstantial. Like, how could that ever be part of this this doctrine of past practice?
So the board confronted this very type of issue in Mike Sells, and Mike Sells involved an irregular practice, sort of like the layoff that we're confronting in this case, or the practice of layoffs, the so-called practice. In Mike Sells, the issue was some subcontracting decisions, which don't occur annually or at set intervals. But the board said that in order to honor employees' right to bargain collectively about changes to the status quo, there has to be some minimal showing that the number or frequency of past events amounts to a practice that employees could have expected. So in the Mike cells, the facts were that there were 51 subcontracting decisions that were made over a period of 17 years. And even though the decisions were not regular, even though in some years there may not have been decisions made, overall, looking at the prolonged period, there were a sufficient number of events. The board took the same approach in this case. It considered a similar 17-year period and how many layoffs took place in that 17-year period. And the Raytheon decision enters into the analysis because the issue is not just number and frequency, it's also comparable events. Under Raytheon, the board was very clear that the past events cannot materially vary in degree or kind from the event at issue. So the board, it was entirely fair for the board to look closely at the particular layoffs that the company is citing.
The thing I'm perplexed about is that the company is arguing that it has been their consistent practice over this period to lay off employees due to a lack of work. Well, you can't demand a certain number because part of the equation is a situation involving lack of work. And what they said was when there was a lack of work, they routinely reduced their workforce. And that was not refuted by the board. And so within the time period looked at, I don't know what more you could expect the company to do. And they also subsequently pointed to the handbook. I'm not sure we can even consider that, but in any event, they said when there has been a situation in which there has been a lack of work, we have laid employees off. And I think the case that you're citing, Mike Sell, I wasn't persuaded that's in any way inconsistent with what we're talking about. We're talking about a situation here when there is a lack of work, we lay people off, and it's not an insignificant number, but it's consistent. The company's position is consistent. And there's nothing to indicate there are circumstances when they did other than what they claimed when there was a lack of work.
Right. The issue for the board is there has to be some. This occurrence that you're talking about, Judge Edwards, is relatively infrequent, right? The occurrence of temporary layoffs of stop employees happened twice in the past. And so, yes, 100% of the time.
More than twice.
No, the
2001, 2, 3, 9, 15.
Well, 2002 and 2003 are admittedly the layoffs of a handful of employees at most. What we are talking about in this case is a layoff of 1/3 of the shop, or 10
Why does it matter? Well, the number of employees who are going to be laid off is going to be affected by the economic circumstance. I don't know what you're telling me. You say there were only a few in 2001. So what? That was all that was required because the nature of the economic circumstance. You wouldn't lay off more than was necessary in any of the years when you had to lay off. But what they are saying is whenever there was a change in our economic situation, we would lay off employees, whether it was a handful or a whole department. It depends on the economic circumstance.
Right. So there are two sort of prongs to the past practice analysis. One is the nature of the past actions, the similarity of degree and kind. The other prong is frequency or number. So I think we're kind of mixing two different things. The 2002 and 2003, and to the extent you want to think about it, 2005 unfair labor, past practices were not similar in degree and kind to the layoff, because those involved at most, 1, 2, 3 employees. This particular layoff.
Again, I'm repeating myself. I don't know why that matters.
It matters because under the law, the past actions have to be comparable. They have to be
because
comparable.
The duty to bargain obligation wouldn't allow them whether it's 1, 2, or 3 doesn't matter. The duty to bargain would be there if they didn't have the past practice. Whether it's 1, 2, 3, or 103, they would have to bargain.
Well, the issue
and what they're saying is, in the past, whether it's 1, 2, or 3, or 103, we have always laid off as necessary. It seems to me perfectly comparable And the number of employees affected depends upon the economic circumstance that the company has faced. And there's nothing to indicate the company is playing games there. They were honestly pointing to situations where there was an economic downturn and they reduced an appropriate number. They're saying, and here there was an economic downturn, not contested, and we reduced an appropriate number. That's the practice that we're looking at. It would make no sense to say you have to show that there is a practice of how many did they reduce here? 20? You'd have to show 18 times in which they reduced 20 employees in order for there to be a binding past practice. That's a ludicrous rule. That makes no sense.
Well, Judge Edwards, I would respectfully say that you have to look at the policy behind this requirement of similarity in degree and kind. The
Duty
purpose,
to bargain.
well, it is the duty of bargain, but it's also that the question is, have the past actions forecasted essentially for the union and employees,
right?
That this kind of action is going to happen. It's a recurring sort of thing.
No. When you say recurring, you have to be careful, I think, when you say recurring. Recurring has to be read with reference to the condition, that is economic downturn. So it will recur as there are economic downturns. You can't demand the company that the company show that there were economic downturns every year in order for the practice to be binding.
And the board didn't do that. The board didn't impose that requirement.
So it seems to me there are an awful lot of occasions here where the company has said, and the board's kind of dismissive. I think in one they said, one involved both shop employees and non-shop employees.
That was 2009. Right.
I read that and I laughed. I mean, why is that relevant that it involves shop and non-shop employees? The point is they're saying it involves shop employees, which is what we did here. We have and so the board dismisses one of their examples, and there was another ludicrous dismissal too. All situations in which the company is saying there was an economic downturn and we have consistently let people go during economic downturns. There's no instance in which we have not. We're not doing anything different here. And the number of employees let go depends upon the nature of the downturn. That seems totally reasonable.
The board looked at sort of whether these past actions would have given the union and employees notice that, this is what the employer does. This is how it would handle a temporary layoff. Right. And the problem is—
Wait. How it would handle a temporary layoff or would have a temporary layoff?
That it would have a temporary layoff and what would happen in the temporary layoff.
Wait, there was no union before.
Right, but
so you can't bring that into the equation. So there was no obligation to bargain. So the employees don't have an expectation of a duty to bargain because there was no union. So that's not in the equation.
The issue is, what was the status quo, right? What is the status quo as to these temporary layoffs? And you have to look at the two temporary layoffs to understand, so that the employees and the union could understand, this is what is going to happen. This is what the employer will do. There's nothing to bargain about. We already know. And in this situation, all the board is saying is the employees in the union could not have known from two prior instances.
And what are you saying they could not have known? They could not have known that the employer would reduce the staff in the event of an economic downturn?
That it would
you don't think these employees had reason to know that?
That would have a mass layoff of 1/3 of the bargaining unit?
Mass or laying off employees appropriate in number to the economic situation before the company. That's the way I would define the practice.
Well, the board defined the relevant action that it was looking at as a temporary layoff that affected a sizable group of employees. Here it was 10. So there were other sizable layoffs, but there were 3. One of them was a permanent layoff.
Why does that matter that it's permanent? They are reducing the labor force with reference to an economic downturn. And what the employees know, if there's an economic downturn, they're going to reduce the workforce, maybe permanent, maybe temporary, but they are going to reduce the workforce. So that's 3 we have. Now, how are you dismissing the other 2?
Well, I'm not dismissing them. I'm just saying they're not sufficient.
Right.
2 temporary layoffs are not sufficient.
No,
in
they're
a period of
5.
17 years.
5.
The other layoffs are affected they were essentially one-off decisions to lay off 1, 2, maybe 3 employees. They are not comparable to the decision to lay off 10 bargaining unit employees.
And I guess it's a matter of definition.
Ms. Rajapaksa, I'm curious about the implications of this in the sense that so the point of the past practice is that it excuses a duty to consult with the union that would otherwise apply. And in Mike Sells, the board says, of course, the union can request to bargain over whether to change the practice itself. So had the employees in this case, or the union in this case, I guess one question is, how do they know that this would be treated as a past practice and a defense before the board? But if they want to going forward, they can ask, say like, no, we think when the employer is laying people off in response to economic downturns, that it should come and talk to us about it. And we should, that's important to our terms and conditions. So it is not, I'm just having a little trouble processing that comment in the end of Mike Sells and how it works, because as I understand from Raytheon, the point of this past practice doctrine is that it is not a change in working conditions that is subject to bargaining if something is a past practice, but it can nonetheless be put on the table by the union.
Right. So the union can bargain over changes to the status quo. So there is, I think all that Mike Sells was saying, it was clarifying really, because there was some confusing language in Raytheon on this point. The employer has a right to maintain the status quo as to its past practices. However, if the union requests bargaining about a past practice and proposes, for example, changes to that practice, there is a duty to bargain over the issue going forward. So,
but if they don't change the past practice, if the employer keeps the past practice consistent, that does not create an opportunity for example, newly unionized workforce to say, hey, we see that as a big deal. We want to bargain over that.
No, they can request bargaining over that.
Yeah. They can request it immediately. As soon as the company announces they're going to lay off, the union can come in and say, we want to bargain about it. And the company would have to bargain about it.
And they just are bargaining over the past, whether the past practice should continue. It seems like,
yes.
I guess I'm having a little trouble because it feels like a very formalistic distinction to say you can bargain over whether the past practice continues, but you can't bargain directly over layoffs that the employer characterizes as consistent with its past practice.
Well, you can, the parties can bargain over both the implementation of the current decision to lay off as well as the issue going forward. But the point of the Mike Sells case, for example, is that the employer can go ahead and unilaterally implement.
Unilateral, they don't have to reach impasse, you don't have to bargain the impasse, but the union can still come in and say, we understand you're following what you think is a past practice, we want to bargain about it. The company would have to bargain about it. But the company is saying, we did not have to reach an impasse over something that we have consistently done, even though there's now a union here. And I don't see why, I don't see how you get over their claim that there was a consistent practice of we will let people go in the event of an economic downturn. I just don't see it. The distinctions you're raising seem really very strange to me. There were only several people, one occasions it was permanent and not temporary. They're distinctions without meaning.
Well, the requirement of similarity between, various past events and the current event is in CATS, for example.
There's no question about it. But we're talking past each other, so I will stop. But what I am saying is similarity is measured by reference to how you define what we're talking about. And the company says what we're talking about is our right to let people go when there's an economic downturn. And they would say, so is this similar? It is similar because we let people go during an economic downturn. You're trying to nitpick it to the point and say, no, no, no. We have to count the number of employees. We have to count which days they were let go. We have to count whether they were men or women. We have to look at the weather. That's not what the cat's rule is.
Well, I respectfully have to disagree with you, Your Honor, because the board's decision is written as it is. However, I will say, to the extent that the court disagrees with the board's framing of the past practice, the board would appreciate a remand to consider whether 5 past instances is enough to amount to a past practice that would have sheltered the unilateral action from bargaining. So I see that.
Other further questions for Ms. Rajapaksa?
No.
Ms. Schroeder, we will give you 2 minutes for rebuttal.
Thank you, Your Honor. It's very clear from the questions and the responses, exactly what the issue is in this case, and I don't want to belabor it too much. I just think it's very easy in the business world for the board to sit in hindsight and then to nitpick, as Your Honor, Judge Edwards points out. Was it 5 people? Was it 4 people? Was it for 3 days? Was it permanent? Were salaried people let go at the same time as unit people? There would never be any past practice because everything is dependent upon the circumstance. And so I'm asking that we really look at the Mike Sells case and say, what we're concerned with here is, what is the circumstance? What is the employer's response? And that is the consistency that we need to look for. And I submit to this court that my client did exactly what it had done a good number of times in the past when faced with this circumstance. And it would have been very clear to anyone, because there was no other evidence in the record to the contrary, that this is what was going to happen. Thank you very much.
Thank you both. The case is taken under advisement.
Case number 20-7077, Joshua Ashley et al. Appellants versus AstraZeneca UK Limited et al. Mr. Branson for the appellants, Mr. Shanmugam for the appellees.
Good afternoon, counsel. Mr. Branson, you may proceed when you are ready.
Thank you, Judge Pillard. May it please the court. The defendants bribed Jaish al-Mahdi terrorists both in cash and in kind, and they knew their bribes were funding terrorist attacks in Iraq. That is more than enough to state a claim for primary and secondary liability under the Anti-Terrorism Act. In holding otherwise, the district court misapplied basic Rule 12 standards by ignoring or recasting large portions of the complaint. The defendants now continue the same theme on appeal, repeatedly asserting their version of the facts. But this is a motion to dismiss, and once our very detailed allegations are accepted as true, none of the district court's rulings can stand. The district court erred on 4 issues I'm hoping to cover this morning: proximate cause, aiding, abetting, Hezbollah, and personal jurisdiction. Now, the first 2 are quite similar, but aiding, abetting is actually even easier than proximate cause because the statute contains no direct link or other causation requirement for secondary liability. And indeed, a recent trilogy of appellate decisions from the 2nd and 9th Circuits, Kaplan, Honickman, and Gonzalez, have reversed district courts for misconstruing aiding, abetting principles in much the same way that Judge Leon did here.
Are you saying that for aiding and abetting liability, a plaintiff doesn't have to prove that the principal who the defendant was aiding and abetting was a proximate cause of the injuries?
No, Judge Wilkins, I'm not saying that. I should have been more precise in my language. When I said there's no causation requirement, I meant that there's no causation requirement that the defendant's cause plaintiff's injury, but you're absolutely correct. For secondary liability here, Jay Shalmati must have proximately caused plaintiff's injuries, and I don't view that element as being in dispute at this stage.
Right. All they have to do is show that they were provided substantial assistance. So you're distinguishing substantial assistance from the kind of substantial factor that counts for direct liability.
That's correct, Judge Pillard. To be clear, we've pleaded both, and I think that, as we explained in our brief, Judge Leon made a very similar error in disposing of the proximate cause issue and the aiding and abetting issue, in that he misconstrued our allegations about the Ministry of Health. But I do agree, Judge Pillard, that substantial assistance, and you can just see this from the court's Halberstam opinion, I don't think most people would say Linda Hamilton proximately caused the murder, and yet she was held liable for it. And so I do think the analysis is even easier for aiding and abetting, and I would submit that that is the most straightforward path to reversal here. That said, oh, I'm sorry, Judge Pillard, you can ask a question. Oh.
You're getting there.
So to move to proximate cause, as I said, I think that Judge Leon made a fundamental error in disposing of both our primary and secondary liability claims. And I really just have 3 points about that. First is the ministry was a known terrorist front, not an independent intermediary. It was, in the words of U.S. Embassy Baghdad, quote, openly under the control of the Mahdi army of Muqtada al-Sadr. That's paragraph 169 of the complaint. Once that allegation is accepted as true, this decision should be reversed. Terrorist-controlled intermediaries do not defeat causation, and they certainly do not preclude aiding and abetting liability.
So you're making a very important distinction between a state sponsor of terrorism and a terrorist-controlled entity, even though in nomenclature they may sound similar. A state sponsor of terrorism is a government, a nation state that harbors in some way terrorists or doesn't go after them, whereas here you're saying no, that Judge Leon made a false equation between a governmental agency and a nation state.
Judge Pillard, that's absolutely correct, and I think this court's Owens 4 decision makes that plain, in that nobody claimed that Al-Qaeda was running the government of Sudan. Sudan was not an instrument of Al-Qaeda. Did it support Al-Qaeda? It absolutely did. But I think the point of Owens 4 was that because Sudan was an independent intermediary, and again, that was this court's words, it severed the link between the bank, and Al-Qaeda. And we have pleaded the opposite of that. We've pleaded that the Ministry of Health was not an independent intermediary at all. I would also want to emphasize another key distinction with Owens 4 on that front, which is BNP's money never got to Al-Qaeda. And that's true of every intermediary case the defendants cite. Owens 4, Rothstein, Kemper, Brill, Siegel, all of them. The bank's money doesn't get to the terrorist group. It stops with the intermediary. Here, Judge Leon himself recognized that we have pleaded exactly what was missing in Owens 4, in that the defendants' free goods payments financed Jaish al-Mahdi, not any legitimate Iraqi health program. And that's most apparent at JA 835, where in Judge Leon's words, defendants were aware that their goods, quote, would be used by Jaish al-Mahdi to support terrorist attacks, close quote. That is the sort of substantial connection to terrorism that Owens 4 held would be sufficient. The plaintiffs in Owens 4 did not meet that test. We do. The third point is the cash bribes. And I want to pause here because these are very important. The defendants paid individual cash bribes to the terrorist operatives who were at the ministry. And no matter what this court thinks about the status of the ministry as a juridical institution, the point of a bribe is that it goes to the individual, not the institution. That's what makes it a bribe. And so I don't think anybody is disputing that if those bribes were paid, it would violate the statute. All that's disputed is whether we've properly pleaded them. And as we've explained in our papers, are many pages of allegations about these bribes more than satisfy our pleading burden under Twombly and Iqbal.
I'm trying to understand how you think that the scope of the liability works. Let's suppose we send your case back, and let's suppose that that the fact finder does not believe that you've proven the bribes, and all that the fact finder finds is that that the defendants did business with Jay Shalmati, or with the health ministry. Because with the health ministry, I'll say, is that sufficient in your view for liability? Because if they did business, even without paying bribes or providing, extra goods that could be sold on the illegal market, that's material support because of the I guess the unity of between Jay Shalmati and the Ministry of Health.
Yes, Judge Wilkins, we do think that. We've alleged that at paragraph 179 of the complaint. We don't think we need to prove the bribes in this case. I think you can see that most clearly. The analogy would be the Ninth Circuit's Gonzalez case, where Google didn't do anything special or illegal to support ISIS. It just had a commercial business relationship, and the Ninth Circuit reversed the dismissal of aiding and abetting claims. So yes, Judge Wilkins, the answer is yes. That said, I think this case involves quite a lot more than that, and the bribes are our lead theory, I would say. And the reason is, the Special Inspector General for Iraq Reconstruction called.
So if you're right, then the U.S. government provided substantial assistance under your reading of the statute, right?
I don't think so, Judge Wilkins. I don't think the U.S. government did business with the ministry in the way that you're positing. Certainly, the U.S. government built infrastructure projects. It tried its best to clean up the ministry. It attempted to wrest control of the ministry back from Jay Shalmati through things like the arrest of Hakim Zamali, who was the deputy health minister, who in General Petraeus's words had, quote, effectively hijacked the ministry. General Odierno ordered a military operation in June 2007 called Operation Black Crescent that was attempting to address this very problem. And that's at JA 794. So no, I know, Judge Wilkins, the defendants say that a lot in their brief. There's no question, but there's no evidence of that. And more importantly, we don't allege anything that would support that inference in our complaint. If you look at paragraphs 76 and 113 of the complaint, we allege that the U.S. government did not support the Jay Shalmati controlled ministry, did things like build hospitals while trying to clean the ministry up. And this goes to a very important point that even Judge Leon accepted at JA 824, where he acknowledged that taking our allegations as true, what the defendants did was counterproductive to the U.S. mission to improve the Iraqi health system. So this notion that the defendants are trying to argue on a motion to dismiss that they are hand in glove with the U.S. government is just not true, and it's certainly not alleged in the complaint.
So on the direct liability, the district court only reached proximate cause and actually only reached the independent intermediary block to a showing of proximate cause, and didn't actually even go further and consider even if there is an independent intermediary, as we know, there can nonetheless be liability if there's a sufficiently, I'm going to get the words wrong, but if there's sufficiently substantial showing of aid nonetheless. But the district court did not go on to look at the reasonable foreseeability aspect of the probable cause determination, nor did it consider the act of international terrorism aspect. And in the act of international terrorism, am I correct that here the allegations are that the acts of international terrorism are material support for terrorists and terrorist funding under 2339A and C?
That's correct.
And am I correct that the statute, that 2333A requires such an act, but that additionally the defendant have violated such law in a manner that appears to be intended to intimidate or coerce a civilian or influence policy of a government or that's a overlay on the incorporated act of terrorism. Is that correct?
That's correct.
Okay. And is there precedent that recognizes 2339A and 2339C as qualifying acts of international terrorism?
Yes, Judge Pillard, the Boehm case from the Seventh Circuit involved 2339A.
Yeah.
So there is precedent for that. There are some district court cases that have recognized 2339C. I don't believe that particular issue has made its way to an appellate court.
And in terms of the appears to be intended to, that is a legal question. There is a complaint before us. Are you asking us to reach that? Are you asking us to remand if we were to agree with you? I'm just trying to get the scope of your position. If we were to agree with you that the dismissal based on a lack of probable cause might need further thought, should we reach or should we not reach the act of international terrorism?
I'm hesitant to give the court advice about what it wants to reach. I certainly don't think it has to reach the question. This was not, because of the posture of how we briefed this, I would say the briefing is rather sparse before this court because it was an alternative argument. I think it would be a sensible course to remand. Of course, this court does have discretion to decide it if it wants to, but I suppose if you were to ask my views, it would be to remand because Judge Leon did not reach this question. And it has not been, I would say, briefed as thoroughly as the other issues in the case. That said, I do think the Boehm case that we've cited provides some very good precedent for our theory, which is that courts typically presume that people intend the natural consequences of their actions.
True enough, but when you're giving directly to, was it Holy Land Foundation, that looks a little bit more like the U.S. donors possibly being on board with the mission of the ultimate terrorist group than giving then contracting for medical goods with even a defunct and hollowed out Ministry of Health in Iraq.
Well, I disagree, Judge Pillard. I don't think that inference you just drew was in the opinion. If you read the district court opinion in the Boehm case, which I would encourage you to do, this was not cash given directly to Hamas. The defendants claim that it was, but that's not what happened. It went to a variety of charities that did legitimate charitable things like social welfare services.
Was Holy Land Foundation, I guess, is in the caption.
That's right. Holy Land Foundation was the defendant, but if you read the district court case, they were not giving money directly to Hamas. They were funneling it through, I think, a list of about 10 charities. And not all of them were even controlled by Hamas. Some of them just were independently aligned with Hamas. So I would say that our allegations are stronger than the ones in Boehm. And the reason that my friends' cases are off point is they've cited cases like Kemper and Brill where there was no proximate causation. So this theory that we're articulating didn't work for those plaintiffs because the natural consequence of their actions did not include terrorism. So if this court were to reach it, I think the comparison to Boehm is good. I would also encourage the court to look at Judge Lamberth's opinion in the Woltz versus Bank of China case, a very, I would say, somewhat comparable fact pattern where the defendant made all the same arguments that we're a reputable bank, we could never intend to cause terrorism, and Judge Lamberth applied the principles I just articulated and denied the motion to dismiss. And I think the same result should obtain here.
On your aiding and abetting, I'm sure you're getting there. I wonder if you could talk to us about designated terrorist organization Hezbollah's role in committing, planning, or
authorizing, Judge Pillard.
Authorizing, thank you.
I think it's an excellent question. That's exactly where I was going next. And I think the important point was built into your question, which is that Congress did not limit secondary liability to terrorist acts committed by a designated FTO. Instead, it extended liability to acts that are planned and authorized. by an FTO. And the reason was to cover attacks committed by a terrorist proxy group of a designated organization, like Jaish al-Mahdi was for Hezbollah. Jaish al-Mahdi was an instrument through which Hezbollah orchestrated terrorist attacks against Americans in Iraq. And on that issue, I would encourage the court to read the amicus brief by the commanders, signed by General George Casey and many of the other top generals from Operation Iraqi Freedom, explaining how deeply Hezbollah was involved in Jaish al-Mahdi's terrorist operations and why the district court's logic misapprehends the way these groups work in practice. So I don't view Hezbollah's role as really being disputed here. I think the only question is whether it was sufficiently linked to each individual attack.
Right, the defendants really push you on, it's not enough to train, it's not enough to inspire, that's just very general. And the way they read the statute, and it's a natural enough reading, that planning and authorizing is a much more event-specific verb.
Well, that may be true, Judge Pillard, but we have tied the training and the planning and the provision of munitions to our individual attacks. I think that's really not even contested. The easiest place to see this is for explosively formed penetrators at paragraphs 395 and 96 of the complaint, where this was a Hezbollah signature weapon, and Hezbollah was involved in every single penetrator attack in Iraq. And so, Judge Pillard, I suppose one reading of the statute that I guess I understand my colleagues to be advocating for is that you have to plead that a Hezbollah individual operative showed up to the scene, the street corner where the attack took place, and have to point, hey, Jaish al-Mahdi, plant this IED here, and I want you to blow up that Humvee. And anything less than that is not planning or authorizing. I think that's textually unfounded, as we've explained in our brief. Planning and authorizing does not require control of all of the details. But I think it's also inconsistent with the way these groups work. And again, I thought the amicus brief from the commanders was quite compelling on this, that's not how Hezbollah orchestrates attacks. It doesn't send Ali Musa Dakduk, its commander in Iraq, to the street corner in Sadr City and plant an individual IED. It orchestrates the infrastructure through which Jaish al-Mahdi then commits these attacks. And for every attack alleged in the complaint, we have alleged a tactical and a geographic nexus tying Hezbollah to the individual attack. And on a motion to dismiss, that's
but you're kind of doing this backwards. You're saying that we have to interpret the statute so that it comports with how terrorist organizations work. No, we have to interpret the statute and we see whether the way that you have alleged that this works fits within the statute, right?
That's true enough, Judge Wilkins, but I think we've done that. I mean, my colleagues, it's not like they define the word planning and authorizing that excludes the theory I've articulated. A person, just the ordinary meaning of the word planned, you plan an attack if you, for example, the example we gave in our opening brief, if a Hezbollah operative trains a room full of Jaish al-Mahdi fighters how to use 107 millimeter rockets against Americans in Iraq, and does so with the specific intent to cause Jaish al-Mahdi then to commit those attacks using those rockets. Hezbollah has planned those attacks, whether or not the Hezbollah operative then shows up to the street corner and says, now I want you to employ what I taught you and go blow up this particular target. Sorry, Judge Wilkins.
So if I, train my law clerks on how to write briefs and how to make arguments, am I planning their future briefs and arguments?
I think arguably you are, Judge Wilkins, but this case is even, I think, easier than that because there's specific intent. And that is a critical facet of our allegations. That Hezbollah didn't just train Jaish al-Mahdi because it wanted Jaish al-Mahdi just to be good terrorists in the abstract. It did so for the particular purpose of orchestrating terrorist attacks against Americans in Iraq.
The statute doesn't require that, or are you reading plan and authorize? I mean, I guess authorize does, but what about plan? Are you reading plan in a manner that would require some proof of intent on the part of Hezbollah?
I think I am, Judge Pillard. I think when you plan an act, you have to have intent for the act to take place. And the fact, our allegations that Hezbollah wanted these attacks to take place, that's not disputed here, and I'm not anticipating any difficulty proving that if the case were to be remanded. But I do think it distinguishes it from a lot of the hypotheticals you can think of, where if all Hezbollah had done was given a small cash donation to Jaish al-Mahdi and said, I want you to have this because we support Muqtada al-Sadr's mission of allegedly providing care to Iraqi Shia, that wouldn't be enough. But I think that the tight nexus between what Hezbollah has done and each attack here is really distinguishes it from the other hypotheticals that have been given. And in the commander's brief, they have cited district court cases from judges in this district that have made evidentiary findings about Hezbollah's role in an individual attack based on little more than the weapon type and the geography in which it was used. So, I actually think that we're going to have experts and we'll be able to prove that even without any other evidence beyond what's alleged in the complaint, if there was an EFP, that's the acronym for the penetrators, that went off in Sadr City, Hezbollah was involved in that. And at a motion to dismiss to require us to plead more, Judge Wilkins, to your point about does the reality of terrorism affect this statute? I think it does, because Congress stated that its purpose in enacting the Justice Against Sponsors of Terrorism Act was to provide the broadest possible basis to afford relief against companies that finance terrorists directly or indirectly. And under their view of the statute, I think this cramped FTO requirement that they're adopting would gut Congress's purpose, and that absolutely is something that this court should consider.
So just to review on the aiding and abetting, the state of mind requirement is different from the requirement for direct liability. In your view, it's only knowingly providing substantial assistance?
I think the Second Circuit, Judge Pillard, has actually cleaned this up quite a bit in the Kaplan and the Honickman cases. For aiding and abetting liability, I think the state of mind requirement is general awareness. And as the Kaplan case explained, that's actually less than fully focused knowledge. Linda Hamilton did not even know about the murder for which she was held liable. She didn't even know that Bernard Welch was committing burglaries. So it's general awareness of the defendant's role in an illegal activity from which terrorism was a foreseeable risk. That is the standard the Second Circuit has adopted, and I think it's correct. Now, you're correct that the state of mind factor for substantial assistance, Judge Pillard, I think the degree of knowledge is relevant to that inquiry. But what Judge Leon held was actually the standard is specific intent, that the defendant has to be one in spirit with the terrorists, and that's just not right. That's not anywhere in the statute. It's inconsistent with aiding and abetting doctrine, and the Second and the Ninth Circuits have now rejected it. And the Ninth Circuit in Gonzalez actually reversed the district court case that Judge Leon cited for that requirement. So I think degree of knowledge is one of the factors, and I don't think it's seriously contested here. Judge Leon acknowledged that these defendants knew. But it's certainly not specific intent, and I think it's very, very important for the court to reject that standard.
You have these two theories, two separate counts on aiding and abetting. One is the RICO count, and the other is the more direct authorization. If we were to believe that Judge Leon erred with respect to dismissing one, do we need to reach the other? Do we need to reach both?
I think you do, Judge Pillard, because they're separate counts and Judge Leon dismissed both. So I do think you need to reach the RICO count. And if I can address that just briefly, it all depends on what does the word act mean. Can the word act encompass a multi-year terrorist campaign? I think Judge Wald's opinion in Halberstam answers that question. The court there defined the act assisted, that is the court's words, as the multi-year burglary campaign. We know Congress wanted Halberstam to provide the legal framework for how aiding and abetting liability should function. And so, and that's an argument I think you'll find conspicuously missing from the district court opinion and from my friend's briefs.
Well, why do you even need RICO? I mean, in a way, it seems like it's almost a factual question. Like either, as you say, I mean, there's no RICO claim in Halberstam. Why isn't it just, either the individual acts or a whole campaign in more common sense problems? Somehow, I mean, RICO is a hornet's nest. That's technical terminology. And so I just wonder, is RICO as such doing any work for you?
Well, the reason we cited RICO is because, Judge Pillard, as you noted, I think in your questions earlier, there needs to be a predicate criminal violation of U.S. criminal law for the definition of the act of international terrorism. And so we defined RICO, and I realized RICO can scare some people off. There have been a lot of bad RICO cases that have been brought in history. But we're not claiming the defendants violated civil RICO. What we're claiming is that Muqtada al-Sadr's terrorist enterprise was a RICO violation. And that is what the defendants aided under count 2. And in terms of whether RICO's predicates have been met, that issue is not on appeal before this court. I think you treat that as true. And so really the only question is, can a multi-year campaign be an act in the context of this statute? And we've explained why in our brief we think it can, but again, I think Halberstam provides the answer. Judge Pillard, I think your question is a clever one, and I think you can also incorporate this concept into count 1 for the reasons you described. That this is a factual question, and you'll find some support for that in the Second Circuit's Kaplan decision and in the Ninth Circuit's Gonzalez decision, which both took care to define the act assisted, the principal violation, not as the individual bomb going off that injured the plaintiffs, but the broader terrorist enterprise perpetrated by the person that the defendants aided. And so I think those cases also provide some ammunition, Judge Pillard, to write the opinion in the way you were just suggesting, if you were inclined to go down that route. I see.
If act of terrorism is.
Sorry, Judge Wilkins.
If act of terrorism is defined that broadly, and planned is defined broadly to include basically training, which is the way that it appears that you're arguing this, then it would appear that even in circumstances where kind of the FTO is kind of in the background, maybe years in the past, involved in training someone who goes out and commits an act of terrorism. And even if that's not really very apparent or publicly known, there's going to be aiding and abetting liability.
Well, Judge Wilkins, sort of a nexus between the training and the attack. So, for example, we don't plead any of these claims, but let's say there was a suicide bombing in Iraq that Jaish al-Mahdi conducted to blow up an American. Hezbollah training them how to use penetrators doesn't have a nexus to that attack, so I don't think that would constitute planning. But the other point that I think should address your concern, Judge Wilkins, is go back to my specific intent point, that the FTO has to be doing it for the purpose of causing the type of terrorist attacks at issue. And I think that's been pleaded here in spades. And Judge Wilkins, to your question about whether it's publicly known or not, the FTO's role, that's not an element of the statute. There's no suggestion that a defendant has to be aware of the FTO's role. It's just they have to be aware that they're assisting a person, a terrorist group that's committing acts of international terrorism. And to give you, Judge Wilkins, an example, something that's outside the line, look at the only case that my colleagues and Judge Leon cited, the Sixth Circuit case from the Crosby versus Twitter case. Lone wolf shooter that shot up a nightclub in Orlando, Florida, the Pulse nightclub, never had any contact with ISIS, wasn't part of ISIS. ISIS didn't train him, didn't give him anything, didn't authorize the attack, didn't say anything to legitimize it. that's an example of something that our theory of the statute would still rule out. But I would encourage the court not to treat the planning and authorizing element as though Congress intended that to substantially circumscribe the scope of the statute. There's no textual or structural evidence that that's the case. And if you look at Congress's declaration of purpose in the Justice Against Sponsors of Terrorism Act, there's no reference to foreign terrorist organizations, and the Congress has declared that its purpose is for this to sweep broadly. So, the fact that this might cover lots of terrorist attacks, that's a feature, not a bug of our interpretation. Because remember, a defendant is only liable if they aid and abet the terrorist group, and if they're generally aware that by doing so, they're playing a role in illegal activity from which terrorism is a foreseeable risk.
I missed what you just said. You said there's nothing in the JASTA reports or whatever referring to foreign terrorist organization, but in the text, there's a requirement that the act be committed, planned, or authorized by a foreign terrorist organization. And it's striking that even though aiding and abetting is typically easier to meet, in this statute, the aiding and abetting provision has this requirement that's not in the direct liability part. So it does feel like it is a narrowing or boundary setting provision.
There's no question it's boundary setting, and I'm not suggesting that the court should treat this as not an element. It is. But I was attempting to address Judge Wilkinson's specific point, which is when you're interpreting the words planning and authorizing, which I submit are very broad words, the court should not be thinking about this from the perspective of we have to really narrow this to a very limited set of attacks. That is not, there's no evidence that that's what Congress wanted this limitation to do. I would submit that what Congress wanted this limitation to do would be to rule out the lone wolf shooter type situation, the Crosby case that the defendants cite. And so you're absolutely right, Judge Pillard. I'm not suggesting read the element out of the statute. It's an element, we have to meet it. But these words on their own, it's not as though my friends on the other side or Judge Leon defined the word plan and authorize in a way that limit out our attacks. I mean, we've defined the words. We basically all agree on what they mean. The question is just how do you apply them to terrorism? And I would suggest, in light of the statute's purpose, that if there's any question about that, the court should not be looking to limit this to attacks that actually look like they're committed by a foreign terrorist organization, because that would be atextual, and I think that would do violence to Congress's purpose, as again, not to beat a dead horse, but as I think very persuasively explained in the commander's amicus brief.
I'm sorry, I know we've kept you a long time, but I'd appreciate it if you could address personal jurisdiction over the foreign defendants.
Thank you, Judge Pillard. The foreign defendants purposely availed themselves of the United States by sourcing U.S. drugs, by working with their U.S. affiliates, by procuring U.S. documentation, and by certifying the U.S. origin to their terrorist counterparties. I think there's no question in this posture that constitutes meaningful jurisdictional contacts. The question before this court is whether they are sufficiently suit-related to support specific jurisdiction. And after the Supreme Court's decision in Ford this year, I think that case confirms that test has been met. We know right out of the gate that Judge Leon applied the wrong legal standard. This is at JA 819, where he said that for contacts to be suit-related, the contacts need to be such that would expose the defendants to liability under the Anti-Terrorism Act. We know that's not correct now after Ford. A contact does not need to be tortious. It does not even need to be causally related to the claims in order to qualify. I think the question under Ford is whether the contacts demonstrate a meaningful affiliation between the forum and the controversy. And I think certainly in this procedural posture, taking our allegations as true, we have more than satisfied that burden. And I'll just make 3 points on that if I could. The first is that the US sourcing was not a coincidence. I know my friends in their brief repeatedly characterize it as happenstance or kind of accidental. That's not what we allege. The complaint alleges in detail for every defendant that the sourcing was a deliberate choice designed to be able to obtain these contracts in the first place and to magnify the value of the bribes being delivered to Jaish al-Mahdi. So that's the first point. The second point is that they were working with their US affiliates. The way these transactions worked is that it's not as though the foreign defendants in isolation handled the contract with no interaction with their US affiliates. We've alleged for every defendant that there were these what we call cross-functional teams, where the US manufacturer and the foreign supplier work in concert to fulfill these orders. And that is very much suit-related conduct. And then the third point is something—
Was that alleged for all of the manufacturer defendants as opposed to the supplier defendants?
Yes, Judge Wilkins, it was. So the manufacturer defendants, just to be clear, those are all American companies. So the manufacturer defendants there's not a jurisdictional question pending before this court, I suppose, other than the pendant jurisdiction question for state law that I think my friends and I agree on. But the manufacturer defendants are US companies, and they are not raising the personal jurisdiction challenge. So we're only talking about supplier defendants. And for the supplier defendants, yes, the answer is yes. We've alleged it for every defendant that they worked with their US affiliates. And I think, Judge Wilkins, your question is a good one, because it brings me to my next point, which is, at a minimum, we should be entitled to jurisdictional discovery. This court has made clear many times, most recently in the Urquhart-Bradley case, that where the plaintiffs can show they may be able to supplement their jurisdictional facts, the court should liberally grant jurisdictional discovery. And we asked for that before Judge Leon. He did not respond. So,
and you want contracts? What is it that you want for jurisdictional discovery?
We want contracts, and we want the contract-related documents that go to this question. All of the factual inferences that are being debated in the personal jurisdiction section, we want discovery on. So, for example, how material was the U.S. sourcing to the contracts? That is a question that I think discovery could answer. Did the foreign suppliers, to Judge Wilkins's question, did they in fact cooperate with their U.S. affiliate manufacturers in fulfilling the contracts? We would want discovery on that as well. And just as a very basic matter, we want to see all the contracts themselves. One of the problems with what Judge Leon found was that some of the defendants, GE Healthcare, submitted no evidence whatsoever. Roche, to take another example, we alleged 4 contracts in the complaint. They submitted a declaration attaching 2 of the 4 and said nothing about the other 2. Yet Judge Leon, with this factual record, drew sweeping factual inferences, in my view, about whether the US sourcing was or wasn't material. And I would submit you can't even start to answer that question until we have all of the contracts.
And your theory that it was material, and when you talk about the connection to the tort, is, as you said, that it enhanced the value of the goods, it increased the ability of the defendants to get the contracts. What other meaningful affiliation are you referring to?
So, Judge Pillard, I think those are the most important 2. I would add a third, which is that the bribes were given in violation of a U.S. federal statute and injured American citizens who felt injury in this forum. And I think that is a very relevant question that goes to the affiliation between the forum.
And that's FCPA. And what's the status of those cases?
Well, I'm sorry, it's not an FCPA issue, Your Honor. I was referring to the Anti-Terrorism Act, that Congress in Section 2A6 of the Justice Against Sponsors of Terrorism Act made a finding that these types of cases are vital to U.S. national security. And so I think, of course, my friends say that's all irrelevant because that's just Congress trying to wish away a constitutional provision. But that's not true. I think if you read Ford, you'll see the Supreme Court placed quite a lot of weight on Montana's interest in hearing the controversy. And I would submit you're rarely going to find a civil lawsuit in which the forum's interest is stronger than in this one. Now, Judge Pillard, you asked me, I think, about the status of the FCPA criminal investigation. I believe that's what you were asking. I don't have a lot of visibility into that. I don't know. I know the defendants have said that it's been closed. What I can tell you is my understanding is that the key time period of our case, 2004 to 2008, was outside of the limitations period that I believe DOJ was working with under the FCPA. I think they might have had, there may have been issues with the beyond a reasonable doubt evidentiary standard. There may have been issues of prosecutorial resources. I just don't know. But what I do know is that Congress intended the Anti-Terrorism Act to provide a supplement to criminal enforcement. And whatever DOJ may or may not have decided about these allegations, I think should have no bearing on this court's decision about whether we have pleaded a cause of action under the Anti-Terrorism Act.
To the extent that your theory relies on notions of agency as between manufacturing defendants and supplier defendants, or even in Iraq, what law do we look to? You cite the restatement. Isn't there a complicated choice of law question there?
I would submit it's U.S. law because this claim arises under the Anti-Terrorism Act. So I cited the restatement because I thought general U.S. common law principles provide the best answer to that. Judge Pillard, to go back to one of your earlier questions, I can confidently say I think this one is not a question the court should reach in this posture. My friends devoted literally a half of a sentence to it in their brief. And if the court actually wanted to hear argument about whether the suppliers were agents of the manufacturers, we would have a lot to say. I don't really think that's a question the court should reach. But if you are inclined to do it, I would submit U.S. law is the place to look. I see I am very far over my time, so of course I'm happy to answer any other questions, but otherwise I'm happy to rest.
My colleagues have questions for Mr. Branson?
No.
Thank you. We did go over your time, but we will give you a short amount of time for rebuttal.
Thank you.
Mr. Shammigan.
Thank you, Judge Pillard, and may it please the court. Taking plaintiff's allegations is true. The district court correctly dismissed the complaint for failure to state a claim. At the request of the United States government, defendants stepped forward to help rebuild Iraq's nationalized healthcare system after years of neglect. Defendants manufactured or supplied life-saving goods to Iraq's Ministry of Health at a time when the United States government and many others were providing similar support. Yet plaintiffs in this case allege that by providing their goods to the ministry, defendants were knowingly supporting armed attacks on American soldiers by the Mahdi army, which stole those goods from the ministry. Plaintiffs have failed to state a valid claim for direct or aiding and abetting liability under the Anti-Terrorism Act, and they cannot cite any case permitting an ATA claim to proceed on even remotely similar facts. As to direct liability, plaintiffs' claims fail first because defendants' transactions with a legitimate sovereign ministry do not establish proximate causation under this court's decision in Owens 4, and second, because the supply of medical goods does not constitute a violent terrorist act, in the words of the statute, an act of international terrorism. And as to aiding and abetting liability, plaintiffs' claims fail first because defendants did not provide substantial assistance to the Mahdi army, and second, because defendants were not aware of their role in terrorist activities. In addition, plaintiffs' claims are barred by the statutory act of war exclusion, and they cannot establish personal jurisdiction over the foreign defendants. A contrary decision would have a severe chilling effect on the willingness of companies and non-governmental organizations to conduct essential activities, often at the government's request, in troubled regions. The district court correctly dismissed plaintiff's complaint, and its judgment should be affirmed. Now, I'd like to start, if I may, with direct liability and then proceed to aiding and abetting liability. As I mentioned, there are really two issues here: proximate causation and the requirement that there be an act of international terrorism. On proximate causation, I think our submission is quite straightforward. Under this court's decision in Owens 4, which is consistent with the law of numerous other circuits, the presence of a legitimate sovereign intermediary breaks the causal chain. And the real relevant question for purposes of this analysis is whether that government entity was performing legitimate sovereign functions. Now, in this case, there's really no dispute that that is true, and we know that from the allegations of plaintiff's own complaint. In paragraphs 2 and 72 of the complaint, which can be found at pages 97 and 121 of the joint appendix, Plaintiffs allege that the Ministry of Health was responsible for administering Iraq's system of socialized medicine. And there's no suggestion that the ministry was simply acting as a front for a terrorist organization.
Mr. Flanagan, under Owens 4, even if you have an independent intermediary, that just raises the need for a robust showing of proximate cause. It doesn't give an immunity anytime you have an entity that might have some legitimate function. Isn't that right? And the district court didn't go on to analyze that, but did just treat the governmental character of the Ministry of Health as a block to any finding of proximate cause. It isn't even just that under the terms of Owen 4 incomplete.
Judge Pillard, I think it's fair to say that the court in Owens 4 left the door slightly ajar. The court said that where the intermediary is a sovereign state, the need for additional allegations supporting substantiality, a substantial connection, is all the more acute. And our fundamental submission, and I think this is a fair reading of Judge Leon's order, is that the allegations here are simply insufficient to meet that high bar. We simply don't think that the allegations in the complaint match up to this characterization of the ministry as acting simply as a front or alias for Jaish al-Mahdi. At most, the complaint alleges that affiliates of Jaish al-Mahdi infiltrated the ministry, that some of the officials in the ministry were acting as agents of Jaish al-Mahdi, and the Jaish al-Mahdi or the Mahdi army was certainly using the ministry as an instrument in some instances to commit terrorist acts. We take all of that as true, but our fundamental submission is that that is not enough to make this like a case where you have, say, a charity that is acting as a front for Hamas or Hezbollah.
This is a very different situation from those in which you have a nation state that is the independent intermediary. And that's, I guess, Owens 4, Kaplan, where that I think your brief is leaning on, where it's a nation state, it's a government of an entire country. And the notion that that by being a state sponsor of terrorism, it is somehow equated with the terrorists that it supports, that seems to me a much more challenging obstacle to a finding of probable cause than, as alleged here, there is, even if you don't believe a full takeover and that there's some, provision of healthcare to people who are not anathema to the JAM affiliated folks who control the ministry. So they may be providing some legitimate healthcare, but this seems quite different from the cases on which Judge Leon relied, in the sense that as alleged, there's a major sort of terrorist function that's being sponsored. So I just, are there other cases or other ways that you can help us think about why, nonetheless, the agency character of the Ministry of Health should prevent a finding of approximate cause? Because that's the only holding really that Judge Leon made.
Judge Pillard, I would flip that around and respectfully submit that if anything, this case is a weaker case for the reasons you identified. And let me explain why that is so. You are certainly right to note that in the other Court of Appeals cases that address this issue, the intermediary is typically one that has been designated as a state sponsor of terrorism. And indeed, in many of those cases, you have defendants who are actually evading sanctions regimes in order to transact with those foreign intermediaries. And yet courts have still said that that is insufficient. By contrast here, you have a government ministry, and there's no dispute that it's a cabinet level ministry within a sovereign government, but it's one that is actually being supported by the United States government during the relevant time period. And I would note parenthetically, because my friend Mr. Branson at argument, as in his brief, sort of strains to say that the United States government was somehow not supporting the ministry during this time period. I think that the allegation in paragraph 113 suggests otherwise. And to the extent that Mr. Branson is trying to insinuate that the United States government was dealing, only through other means, that it was not transacting with the ministry, I do think that that is belied by the government reports on which we rely at page 31 of our brief, and on which this court certainly can take judicial notice, that indicate the United States government was providing millions of dollars of support to the ministry and encouraging the defendants to transact with the ministry, which accords with the common sense reality here, which was that the United States government, in the immediate period after the fall of Saddam Hussein, was attempting to once again stand up the Iraqi healthcare system. But leaving all of that aside, Judge Pillard, even if you disagree with everything that I've just said, you're left with the fundamental problem that Judge Wilkins identified in his colloquy with my friend, which is that if you think that the plaintiffs here have sufficiently alleged that the ministry was somehow, a front for or an alias or an agent of the Mahdi army, you're left with a fundamental problem that the logical consequence of that would be that the United States government and anyone else, the United Nations, whoever else, who dealt with the ministry would somehow be responsible for proximately causing these attacks on American service members. Now, I think in an effort to avoid that implication, what plaintiffs are trying to do is to suggest, well, this is different because there is corruption involved, because the supplier defendants here somehow structured their transactions in a way to provide free goods to the ministry or bribes to Mahdi army terrorists. Now, I would vigorously dispute the characterization that the allegations here support corruption. And indeed, as Mr. Branson acknowledges, and as we point out at footnote 2, to the extent that the Justice Department was investigating those allegations, it has indicated that it does not intend to go forward with any further investigation. But leaving all of that aside, this is not an FCPA case. The question here is not whether corruption was taking place or even whether defendants knew that corruption was taking place.
Under Halberstam, though, it seems actually that our circuit has viewed, other illegality as relevant to the question, at least of aiding and abetting. I mean, in a way that on reading might even seem somewhat shocking that knowing about someone's apparent burglary makes you liable for murder. So I think, what's the pushback on that analog, which
that goes
Congress
to the question
has clearly embraced?
Yeah, and Judge Pillard, I want to be very clear about how I'm signposting the issues here, because they are obviously discrete. I think that goes to the issue of state of mind, both as an element of substantial assistance and also as a standalone requirement for aiding and abetting liability. My point here is simply that, that to the extent that plaintiffs are attempting to rely on these allegations of corruption as an effort to sort of get around the fundamental problem with their corruption theory, it just doesn't work here, because there are insufficient allegations that this is a case where what was taking place was that defendants were somehow supporting Jaish al-Mahdi directly. I want to say just a word about the allegations in the complaint, because this is such a central part of plaintiffs' argument. With regard to the free goods, the complaint actually at numerous points alleges that the free goods weren't even distinguished from other goods. And so, it's a little bit unclear exactly how the plaintiffs can allege that the free goods somehow were going directly to JAM and were bypassing the ministry. Indeed, the complaint itself alleges that this was actually a common practice, that to this day it still appears on the standard bid instructions. And as we explain in our brief, it's a common practice more generally as a way simply of providing a discount from the reference price for drugs that are being provided.
Although they would dispute that a discount from the reference price is something that's quite different and doesn't facilitate the evasion of inventory controls, such to the extent that there were any. That's a different move on the part of defendants.
To the extent that that's true, though, I think the plaintiffs still have the problem that in paragraphs 120 and 123, and I would note that the complaint is no model of clarity on this point, But at various points, the complaint suggests that the free goods were not being distinguished from other goods. And so to the extent that what plaintiffs are trying to do is to suggest that somehow free goods are going directly to JAM, I don't think their allegations get there. But I want to really
the
focus.
way, just reading in the light most favorable to the plaintiff, I take them to be saying they're packaged all together. They arrive in a way that doesn't, that they travel in a way that doesn't single some out. In fact, on their telling, Jaish al-Mahdi has free play on the receiving end and can sell even things that doctors have said they need, sell them on the black market. But it's really, I think, a way for them of saying, maybe we would have a case if only the amount ordered were being sent, because the defendants knew or should have known that this was not a Ministry of Health, but a terrorist hotbed. But at least where they are sweetening the pot and sending goods that aren't, they're over and above, they're basically engaging in bribery of bad actors who they know will use that money for ill.
Well, a further problem with that, Judge Pillard, is that I really don't hear plaintiffs to dispute that their whole theory here is that these goods were being provided to the ministry. And then at that point, they were being looted or stolen, or whatever verb you want to use, by ministry employees who, in their view, were typically JAM agents. And that just underscores the fundamental causal problem with their theory. And before we get off this subject entirely, I do want to specifically address the allegations concerning bribes, because that was where my friend, Mr. Branson, started with his very first sentence. And those are obviously, the most lurid allegations in this complaint. And I think Judge Leon correctly found.
Oh, I don't know. I think there's some other allegations that have a higher claim to being lurid, but go ahead.
But can I say one thing about these so-called bribes, which is that Judge Leon, I think, correctly determined that there were simply insufficient allegations of that. And the one specific example to which plaintiffs point are these transactions by GE Healthcare, which plaintiffs rely on both in their opening brief and in their reply brief, these so-called $6 and $10 million bribes. I would invite the court to look at the relevant paragraphs of the complaint, and particularly paragraph 214 at Joint Appendix 188. The complaint does not allege a $10 million bribe. It alleges that there was a contract worth $10 million that, quote, caught the eye of investigators, and that the contract was linked to GE, quote, on information and belief. And I think that there are sort of analogous deficiencies with the allegation concerning the $6 million bribe. But I think that in fact, if you look at that paragraph, it's not alleging a $10 million bribe.
It actually is quoting a source saying of Dr. Zabili, saying that Dr. Adel took a $6 million bribe from a foreign company. All right. I mean, that's just what it says.
Yes, on contracts that one confidential witness understood to concern GE Healthcare. And so there I'm not disputing
but there is an allegation of a $6 million bribe from a foreign company.
Correct.
But pretty straight up.
But I think that the link to GE Healthcare there is fairly spare. And again, I make the point simply to sort of underscore, and the overarching point with regard to the so-called bribes, Judge Pillard, is that there's no dispute here that the complaint itself, and this is in paragraph 145, but also in paragraph 142, alleges that payments were made to Ministry of Health officials who were at most also members of JAM. There's no suggestion that payments are going directly to JAM. Now, I don't want to consume the entirety of our time on this one issue, but I'm content to sort of rest on the fundamental proposition that to the extent that this court left the door open to the possibility that there might be sufficient allegations in a case involving a sovereign intermediary, our fundamental submission is that these allegations simply don't meet that high bar. Now, I do want to turn to the act of international terrorism requirement, because a number of you had questions about that to my friend, Mr. Branson. And I think that while Judge Leon did not rest on that ground, Mr. Branson acknowledged that that's a pure legal issue that I think this court could comfortably resolve. And our fundamental submission on this is fairly straightforward. The definition of act of international terrorism is really meant to differentiate between conduct that can constitute primary or direct liability and conduct that can constitute secondary or aiding and abetting liability. And an act of international terrorism under section 2331(1) has to satisfy two requirements. First, it has to be a violent or dangerous act. And second, it has to be an act that an objective observer would conclude was intended to intimidate or coerce a civilian population. There are other potential intents, but that's really the relevant one here. And I think with regard to these sorts of claims of providing effectively material support, that these are at most fits for secondary liability and not primary liability. And the case on which Mr. Branson primarily relied today, as he does in his briefs, for the contrary view is the Seventh Circuit's decision in Boehm. Now, I think that opinion is frankly a somewhat confusing opinion. And I think it's fair to say that the court in that case seemed to really be straining to find a way of characterizing the conduct as primary liability because aiding and abetting liability was not yet available. But as the Seventh Circuit in Judge Wood's very lucid opinion in Kemper explained, that was a case in which the defendant was making a direct donation to a known terrorist organization. And that's obviously not the case here. And I think with regard to the objective intent requirement, all I would say is that the only thing that the complaint alleges is that the supplier defendants had a commercial motive, namely to grow their market share in Iraq. And I would once again point to Judge Wood's, very thoughtful opinion in the Kemper case, which held that very similar allegations were insufficient.
But a commercial, again, I'm just thinking about, the logic of these tort doctrines, like independent intermediary, it seems to me that one can concede that there may be some independence or some non-terroristic function going on at the Ministry of Health, and it might even be the intent of these defendants, the dearest wish that whatever they're doing stays within that lane. But, if there's a huge amount of terrorism also being sponsored out of that building with that staff, is the independent intermediary doctrine really applicable? That's one question. And then parallel with the commercial motive, sure, of course, these entities, these defendant entities are businesses, and they can say, look, we just want to do business. But is that a block against liability? Is that a defense if they're willing to exercise the commercial motive in a way that is knowingly providing support to terrorist organizations? And clearly not. So the fact that the recognition that there may be a commercial motive, or the recognition that there may be some sovereign function that even the plaintiff's complaint seems to acknowledge, I guess the question is, that legally, can we at the complaint stage categorically kind of lean on that, or to what extent can we, and why?
So I think with regard to the act of international terrorism requirement, and Judge Pillard, I think we're really talking now about the second component of that, the objective intent requirement.
Are you talking about appears to be?
Yes, that is to say, the requirement that the act be one that, in the language of 2331(1), appears to be intended, and I'm ellipsizing some language, to intimidate or coerce a civilian population. I think that is something that the court can determine as a matter of law, as again, I think Mr. Branson acknowledged. And I think here our submission is quite straightforward, which is that transacting with the ministry is not an act that is intended to intimidate or coerce a civilian population, and not one that an objective observer would think was intended to have that effect. And again, you have to satisfy both requirements to have an act of international terrorism, and the act here simply was not an act that is violent or dangerous to human life. And that's why I think aiding and abetting liability would ordinarily be a more natural fit if the plaintiffs could satisfy the requirements for that. And the only other thing I would say on primary liability before we move to aiding and abetting liability is that I think with regard to the causation analysis, the manufacturer defendants do stand at a further causal step removed from the supplier defendants. And there simply are not allegations in the complaint, non-conclusory allegations in the complaint, to support the notion that the supplier defendants were acting as the agent for the manufacturer defendants. And so I think at a minimum, if this court were to disagree on primary liability, it should at least make that clear and make clear that the manufacturer defendants were
properly. Do you have a view of what source of law applies? I mean, it seems, just in common sense parlance, it seems pretty clear that if you're a manufacturer and you want to sell to a market, you work with a supplier to send your stuff there. I mean, it doesn't have to be day-to-day control in every aspect. We're not talking about a general agency to act in all respects. We're talking about the manufacturer is getting these specific goods to these specific customers. Is there really any question that the suppliers are their agents for that purpose?
I don't think I would disagree with Mr. Branson's suggestion that this is governed by restatement type principles. My point is simply that the complaint, again, and we set this out in our brief, doesn't really contain any non-conclusory allegations of that. And there's undoubtedly, we're talking about proximate causation here, so there's undoubtedly a further causal step that would have to be satisfied as to those defendants. I do want to turn
you were going on. Yeah, go ahead. You were going.
Yeah, I do want to turn to aiding and abetting liability because, while I said a second ago that I think that would otherwise be, a natural fit if the requirements can be satisfied. Of course, our fundamental submission is that there are two basic requirements that haven't been satisfied here. First, the substantial assistance requirement, and second, the general knowledge requirement. As to substantial assistance, we believe that Judge Leon correctly applied the Halberstam factors, which are, of course, incorporated into the ATA under JASTA. And I want to try to simplify the analysis here, because I think whenever a court has a multi-factor test like this, it can turn into a morass fairly quickly. I think I would try to categorize the factors here, into three. The first is the nature of the act and the kind of assistance. The second is the presence of defendants and defendants' relationship with the perpetrators. And the third is really the defendant's state of mind. I think with regard to the kind of assistance, plaintiffs really tried to run from the language that this court used in Halberstam. But the court repeatedly referred to whether the injurious act was heavily dependent on the alleged assistance, whether the assistance was essential or important to the illegal activities. Clearly, that was true in Halberstam itself. There's no question that Hamilton played an essential role in the overall criminal enterprise. But here there is no, but the whole point, of course, is that is not required as a matter of secondary liability. And this court, I think, correctly drew on principles from the aiding and abetting and the conspiracy context to say that you don't have to play a role in every single act of the criminal enterprise. Whereas here, there is an obvious mismatch between defendants' transactions and the Mahdi Army's terrorist acts. And the complaint really doesn't allege that defendants' transactions intensified the terrorist campaign. Indeed, the complaint itself alleges that Iran supplied the Mahdi army with its weapons. And so, again, I'm willing to acknowledge that that the plaintiffs don't have to show that the terrorist activities would not have taken place absent the assistance. My point is simply that this court has said that the conduct has to be important, essential, that the injurious acts have to be dependent on that assistance, and plaintiffs can't meet that requirement here. And I think with regard to the second category of factors, the presence of the defendants and defendants' relationship with the perpetrators, I think plaintiffs all but concede that those factors favor the defendants. And that brings us to the defendant's state of mind. And I think here, once again, the plaintiffs are really struggling with the language that this court used in Halberstam. This court said that the defendants have to be one in spirit with the perpetrators. And while plaintiffs, I think, try to sort of file that down to a very generic knowledge requirement, that is language that courts in engaging in the substantial assistance analysis have routinely relied upon. And there's obviously no dispute here that defendants did not share the Mahdi Army's intention of harming American service members. Now, we think that the complaint fails plausibly to allege even knowledge, and I'll get to that in a minute. But I think for purposes of the substantial assistance analysis, this court in Halberstam was really, I think, drawing on principles in other contexts such as conspiracy to say that the real question is, does the defendant share the aims of the enterprise? And in applying that requirement in the Halberstam case, the court concluded that the defendant Hamilton's knowledge, quote, evidences a deliberate long-term intention to participate in an ongoing illicit enterprise. And so, Judge Pillard, while Hamilton may not have specifically intended that the murder be committed, the court nevertheless found that that factor weighed in favor of a conclusion that there was substantial assistance.
But even in a criminal case where a defendant is subject to aiding and abetting liability, let's suppose aiding and abetting first-degree murder, the government, the prosecution doesn't have to prove if I hand a knife to someone and then that knife is used to murder someone else, they don't have to prove that I had premeditation and deliberation, kind of the same intent required of the principle. It's something less that the government is required to prove. And so saying the kind of one in spirit language in Halberstam, I mean, we can't take that too far, right?
I think that's a fair point, Judge Wilkins, and I don't think I would disagree with something that the plaintiffs said in their brief, I believe in their reply brief, which is that, you know, this is something of a sliding scale. This is, after all, a multi-factor inquiry. I just don't think that it's a one-way ratchet. In other words, I think that the absence of a shared intent here is significant. That's a point that other courts have, I think, attached significance to in engaging in the substantial assistance inquiry. It certainly isn't dispositive. And of course, you know, our submission is that to the extent that knowledge is sufficient to meet the independent state of mind requirement, that the allegations here fall short of the required level of knowledge. And I'm happy to turn to that because I do think that.
Yeah, I mean, that might be helpful. My question when you were characterizing Halberstam is it just seems that, you know, you're going to have situations in which you have corporate defendants, which frankly are really in it for the buck. And they're, you know, so they're not, you know, a deliberate long-term intention like the domestic partner of a criminal. No, it's not really a perfect fit. But the fact that they're really in it for the buck doesn't get them off the hook, where they're willing to go after that buck in a way that really is heedless to an ongoing, I mean, as alleged by these plaintiffs, an ongoing, obvious, open, violent, you know, campaign of terrorism. It's like, you know, not our problem. And then sending along the support. And so I guess if that were proved, and I know that your position is that these allegations don't rise to the level of even the way Mr. Branson would characterize them, but if you did have a case that presented a corporation in that position, you wouldn't be limited by Halberstam in the way you just described, would you?
If you had allegations that rose to that level, Judge Pillard, and I really don't think that the allegations in this complaint rise to that level, but if you did, it would obviously be harder for a defendant in those circumstances to make an argument that the requisite state of mind didn't exist. But let's go right to the state of mind requirement, because I do think that that provides an independent way of disposing of the aiding and abetting claims here. Now, first, what is that requirement? In our view, the proper understanding of that requirement is that a defendant has to be aware that it was playing a role in terrorist activities. Where do we get that from? We get that from the language of Halberstam itself, which says that a defendant must be, quote, generally aware of his role as part of an overall illegal or tortious activity at the time he provides the assistance. Now, I think the proper understanding here is that the relevant activity, the relevant illegal activity, is the terrorist activity. Now, my friend Mr. Branson relies on some language from the Second Circuit's recent opinion in Kaplan, where the Second Circuit slightly modifies that and says that a defendant may be liable if it was, quote, generally aware of its role in an overall illegal activity from which an act of international terrorism was a foreseeable risk. Now, I think that that's probably a somewhat imprecise gloss on the relevant statutory language. I really do think that the illegal activity is the terrorist activity. It certainly has to be the activity of the alleged perpetrator. But even if you accept that gloss, we think that that requirement is still simply not satisfied here. And I want to go directly to the sources on which plaintiffs rely for the alleged knowledge. Now, I think at bottom, plaintiffs are really relying on three things. They're relying on press reports, they're relying on visual cues, and they are relying, once again, on the allegations of corruption. Now, with regard to the press reports, we address these at some length in our brief at pages 54 to 55. Our fundamental submission is that there were no allegations of diversion of resources in the public domain at all until 2007, when the Deputy Ministry of Health was arrested. And I think even at that point, I think that the fair inference from the press reports was that the government was dealing with the issue of militia influence. But our submission is that these sorts of press reports are simply not sufficient to get to general awareness of the role in terrorist activities. And I would point this court to two Second Circuit opinions, the Siegel case and the Honigman case, for the proposition that these sorts of press reports in and of themselves are not enough. Now, as to, and I would note parenthetically that to the extent that Mr. Branson today relied primarily on a U.S. Embassy report for this proposition, this is at Joint Appendix, I believe, 123, that report isn't really helpful for scienter purposes because they're citing an internal U.S. government document that doesn't even appear to be available publicly. It's marked sensitive but unclassified. Leaving that aside, let's get next to the visual cues. And I think on the visual cues, our submission is that even if the complaint alleged that defendants' own employees actually visited the ministry, and the most of the complaint alleges is that some scientific bureaus that were allegedly agents of the defendants visited the ministry. But even if they did visit the ministry, and even if they did see these posters, that would not be enough to put defendants on notice that the Mahdi army was stealing and selling medical goods and using the proceeds to finance terrorist attacks, once again, particularly given that this was a time period during which the United States government was providing support. And to the extent that there are, allegations that there was a room with AK-47s in it, there's no allegation that anyone went to that room during the relevant time period. And so again, our submission is that these allegations of state of mind are weaker than those in other cases where the court has said that state of mind is insufficient. In the Siegel case, the defendant bank was aware of public reports of an organization's linked to terrorists, and indeed the bank itself was committing sanctions violations. And the court still said that that was insufficient to satisfy the general awareness requirement. And again, to the extent that plaintiffs point to the allegations of corruption more generally, the most that could be said is that would suggest, and I don't think it sufficiently does, but even if it were, the most that it would do is to suggest that defendants were aware of corrupt practices at the ministry, and not that defendants were aware that they were playing a role in terrorist activities. So I think that to the extent that the court has any concern about affirming on the ground that there was not substantial assistance here, and I do think Judge Leon's analysis of that was correct, the court can affirm on the ground that the state of mind requirement here was not satisfied.
Why do you think on the aiding and abetting that this case can be properly, assuming we're bound, can be properly distinguished from Kaplan? Kaplan distinguishes Siegel, so I'm not persuaded that your analysis of Siegel is in any way dispositive. Kaplan is a very strong statement against your position.
So
you and those on that side of this world cheered by the Second Circuit decisions before Kaplan. Judge Kears really whacked you away on a lot of these questions on aiding and abetting. How can you distinguish? If I'm persuaded that Kaplan's right, at this point, what would your response to me be?
I think I would respectfully say, Judge Edwards, that this case is more like the cases that preceded and followed it, Siegel and Honigman, and less like Kaplan. And that is because in Kaplan, you know, the party with whom the defendant was transacting was, you know, persons who were known to be, in the words of the court, integral parts of Hezbollah, and who were so closely intertwined with Hezbollah's violent activities that one could reasonably infer that the bank had general awareness. And again, as we discussed earlier in the argument, I don't think that the allegations here rise to that level. And so we don't dispute that Kaplan came out correctly. Our view is simply that this case is more like the cases where courts have said that allegations are insufficient.
Mr. Shanmugam, I mean, you know that, and this is a very, very tough issue for courts because of the, you know, the tremendous burdens of discovery. But, you know, when there are allegations of state of mind, it's pretty hard to be, you know, super definitive at the pleading stage about what your opposing parties knew, what kind of due diligence they did, what they uncovered when they did that due diligence, to what extent they were actually acting reasonably and really unaware, or to what extent they were on notice and putting their heads in the sand. And so, you know, and I, as I said, I recognize that these are very difficult and frankly, issues that are hard to resolve in a satisfactory way because of the implications of opening the door to that kind of inquiry. But if the law is making state of mind relevant, consistent with the law, you think we can nonetheless demand more at the pleading stage?
I don't think we're asking you to demand anything more, Judge Pillard, but as I think your question reflected, courts have not hesitated to dismiss these cases at the motion to dismiss stage, including on the issue of knowledge with regard to aiding and abetting claims. And indeed, the Siegel case and the Honigman case are both examples of that. And if a court applying the plausibility standard concludes that the plaintiff's allegations are insufficient, I do think that that is the right thing to do, particularly given the burdens of this type of litigation and the potential for really a challenging discovery. But the only other thing I would note with regard to state of mind here generally is that I think the issue of state of mind here has to be read against the backdrop that makes this case so fundamentally different from all of the other cases that we've been discussing. Namely, that during this time period, the United States government, far from labeling the Iraqi Ministry of Health somehow problematic or the equivalent of a state sponsor of terrorism, far from labeling Jaish al-Mahdi as a foreign terrorist organization, was providing support for the Iraqi Ministry of Health and indeed encouraging defendants to do so. And
you started your argument, Mr. Shanmugam, saying that these defendants answered the call of the United States. They stepped forward at the request of the United States government. And your citation for that, I'm sure it's in the introduction to your brief, but you're relying for that on what?
On government reports, of which I think that this court can take judicial notice. And I would point the court to page 31 of our brief, where we point out that the United States government encouraged companies to supply the ministry and even contracted with some of the defendants to supply medical equipment for ministry facilities, citing a report from the Special Inspector General for Iraq Reconstruction. And, you know, again, I think that that is comfortably in the category of things of which the court can take judicial notice. Not
Maybe
least because,
so. I'm sorry, I didn't mean to interrupt you. Not least because?
Not least because this court has repeatedly said that it is settled that the court can take judicial notice of records that reflect the United States government's official position. And that's all that we're asking the court to do, I think, consistent with the familiar standard from Rule 201. And I think that that's a really pretty modest proposition for the court to take judicial notice of. And I would note that to the extent that the plaintiffs seek to supplement their third amended complaint in this case with amicus briefs to try to sort of cast doubt on the nature of the United States government's support, I think the amicus brief on which they rely stands at most for the proposition that some within the United States government were concerned with corruption at the time, as they were before, during, and after the relevant time period. And for purposes of the state of mind requirements, again, the question is, did defendants know that by transacting with the ministry, that they were potentially supporting terrorist attacks on American service members, and leaving aside the obvious implausibility that these defendants would want to do anything to endanger the lives of American service members, an allegation that is obviously, deeply upsetting to these defendants. The fact remains that that is the touchstone of the inquiry here for purposes of aiding and abetting liability, as it is for purposes of primary liability with regard to the objective intent requirement we were discussing earlier. I know that the time is...
I just want to add one thing. Both Kaplan and Gonzalez rely on news reports for general awareness. So, I don't think you can sweep them away as quickly as you're doing. They clearly are making findings. So you may disagree with them, but they certainly have adopted an approach. And you're right, the earlier cases were very grudging, but Congress has amended in willingness to find liability. But Congress has amended the statute and has tried to give very strong statements as to what their intended purpose is. The purpose of Congress is sweeping. But one other thing, I'm just curious on this government support. It's an interesting argument. Are you saying these are mutually exclusive notions, that is, the existence of government support and the support of terrorists? If you can find the existence of government support, you cannot find support of terrorists? Because you're trying to get away with too much.
No, I'm not trying to get away with
No,
anything.
I don't mean that in
There's
no bad intent, but that given the world in which we're living in now, I think you and I could agree over cocktails. Of course, there are situations where the United States is probably supporting a piece of this, and there were parts of the ministry that were perfectly okay in what they were doing, and there's a part of that group, the ministry and those with whom they're hanging out, are doing bad things. And so you can have both U.S. support and you can have support of terrorism, right?
So I would say three things in response to that. First, Judge Edwards, I am not trying to argue for that sort of a bright line rule. My view is simply that the United States government support is relevant to the analysis. Second, I take your point that plaintiffs now have two cases at the Court of Appeals level that have found allegations of knowledge to be sufficient, the Kaplan case and the Gonzalez case, which found allegations in part to be sufficient. But the allegations there were much more substantial. And in the Gonzalez case, with regard to the part of the claim that the court allowed to proceed against the social media companies, the court cited the fact that, quote, defendants allowed ISIS accounts and content to remain public even after receiving complaints about ISIS's use of their platform. So again, I think that the allegations there were more substantial. And my third point, and then I do want to turn briefly to Hezbollah and then personal jurisdiction, and I know that we've gone over time. But my third point, Judge Edwards, is that this brings us back in some sense to where I started, which is really the concern with permitting broad liability in contexts like this, where you have the United States government encouraging defendants to do business. If you permit liability under these circumstances, it is going to chill companies and non-governmental organizations from doing business in precisely the sort of troubled reasons that you were alluding to. If we were discussing this issue over your cocktail, we might be talking about what's going on right now in Afghanistan. You're going to have similar problems in other troubled areas of the world where parties are going to be concerned about potential liability for transacting with government entities. And that does actually bring us to the issue of Hezbollah, because the reason that there is a foreign terrorist organization requirement here is, I suspect, in part to provide some degree of clarity as to who you can deal with and who you can't deal with. And so while the foreign terrorist organization argument would not dispose of the entirety of the complaint in this case, because we acknowledge that there are at least some attacks as to which the complaint alleges some degree of involvement by Hezbollah, it simply can't be enough simply to inspire a non-FTO perpetrator or to train its fighters or even to provide weapons. If I say to you that it's a good idea to get married, no one would say that I was planning your wedding. even if I provided the ring to you, I don't think I could be said to have planned or authorized your wedding. And Judge Wilkins's example involving briefs is exactly right. While we would acknowledge that you could plan a campaign, that you could plan, a series of acts, there has to be a greater degree of involvement than simply inspiration or providing weapons.
Maybe that's planning a wedding is more complicated than planning the detonation of a penetrative missile.
Well, that may very well be true, but the mere provision of the missile is insufficient. And one thing we know is that Congress didn't use terms like material support. It required planning or authorization. And I think that tends to confirm that mere supply is not enough. Now, I do want to turn, because I know that we're well over time, just to personal jurisdiction in the last couple of minutes here, because I do think that should this court disagree with us on the merits here, that at a minimum, Judge Leon's dismissal on personal jurisdiction grounds was sufficient. Mr. Branson is certainly correct that the Supreme Court's decision in the Ford case makes clear that a causal connection is not required. But even in the wake of Ford, our fundamental submission is that there is an insufficient nexus between plaintiffs' claims and the presence of United States manufacturer defendants in the foreign defendants' supply chains. Now, plaintiffs have considerably narrowed their theory of personal jurisdiction on appeal. They're relying only on the allegation that the foreign defendants sourced from the United States some of the medical goods that they supplied to the ministry. But I think Judge Leon correctly determined that those forum contacts are incidental to plaintiffs' claims. The foreign defendants' liability here was rooted in their alleged misconduct in Iraq. It was not rooted in the sourcing of goods from the United States. Now, Mr. Branson suggested that Judge Leon got the legal standard wrong. I would encourage the court to look at the page that he cited. It's Joint Appendix page 818 or page 11 of Judge Leon's slip opinion. He does note that the plaintiffs do not allege that the foreign defendants' manufacturing or sourcing practices were themselves unlawful or could otherwise subject the foreign defendants to liability under the ATA, were it otherwise that would be sufficient to establish personal jurisdiction. But then he goes on in the next sentence. He doesn't stop there, and he says, nor do those practices constitute the suit-related conduct underlying plaintiffs' ATA claims. And that's the fundamental problem here. At bottom, plaintiffs are really relying on a single allegation. It's the allegation in paragraph 153 of the complaint at Joint Appendix 158. It is incorporated earlier, I think, in paragraph 121, but it's the allegation that the Soderus, quote, placed a premium on importing medical goods manufactured in the United States and Europe, noting that other goods were more likely to be counterfeit. That is simply not enough. And this case is a far cry from a case like the Lychee case, on which plaintiffs rely in their reply brief from the Second Circuit, where a U.S. bank account is really being used as the instrumentality of the relevant misconduct. And so we think that the mere fact that some of the goods were sourced in the United States is insufficient. And we don't think the jurisdictional discovery would affect the analysis, because the question here
almost sounds like, Mr. Shanmugam, you're going back to the causal test, because here there's no question that they were in fact sourcing vast quantities of goods from the US. And so it sounds like you're saying, well, their US-ness has to somehow be, their character as American goods, which, granted the plaintiffs have, as you say, also alleged that, but putting that aside, does it matter for personal jurisdiction, or is it required for personal jurisdiction that the American trade dress of these products be relevant to the terrorism allegations? Or is it enough that the suppliers are sourcing all of this stuff from the US?
So the question is there a tight enough relationship between the suit-related contacts, so here the US-related contacts, and plaintiffs' claims?
Yeah.
And our view is that even if you don't think about it in terms of causation, that the mere presence of US goods in the supply chain is insufficient. There's no dispute.
It's not mere presence. They're buying, they're taking US goods and and selling them in huge quantities I mean, they are the instrument of this support for terrorism allegation. These are American goods. These are companies that are, the suppliers are, benefiting in the selling of these goods in Iraq. They're benefiting from the protection of US contract law, from the protection of US food and drug law, from the protection of US intellectual property law. And all of these, that's how they make their business, is that they're selling US goods in other countries. And so I guess I'm missing why the potential, the questions that you raise about the terrorists particularly liking American goods, like put that aside. Is there a question about personal jurisdiction even if we didn't have those allegations?
Well, I think what we know, I think we can't say, how much of these goods were sourced in the United States. I think I take that point that on this record, we don't know the answer to that question. What we do know is that many of the contracts did specify other countries as the source of origin for the contracted goods. But our submission is that I think for legal purposes that doesn't matter. In other words, that the exact quantification, which seems to be what Mr. Branson would want from jurisdictional discovery, wouldn't somehow establish a tighter nexus between the United States and plaintiffs' actual claims here, which again do not depend in any way on the fact, as a legal matter, on the fact that the goods are being sourced from the United States. And so again, I think at a minimum, it is not the case that Judge Leon adopted a legal test that turns on the unlawfulness of the United States conduct. And because he applied the correct legal test, we believe that he in fact reached the correct result, and that is true even in the wake of the Supreme Court's decision. Unless the court has any further questions, I think I would just sort of close where I began. And it goes without saying that the defendants here condemn the attacks on U.S. service members in Iraq and sympathize with the plaintiff's plight here, with their desire to hold someone accountable for the injuries that they and their loved ones have suffered. But as Judge Wood said in her opinion for the Seventh Circuit in Kemper, this is a case in which my clients are simply the wrong defendants, and there's no valid legal theory on which they can be held liable, either as a matter of direct liability or aiding and abetting liability under the ATA. And unless the court has any further questions, we believe that the district court correctly dismissed those claims and that its judgment should be affirmed.
Thank you. Mr. Branson, if you would like it, you can have, given the length and the complexity of the issues, you can have 4 minutes for rebuttal. You're on mute.
Thank you, Judge Pillard. And Judge Edwards, I'd like to start with your question. You are exactly right about Kaplan. Judge Kearse rejected virtually every legal argument that my friends have made on aiding abetting liability. And Mr. Shane McGam attempted to distinguish it by saying that the intermediaries there were integral parts of Hezbollah. That's their argument. That was plaintiff's characterization in the complaint, sourced primarily to anonymous, undated websites. That is why the Second Circuit accepted that characterization. And I think all this court needs to do is compare paragraphs 78 to 79 of the Kaplan complaint, which were the basis of that characterization, with paragraphs 165 to 187 of our complaint. It's no contest who has more detailed allegations to draw the inferences that Judge Kearse properly drew in Kaplan. And I would just note that the lead intermediary in Kaplan was the Shaheed Foundation. The defendants argued vehemently, just like Mr. Shanmugam just did, that was a medical institution that built hospitals and provided medical services to orphans. That's what the defendants said in their brief. But the Second Circuit accepted the allegations in the complaint because it's a motion to dismiss. And if this court does that here, the logic of Kaplan, which I think is very persuasive, dictates a reversal. Mr. Shanmugam also said repeatedly that the US government encouraged them to do these transactions. There is not a shred of evidence in the joint appendix that says that. I'm happy to walk through every document that they've cited. I've read every one multiple times. There's no evidence of that. The best Mr. Shanmugam has is this vague spreadsheet from a Special Inspector General for Iraq Reconstruction report at JA, I believe, 691 to 96. Those are talking about direct US government contracts where the US ran the procurement and then supervised the installation of the goods and the services as part of its effort to rebuild Iraq's health infrastructure. And their own lead amicus in an interview given to the Special Inspector General for Iraq Reconstruction acknowledged the difference between the two. So this idea that the US government asked the defendants to sell to Kamadia, it's not true, and there's no evidence of it. And that's even assuming the court should take judicial notice of these reports, which I don't think it should. I mean, most of them are these anonymous weekly reconstruction update documents that I've been unable to authenticate. We've served FOIA requests on USAID to find them. USAID can't find them. The defendants downloaded them from some third-party website. For all I know, they were written by an intern in USAID and never made public. So the idea that in a case of this magnitude, the court should find what official US policy in Iraq was based on anonymous newsletters that nobody's been able to authenticate, that's not what this court should do. By contrast, here were the facts about the US government in Iraq. By 2007, US officials could not even go into the ministry building because it was too dangerous and they were getting death threats. That's paragraph 180 of the complaint. We've spoken about the military operation to arrest and prosecute Hakam Zamali, who was these defendants, essentially their counterparty and one of the worst terrorists in Iraq. That's paragraph.
I hate to interrupt when you have limited time and you're clearly trying to use it efficiently, but when you talk about the agents of the defendants or the defendants, it's a little bit unclear in the pleading, going into the building. As you've said, Americans couldn't go in. I assume that you're talking about the Scientific Bureau. Is there any reason to think that if the Scientific Bureau, who I understand to be local Iraqi people that are working on behalf of the defendant companies, any reason to think that they would communicate back how many AK-47s they saw leaning against the wall, or whether they saw Death to America posters on the wall or anything like that?
Yes, I mean, the scientific bureaus were their local agents in Iraq responsible for these businesses' relationship with the ministry. So yes, there is entirely plausible reason that they would have reported it back. But I would also note, Judge Pillard, we've alleged that they were agents. That's paragraph 158 of the complaint. And so, an agency relationship, the knowledge is imputed to the principal. So even if there was not a communication back to the companies themselves, and to be clear, we're entitled to discovery on that. That is not an inference this court should resolve on a motion to dismiss. But we don't think we need that, because as a matter of fundamental agency law, the knowledge was imputed. And I would just stress that for all of Mr. Shanmugam's discussion about knowledge, Judge Leon went as far as to say there was knowledge at JA 835. I quoted that in my opening brief. He said that the defendants, quote, were aware that their goods, quote, would be used by Jaish al-Mahdi to support terrorist attacks, as alleged, of course. And so this knowledge issue, again, I think Judge Edwards had it right. I mean, you compare the knowledge allegations here to the ones in Kaplan, and I think the case needs to be reversed. On Hezbollah, just very briefly, Mr. Shanmugam characterized our allegations as merely providing the weapon or merely giving inspiration. That's not what we allege. Yes, they did provide the weapon, but they did a lot more than that. They trained them how to use the weapons. They had operatives on the ground dictating day-to-day tactical decisions about how to use them. They encouraged Jaish al-Mahdi to use these weapons against Americans in Iraq. And that is why I think the easiest way to see this is at paragraphs 395 to 96 of the complaint, talking about these explosively formed penetrators. The idea that all Hezbollah did was give them the weapons and nothing else, that is not what we allege. And at a minimum, Judge Wilkins, I know that you had some questions about how to draw the line on this, and I acknowledge that there are going to be hard cases at the margins. I would encourage the court, if it's concerned about that, to draw those sorts of lines on a summary judgment record when the factual record has been fully developed. Because I think no matter what the legal test is, and I would note that my friend didn't actually articulate what he thinks the test is. I'm surmising he thinks that it means that a Hezbollah person has to show up to the street corner and point, blow up this bomb and kill that tank. If that's the test, and I don't think it is, we're entitled to discovery because we have at least alleged a plausible nexus between what Hezbollah did and each individual attack, such that discovery may well yield the sort of evidence that I think my friend is demanding.
I'm going to let you go,
Okay.
but what are the best responses to the concerns that many voiced in opinions and in the argument today about casting a net so wide that entities or individuals that really want to provide humanitarian aid to people in distress, of which there are many in areas that are under terrorist control or besieged by terrorists, that they would be snared in this law?
Well, Judge Pillard, it depends on what the facts are, of course. I think if all, and I'm thinking of the charities amicus brief that the other side submitted, if all you're doing is providing humanitarian assistance in an area that has terrorists in it, that's not going to be enough to create liability. I mean, the statute, I think my friend quite rightly said, has two key elements. You need substantial assistance and you need general awareness. And those are not easy bars to meet. I think they're met here by the complaint, but it's not as though every charity in the world is going to be subjected to a lawsuit like that. And I think there's been no showing that there would be. To create an action under this statute, you have to substantially assist terrorists that are attacking Americans. And I guess, Judge Pillard, I'd close by saying this law is broad, and it's because Congress really doesn't like it when companies fund terrorists. And so, there may well be some competing policy considerations that might rear their head in some future case. But very heavy in the calculus is Congress's determination that you shouldn't fund terrorists. And when you do, that is an extraordinary interest that Congress was entitled to legislate against. And I think when you apply this statute to these facts, the case should be
Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and its Honorable Court. Case number 20-5143, Dean Ray Michael T. Flynn. Ms. Powell for the petitioner, Michael T. Flynn. Mr. Wall for the U.S. Department of Justice. Ms. Wilkinson for the Honorable Emmett G. Sullivan.
Thank you. This is Chief Judge Srinivasan. Before we begin with argument this morning, I note on behalf of the court that our colleague, Judge Stephen Williams, passed away last Friday in his 34th year of service on our court. Please join the court in observing a moment of silence in honor and remembrance of Judge Williams. Thank you. We'll now proceed with argument in today's case, to be conducted as follows. Each counsel will give an opening statement to be followed by questioning by the judges in order of seniority, and then a second round of questioning for any judge who has a follow-up question. We'll follow the same process for each of the three counsel presenting argument today, and we'll then end with a brief rebuttal and closing time for Mr. Flynn's counsel and counsel for the United States. Ms. Powell, we're ready to hear from you. Please proceed.
Thank you, Chief Judge, and may it please the court. General Flynn is a defendant without a prosecutor in litigation now without any controversy between the actual parties to the case. Instead of promptly granting dismissal as required on this facts as a matter of law, Judge Sullivan denied two defense motions opposing any amicus at all, appointed Mr. Gleason to usurp the job of the prosecutor, raised a sword of perjury and contempt charges over Flynn's head, and impermissibly sallied forth to right the wrongs he perceives. But as Judge Posner noted in NRA United States, the job of the United States Attorney is otherwise occupied. In adding these unconstitutional burdens of process to punish Michael Flynn, Judge Sullivan discarded any semblance of the unbiased, impartial adjudicator this court extolled in al-Nashiri, the 2019 chapter of that case saga, as the cornerstone of any system of justice worth the label. 4 rulings are required to conclude this novel Article III excess. Judge Sullivan's petition for rehearing must be flatly denied, with clear Ligon-like language that a judge has no injury and no standing to seek relief in this court of this court's rulings. Second, because Judge Sullivan has so invested himself in his own prosecution of General Flynn, al-Nashiri mandates his disqualification for the now glaring appearance of bias to millions of citizens. Third, Cheney, Sinanine Smith, and Bond require mandamus issue to vacate the unconstitutional appointment of Mr. Gleason for intrusion into the sole Article II functions of the executive branch. And fourth, mandamus must issue to compel the district court to grant the dismissal as a matter of law. Only the Department of Justice can decide the public interest and myriad factors inherent in pursuing a prosecution. This is not an ordinary motion on which there can be factual development or debate. This is a Rule 48A case dispositive motion as to which the executive branch has sole discretion and determinative authority. The government has dropped the case, and every 48A decision in the country requires this motion be granted.
Thank you, Ms. Powell. I'll begin the questioning. And can I ask you the following question? And assume with me that I'm focused primarily on your request to require the district court to grant the 48A motion, and just put aside for one moment the other forms of relief that you're requesting. I'm focused on the one that the panel decided the case on, which is the requiring the district court to grant the motion for dismissal under Rule 48A. And you agree that you're entitled to mandamus as to that form of relief only if there's no other adequate means to attain the relief?
Yes, Your Honor, and there is no other adequate means to attain the relief because of the usurpation of power and intrusion into the Article 2 branch by the process he's suggested, and the fact that there's no discretion involved in the district court on the district court's part in addressing a 48A motion.
But are you aware of any other case in which mandamus has been granted to compel a district court to decide a pending motion in a particular way, either by granting or denying it, before the district court itself has decided whether it's going to grant or deny the motion?
Well, now that we have Fokker Services, which of course you know as you wrote it, that with the law is clear that this motion has to be granted. Every 48A motion in the history of the country has ultimately been granted. He could have had a hearing. He has had ample time that he could have had a counsel appear in front of him, but there's nothing.
I'm not even focused. If I can just stop you for 1 second, I'm not even focused on Rule 48A motions as such. And I take your point about Fokker. And in fact, for purposes of this question, I'll assume, and it's just for purposes of this question, I'll assume that everything you've said about the Fokker decision all along is correct. And I'll assume further that the en banc court agrees with Fokker, even though Fokker was a panel decision. But I'm focused on the prong of mandamus that deals with other adequate means. And whatever you might think about the clarity of Fokker, that's going to be true of all kinds of decisions that are on the books. And I'm not even focused exclusively on 48A motions. I'm asking just for any kind of motion pending before a district court. Are you aware of any situation in which a district court has been compelled under mandamus to grant or deny the motion before the district court itself has decided whether to grant or deny the motion?
No, sir, because I don't know of any other case where a district court has set about the process that this district court did that went outside the boundaries of Article 3 from its very inception, from the minute he requested amicus, which is not provided for in the rules of the court at all in a criminal district court case.
If the district court grants the motion, then that would be adequate alternate means, would it not?
Well, no, sir, because the process here is the problem. The process is what violates both Article 3 and Article 2. He could have granted or denied the motion months ago, 3 months ago to be precise. But instead, we've had the unconstitutional burden that Cheney talks about being imposed on us by the process he created that he has absolutely no authority to create. All he is entitled to do, even if he'd done it timely, would be to review this motion on its face and grant it. Okay. There is no precedent whatsoever for denying it.
Thank you, Ms. Powell. I'll let my colleagues answer questions and follow up in the follow-up round with anything more. I appreciate your answers. Judge Henderson?
No questions, thanks.
Thank you. Judge Rogers?
I'll follow up briefly. To what extent do you understand Fokker? To the extent you rely on it, given the Chief Judge's assumptions and the panel opinion, was Fokker not a case where mandamus was